We are live.
Great. Good afternoon. It's February the 24th, 2021. Welcome to the House Judiciary Committee. We have a wide range of different bills today. There are 14 bills, a wide range of different issues. We are also hearing some bills at the same time as JPR. So this schedule has been kind of finely tuned to make sure that we can get people virtually across the street. So we're going to do the best we can with all of that. To that end, we're going to begin with that Delegate Pippy guy again, Delegate Pippy for House Bill 1000, and a bill on estates and trusts for which he is the only witness. So we will go ahead and start there and hear from him. Delegate Pippy for 3 minutes.
Thank you, Chairman Clippinger, Vice Chair Atterbury, members of the Judiciary Committee. Delegate Jesse Pippy for the record, here to testify on House Bill 1000. This bill deals with court-appointed guardians for minors and disabled persons. Currently under Maryland law, a court-appointed attorney for a minor or disabled person may, without court authorization, pay or apply income in principle from the estate as needed for the clothing, support, care, protection, welfare, and education of the minor. A guardian of a disabled person may, without court authorization or confirmation, pay or apply income in principle from the estate as needed for the clothing, support, care, protection, welfare, and rehabilitation of the disabled person. Income in principle also may be paid or applied without court authorization or confirmation for the benefit of persons legally dependent upon the minors or disabled person. What this bill says is that a guardian who is not a family member may not distribute or disperse property without court authorization or confirmation if the distribution or disbursement would financially benefit the guardian or the guardian's family. An example, the guardian needs to sell the home of the disabled person and he decides to use his wife as the realtor. Another example, the guardian needs to hire a cleaning service and he decides to use a family member to pay out of the estate directly to the family member. There's actually a Netflix movie that just came out called I Care a Lot, dealing Rosamund Pike, which involves a legal guardian who drains the money from elder clients by selling their assets. This is actually an issue in Maryland. There was a recent situation. So long and short, I believe we have a responsibility to protect those most vulnerable in our communities, and this bill would ensure that when it comes to court-appointed guardianships, we are doing just that. And I ask this committee for a favorable. Thank you.
Apparently, Delegate Bartlett was very upset because you were engaging in a spoiler alert moment, and she didn't want to find out what is going on in the show. But now that you've ruined that for her, she has a question. Delegate Bartlett.
Why did you ruin it? No, thank you. Thank you, Mr. Chair. I haven't been watching it. My husband's been watching it. But anyway, so here's my question. We already have a fiduciary duty in place. How does this relate to or correlate or supersede what's already in place?
Sure, great question. So the only requirement for these court-appointed attorney guardians is that they follow the model rules of professional conduct. It just doesn't explicitly say that they can't hire their brother-in-law to be a mover. And I'll use you a perfect example. There was an estate in a jurisdiction in Maryland, and they needed to hire a cleaning company to clean out a trailer. And they paid this company like $20,000. And it turns out that the wife owned this company and it was just kind of shifting money around. And so, you know, ideally in a perfect world, they would just do what's in the best interest of their client, but it doesn't explicitly say that they have to, or that they can't use a family member for one of those many services that these people are basically distributing money out of these estates. And so what this bill says is they just have to check with the court, which they're already doing, because in order for them to get paid, they have to apply through the circuit court. This just says that if they wanted to hire a brother-in-law or a family member to do one of these services, they just got to get approval first. There's no fiscal note. It doesn't change the mechanics of anything they're doing. I think it just prevents somebody from putting themselves in a tough spot. hopefully that answers it.
You're unmuted. Is there a further question? Delegate McComas, go ahead.
Thank you, Mr. Chair. Delegate Pippi, there is a letter of, I think, support, but also they would like to amend it to have it to also apply to family members. And they feel that, you know, people that are disabled or elderly or have, you know, mental disabilities and they live in, you know, they have to, in other words, they need protection, that family members are just as capable of exploitation of disabled other family members than someone who is not related. So would you consider just, you know, maybe putting in an amendment that over a certain amount, they would have to receive court approval or something that would protect the vulnerable family members, particularly if you know, someone has let's say a gambling problem or, you know, and they got guardianship and there's other issues for a drug or alcohol problem and they just can't keep it together.
Thank you, Delegate. I am 100% amenable to the will of the committee. So whatever you guys think is best, I am all in for it. But this is kind of unique because, you know, there's really nothing that says you can't hire your spouse to be the agent to sell their home, or that you can't hire your brother-in-law to come over to paint their house for $10,000. I mean, it's kind of bizarre. And you don't even have to ask the court for permission, so.
Are there further questions for Delegate Pippi? Seeing none,
Thank you.
Thank you very much. That concludes the testimony on House Bill 1000. Continuing on the theme of people who have left us, we now go to Delegate Hartman, House Bill 855. Delegate Hartman is going to testify along with David Daggett, Billy McDermott, and Carla Ortiz. Delegate Hartman will speak for 3 minutes. Everybody else will get 2 minutes. Thank you very much. Let's go with Delegate Hartman now for 3 minutes. Have to unmute yourself though, otherwise we can't hear you. There you go.
Does that help?
Yes, otherwise
Very
we
good.
can't tell who you are. 3 minutes.
Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, members of the House Judiciary Committee. It is great to be back with you. Seeing the pre-streaming camaraderie, it makes me miss the committee all the more. But I'm here with House Bill 855, criminal negligence in causing life-threatening injury involving a motor vehicle or vessel, known as Wade's Law. This bill simply fills a void, and that it's a void that presently exists in our justice system. So if there is someone operating a vehicle or vessel criminally negligent causing death, there is a just penalty. If there is criminal negligence and there's severely injured, life-threatening injuries, permanent disabilities, whatever the case, there is a $500 fine. And that is simply not justice. So let's put $500 in perspective. For some people, that may be a new set of tires on their car. For others, it might be a nice dinner with them and another couple. For some, it might be part of a weekend in Ocean City. But for the victim that has suffered a permanent injury, a life-threatening injury, that is not justice. I know it doesn't change the outcome, but it certainly is not justice for that person. This past Monday was the 5-year anniversary of the accident that Wade Pusey, a Worcester County road worker, was severely injured, and he was practically left for dead after being thrown hundreds of feet from the impact of a vehicle operated by a criminally negligent driver. His coworker died in that accident as well. And let me add, if this, not necessarily this body, but if the General Assembly would have acted in 2017 when this bill was first introduced, Janaea, a victim who you will see in a few minutes, would have received justice from this legislation. The House has passed this bill, and let me remind you, the Senate has passed this bill. And we need to make this the year to get this bill passed into law so that justice can be served. A $500 penalty for a permanent disability only adds to the pain of the traumatic incident or experience that person already suffered. Please vote favorably for House Bill 855. And if I could ask that Bill McDermott be called next.
Fine, we'll have Mr. McDermott, please, for 2 minutes.
Thank you, Mr. Chair. Members of the committee, my name is Bill McDermott. I am the Deputy State's Attorney in Wycomico County, and before that, I had the privilege of being the ad interim State's Attorney in Worcester County. In Worcester County, I had the honor of meeting and working with, as a prosecutor, an individual of whom I think the committee will hear from later on today, an individual by the name of Wade Pusey. Wade Pusey, as I've mentioned to this committee in years past, is a hero of mine. I'll note that 2 minutes is rarely enough time for a lawyer to introduce themselves, let alone speak persuasively or substantively on any particular topic. But with that said, I'm going to try to, in as quick and as candid a fashion as I can, frame for you what I think this issue is all about. As we've testified in years past, and we've testified this year in front of the Senate, this is simply an opportunity to correct what is an unjust penalty scheme within an already existing framework of our law. I've noted that in speaking with a number of legislators this year, 2021 has been framed, at least for the Maryland legislature, as the year in which the criminal justice system under a microscope, looking for inefficiencies and imbalances. I'll note that—
Mr. Daggett, you are not on mute. Thank you. Mr. McDermott, go ahead.
Thank you, Mr. Chair. I'll note that we have, as Delegate Hartman noted just moments ago, we have come to this body in years past. In 2017, I'll note that this bill passed the House 140-0 and never received a vote in the Senate. In 2019, this bill received a vote of 46-0, but never received a vote in the House. This is the year in which, if we are looking for imbalances in the law, you need not look any further, because this has come to you for the last 4 years and comes to you again. I hope that I get an opportunity, as in years past, to answer questions about whether or not this is a new standard in the law. I hope that there's an opportunity to talk about the distinctions that often are asked about this particular bill with respect to simple negligence. But what I'll note just very quickly and very clearly is that this is not a new standard of negligence, that criminal negligence is in existence already on the books. It exists in the statutory scheme of the criminally negligent manslaughter statute. It's been around since 2010. There are Attorney General's opinions that followed after the passage in 2010 that looked not only at the scheme itself, but looked at the legislative intent and what other jurisdictions around the country have done. What this does, plain and simply, is it creates parity in the law for the person who survives a criminally negligent driver as opposed to the person who does not. For the person who does not, there is a just penalty. For the person who does not, a $500 fine, as Delegate Hartman and certainly Senator Carrozza have noted before, is simply unjust. If this is the year of balance, this is the year to pass Wade's Law.
Thank you very much, Mr. McDermott. Now we'll now go to David Daggett, and then we'll hear from Carla Ortiz.
Thank you, Mr. Chair. Madam Vice Chair, I apologize. I thought I was on mute, so I'm glad you.
Now, these things happen. That's okay.
Okay. My name is David Daggett. I'm a prosecutor with the Maryland State's Attorneys Association. I've been a prosecutor for a number of years, about 30 years now. And as Mr. McDermott said, this is about the 4th year we've brought this bill, and we really do think it's a good bill. And it does not. I just want to stress, as Mr. McDermott did, that we are not asking for anything like a new law. This is not negligent driving resulting in a life-threatening injury. This is criminally negligent driving. So right now, as the committee probably knows, if you drive in a criminally negligent manner and you kill somebody, it is a crime. It's a 3-year incarcerable offense. If you drive in the exact same manner and you hit a car, you kill one person and you maim another, the person that only gets maimed, that doesn't die, the driver is only subject to a $500 fine. And we just don't think it's fair. We're not looking to reduce the level of negligence that already exists for killing someone. You have to have the exact same level of negligence. The hardest thing that I've had to do, I think, as a prosecutor, is tell the next witness that you're going to hear, Carla Ortiz, that I was not able to go forward with an incarcerable offense involving her daughter, who was maimed and paralyzed because the driver was criminally negligent, but thankfully she didn't die. But you're going to hear about the horrific injuries that she suffered. And with that said, I don't want to take up any more of the committee's time. the State's Attorney Association would ask for a favorable report on House Bill 855, and we really thank Delegate Hartman, Senator Carosa for bringing this bill forward. Thank you.
All right, we'll go now to Carla Ortiz for 2 minutes, please.
Good afternoon, Mr. Chair, Madam Chair, and House of Representatives. My name is Carla Ortiz, and this is my daughter, Gianni Lyles. And we are here to ask that you see that the time is now to pass this law. On June 18th of 2018, we were sitting still in traffic and we were struck from the rear by a tractor trailer driver, an 18-wheel tractor trailer. And due to that, my daughter, who was at the age of 13, was catastrophically injured. As a result of that accident, as a vibrant 13-year-old, very active in all kinds of activities, she endured a complete severance of her spinal cord, which resulted in permanent paralysis from her breastbone to her toes. She had hemothorax, multiple rib fractures. She endured a spinal fusion. She has had pulmonary emboli, cellulitis, severe sleep apnea. She has a neurogenic bladder and bowel, morbid obesity, deep vein thrombosis, diabetes, depression, anxiety, PTSD, and an increased blood clotting order. And both of her hips are permanently dislocated. Right now, we are surviving. And just to let you know what the fine that he sustained at $500, her wheelchair, one wheelchair was $84,000. And I had to fight with insurance to get that so that she could function. We are now preparing on March the 17th for a complete reconstruction of her bladder and bowel, where we'll spend 6 to 8 weeks in Baltimore at Johns Hopkins Hospital, trying to piece back her life and give her the ability to handle her own personal care of going to the bathroom, which right now she does not have. Our lives have been impacted financially, emotionally, and physically. Please, we ask that you help us help others, because thank God we are survivors. Thank God she is alive, but it is extremely difficult to manage and live day to day. And we ask that you hold those accountable who are criminally negligent in doing these types of situations more responsible for their actions. Thank you so much. We appreciate you and pray that all of you are safe during these COVID times. Thank you for hearing us.
Thank you. I believe that concludes all of the people who are signed up to testify. Ms. Ortiz, did your daughter wish to say anything? No?
I think that she is very anxious about the surgery, and this is a very unstable time for her.
All
So
right.
I'm going to request that, she wants you to see, and I spoke on behalf for us, okay? For her.
That's fine. That's
Okay.
perfectly fine. Thank you very much.
Thank you.
Questions to the panel now. Delegate Erican, please.
Thank you, Mr. Chair, and thank you again, Delegate Hartman, for bringing this incredibly important legislation that we all already love and wish would have passed the other side. Hopefully this year is the year. I just have a quick question. So this is not a new standard of negligence. So it's the same one that we already have. It's just applying it to people who are not, situations where their victim's not killed, right?
It's a new standard. It's criminal negligence. Yes, it's not simple negligence. It's the current standard for criminal negligence that we already have for killing someone. Yes.
And what if it was just simple negligence? Would that apply?
No, it would not. Simple negligence would just be the $500 fine as it currently is.
Okay.
And
Okay.
Delegate Erican, to that point, I'll just note that that's actually contained within the bill itself. Like the plain language of it says, simple carelessness is insufficient to establish defendant's guilt. Simple negligence does not apply.
Okay. All right. Thank you very much.
Thank you. Delegate Davis, Deborah Davis, please.
Hello, I've got a simple question, I hope. Was vessels included in the prior bill?
I believe that has always been the case.
Could you make sure? Could you let us know? Or just tell me the prior bill's number.
Yes, I'll follow up with you. Absolutely. Thank you.
All right.
feel like it was. I don't know why I'm saying that, though. We'll check. Delegate Cox,
Well, probably because you were a co-sponsor, Mr.
a long time ago. That's right. I think I remember something about that. Delegate Cox.
Thank you, Mr. Chair, and thank you, Delegate Hartman. Good to see you back here. We miss you on the committee. I just had a quick question for, I guess, either Mr. McDermott or someone else who may have the expertise concerning the standard for criminal negligence. Could you explain to the committee how that is such a higher standard, important to make sure that we protect people from distinct crimes versus that mere negligence that Delegate Aragon mentioned?
Sure, Delegate Cox, I'll take that first, and then I'll pass it to Mr. Daggett if he wants to follow up. Criminally, as I mentioned before, the criminally negligent standard came to us by way of this legislature first passing it and effecting it back in 2011. And sir, I'm just going to read straight from what is our, and I have it in front of me, the jury pattern instructions, which lay out exactly what it is. It means that the defendant should have been aware, but failed to perceive that his or her manner of driving created a substantial and unjustifiable risk to human life. This failure to perceive the risk must have been a gross departure from the conduct of a reasonable person under similar circumstances. Again, simple carelessness is insufficient to establish a defendant's guilt. Moreover, I point the committee to an Attorney General's opinion, which is 96 Opinion Attorney 128. This was following this legislature's passage of the criminally negligent manslaughter, and it details out the criminal negligence standard, how it is a different standard from, say, gross negligence, and how it is also a different standard from simple negligence, and how we simply adopted, at least this deliberative body adopted back in 2011, those standards that we enjoyed in other parts of the country and at the federal level.
Thank you. Thank you very much.
Delegate Conaway, please.
Thank you, Mr. Chairman. The question is to Mr. McDermott. I was wondering how fast over the speed limit, let's say if the speed limit was 55, would a person have to be traveling to be grossly negligent?
Thank you, Delegate. And in classic lawyer fashion, I'm not going to answer your question because in all candor, it depends on a lot of different factors. For instance, if you are on a crowded street with a lot of pedestrians, let's say Coastal Highway in Ocean City during peak summer months, that speed may be greatly affected by the people who are out there on that particular day. Is it a rainy day? There are, in addition to the question you've asked, which is, an ipso facto, if you go faster than the posted speed limit, is that negligence? Well, we also have in Maryland a violation of the law, which is faster than reasonably prudent under the conditions. And that takes into account a lot of different factors. So not to not answer your question, but I don't think it's as simple as saying, if you're going 70, then it's gross negligence if you're in a 55-mile-per-hour zone. It's going to depend on a constellation of factors that would go into a determination regarding negligence.
Thank you very much.
All right. Are there further questions for the panel? Seeing none, thank you very, very much. That concludes the testimony on Delegate Hartman's bill, House Bill 855. We're going to go now to House Bill 950 and Delegate Washington. He is going to be joined by John Nethercutt and Cecilia Plant. He'll talk for 3 minutes. They'll each talk for 2. So Delegate Washington, if you wouldn't mind, please, for 3 minutes.
Thank you, Mr. Chairman and members of the committee. For the record, Delegate Alonzo Washington here to present on you for a 4th time this session. I believe it's the last time that we're going to be together this session, but I'm here to present on House Bill 950, which requires the state court administrator to ensure that every judge receives annual training to increase community and cultural awareness. These include anti-discrimination training, anti-racial bias training, implicit bias training, procedural justice training, training on reconciliation techniques, and anti-Blackness training. As the country was embroiled in mass protests last year over the treatment of Black and Brown Americans by the police, it is important to remember that law enforcement is not the only component of our criminal justice system. It is well known that Black residents are sentenced to longer sentencing sentences for the same crimes as white residents. A study in 2018, the Justice Policy Institute found that despite only 31% of Marylanders being Black, these residents make up of over 70% of Maryland's prison population, the highest rate in the nation, and more than twice the national average of 32%. This disparity is more pronounced among emerging adults ages 18 to 24, who have even longer sentences. More than 80% of them are Black in our prison system. Also, a study by the U.S. Sentencing Commission shows that Black men also serve sentences that are on average 19.1% longer than those for white men for similar crimes. Additionally, sentence lengths for young adults have increased by 25% over the last 15 years. Judge's discretion in Maryland, again, the judge's discretion in sentencing allows implicit biases to dictate longer sentences for Black Marylanders, which contributes to the disproportionate number of Black people in Maryland prisons. The data tells us that subconscious stereotypes about Black and brown people remain seeped in our judicial system. The training outlined in this bill will help bring these biases to light. It is vitally important for every member of the judicial system to understand how subconscious biases affects sentencing decisions. Disproportionately long sentencing will continue to disrupt and divide communities of color, and we need to use every tool we have to prevent this from happening. I'll just say that I think you guys are going to hear from the judicial system, if not today, but for me, it's about them taking if Chief Barbera said today that they're going to do this already, I would withdraw this bill today. It's easy fix, it's easy something they can do, but until they do it, I believe that this legislature must take on this and should require that all of the judiciary take this type of training because the data is there and it's necessary to prevent so many disparities from happening within our judicial system. With that, I urge a favorable report of this bill, and I thank you all for listening.
Thank you. For 2 minutes, we'll go to Mr. Nethercutt, please.
Good afternoon, Mr. Chair, members. I'm John Nethercutt. I'm the Executive Director of the Public Justice Center, which is a civil legal aid organization in Maryland here. We represent hundreds, over 800 usually, clients per year, predominantly in eviction courts doing eviction defense. So our clients are predominantly African-American or other people of color, women with children. The judiciary is not predominantly of that demographic. And so there have been a number of studies, and I'm going to refer specifically to several I cited in the testimony I filed, which I won't repeat, but the work on this has already been done to determine what the problem is. In 2004, the judiciary had a commission on racial and ethnic fairness in the judicial process. They found that, in fact, there was implicit bias in the judiciary, and that shouldn't be surprising. The judiciary are no different than any of the rest of us, having grown up in America and having been exposed to quite a bit of racial prejudices and biases. I will also say that what we're talking about is not primarily intentional, deliberate discrimination based on race. It's attitudes and beliefs that have gotten into at an implicit subconscious level. The reason that this commission recommends cultural and cross-racial training is to bring those implicit biases to the surface so that then we can begin working on changing our behavior and our patterns so that the court will in fact be a place of justice for all instead of some people being treated worse than others. Because the PJC itself is in court quite a bit, we did a quick survey just of our attorneys who are both white and people of color and asked them, and in my testimony, there's a number of examples of just the things that we see in court, on a day-by-day basis. I know I can't tell you how often, particularly our Black.
Mr. Nethercutt, if you would
Yes.
please, if you'd begin to wrap up, please.
I will, certainly. So for these reasons, training is, I think, really important. Most organizations are doing this kind of training now. There's no reason the judiciary shouldn't either. So we urge a favorable report.
Cecilia Plant, please.
Good afternoon, Mr. Chair and members of the committee. My name is Cecilia Plant, and I'm the co-chair of the Maryland Legislative Coalition. We are a coalition of over 30,000 citizen activists who have become citizen lobbyists to lobby for legislation that makes our state a better place. I'm testifying in support of HB 950. Our members believe that judges, given their position and the power that they have to affect the course of somebody's life, should be beyond reproach. We're all aware that everyone has biases and that those biases can lead to a lack of empathy and understanding of people of other races and cultures, and that can lead to harsher sentencing. It makes good sense for us to provide training for judges in implicit bias and anti-discrimination, along with giving them techniques that will help them understand these biases and how to deal with them. This bill, if passed, would require all judges to receive training to address implicit bias, anti-racial bias, anti-discrimination, and anti-Blackness bias, as well as techniques for procedural justice and reconciliation. We believe that this is a good first step in providing necessary training and also in gaining an understanding of where we need to go from here. We support this bill and we recommend a favorable report in committee. Thank you.
Are there questions for the panel? Delegate Washington, I would suspect that the question that came from the judiciary is one of a constitutional nature. How do you address the issue that a separation of powers issue where we generally can't instruct judges on how they're trained after they become judges, after they become part of the judiciary?
That's something that we've asked the AG to look into for us, Mr. Chairman. So we'll get some response from him on that. But we've taken that under advisement, and I may have some statements against that constitutional argument, but I'll leave it to the professional to render an opinion.
All right, Delegate Crutchfield.
Thank you, Mr. Chair, and thank you, Delegate Washington, for this to us. I just got really a couple of real quick questions. One is, what guidance or guidelines will be provided for the type of training to reach the goals you're trying to obtain, with the judiciary? And are there any specific vendors you have in mind? Is there anything else that you can give them? And then finally, what about enforcement, to ensure that they actually get the correct training and are enabled to do or have, the kind of training that you're.
Yeah, well, thank you for the question, Delegate. I think your question is one of oversight and one of transparency and what we don't see in the judicial system and accountability. One thing that we don't see in our judicial system is a lot of accountability for judges for what they do and they don't do. And I would like to see more of that happen and occur. To answer your other, as it pertains to enforcement, as far as the other piece on, what type of guidance that we will provide them, I don't want the bill to be too prescriptive in nature to provide them with that guidance. I think that they can promulgate those rules and regulations amongst themselves if they need to. I understand that they have a work group in place right now to look at similar issues like this.
Delegate Conaway.
Okay, thank you, Mr. Chairman. We're having technical difficulties over here. Can't print out the testimony. Thank you, Delegate Washington, for coming in. I was wondering, is there official definition somewhere for anti-Blackness training? Or have we made an official definition?
Not in statute, sir, but I'm sure this committee can come up with something.
All righty, thank you.
Yep. I'll also just add that there's definitions out there of what anti-Blackness means, and anti-Blackness training is and consists of at the organization that organizations that I work for, they've all gone through anti-Blackness training before.
Thank you so very much.
Yep, absolutely.
Man, we are very happy to see now to ask the next question, Delegate Ron Watson.
Thank you, Mr. Chair. Good to be back. Good to see Delegate Washington. Delegate Conaway asked my first question regarding anti-Blackness. That's a phraseology that I had not heard before, and I doubt that all members of the Judiciary would know automatically what that means. It seems to be very broad in your bill where you list a variety of things and you leave it up to Judiciary to implement the way they want. It could be one course, several courses, however they seem to do it. My question is, how do you know the efficacy of this bill? I don't see any type of reporting requirements. So how would you know that the bill is doing what you intended to do?
Delegate, I think that's a great question and a great point, and maybe some of the folks on my panel can chime in here too. But what I'll say is that, again, I don't think I want to be too prescriptive in here, Delegate, about what they should and should not do. Obviously, they will have to do the research behind it to make sure they are implementing this piece of legislation. And also, I know Delegate Melissa Wells also has a bill similar to this one that does require tracking and information gathering and things of that nature and reporting from the Judiciary. So, and as we work through these, as we work through our committee structure and our subcommittee structure, Delegate, I think the subcommittee can come up with some other guidance and guidelines on these two. And I'll be sure to help you if necessary, if this bill does come up for discussion, which I hope it does.
Are there further questions for this panel? Seeing Delegate Anderson, go ahead.
Yeah, thank you very much, Mr. Chairman. Delegate Washington, considering the fact that we don't know whether or not the Attorney General is going to render an opinion as to whether or not this is constitutional in terms of separation of powers, do you think about attacking the problem as you see it prior to a person becoming a judge? And I mean, asking the different bar associations that interview judges, Hispanic bar, the women's bar, the black bar, to include this in their protocols so that we don't even get to a point where a person becomes a judge and may have some of these drawbacks.
No, I think that's a great point, Delegate Anderson, and your wealth of knowledge in this committee and in the House of Delegates, and we appreciate your service. And so I would hope that this committee would take something like that up and make an amendment for that to happen. If we can do that, that'll be fantastic. I think it's a great idea.
Okay.
Is that in your subcommittee, Mr. Delegate?
Feel pretty confident it's not going to get to a subcommittee if the AG feel pretty confident the AG is going to need to say that it's constitutional in some way.
Well, Mr. Chairman, he also spoke to a great amendment, which I'm sure the delegate will add, that could speak to before our judges become judges, before these attorneys.
Yeah, that's it's something Delegate Anderson actually has brought up before, and it was brought up in the context, I think, of Delegate Wells' bill on implicit bias and whether, as part of the process, there are different bar associations that exist across the state for different groups of people, and they could themselves decide to take on that work without legislation, without any kind of further work on our part. Having said that, that's kind of sort of the sum and substance of that. I think there's more that potentially could be done in that realm that would perhaps even be more effective than this, because I think the biggest problem with this legislation, as was mentioned a moment ago, was, I think by Delegate Watson, was that you have really very little way to hold the judiciary accountable if they don't do this. And that is sort of the sum and substance of the separation of powers issue here. But I will stop because Delegate Cham has a question and we'll pass it to her. Delegate Cham.
Thank you, sir. Chairman Clippinger. Thank you, Delegate Washington, for joining us today. I had a question regarding the trainings that you included in your bill, anti-discrimination training, anti-racial, implicit bias, so on and so forth. I won't name them all. I'm sure you know them all. Are these all separate trainings? Are they sort of all-inclusive? Because I'm having difficulty with understanding maybe the difference between implicit bias training and anti-racial bias. So do each of these trainings have their own definitions and they are separate in and of themselves, or is it sort of all-inclusive?
Delia, I'll send you a document that we developed that outlines different types of training and what they consist of from different organizations. There are different organizations in the country that that conduct all these types of trainings. Again, I work for organizations that have trained trainers and then also implemented within their organizations. So I could send you a list of those two, but I'll be remiss if I didn't say something about what the chairman just said, which I think is important piece. If we again just allow it to be up to the process for which we vet these judges, we aren't going to get anywhere. We're going to end up with the same disparities that we have already, and I think we're going to consistently leave it up to the judiciary and their process to become judges. There's no way to hold a judiciary accountable, not even in elections, Mr. Chairman. In elections, I've had so many residents come to me asking, tell me more about these judges, Alonzo. How many people, give me some background information on these judges. And I could not tell them anything about these judges and what they do because we have not held them accountable for their work and what they're doing. So I can't inform them. And so if we're going to leave it up to the judiciary to hold themselves accountable, we're going to wait another 100 years, another 400 years of disparities within this country.
Well, it's a pity that Delegate Grammer isn't in his chair right now, because I know he'd be very happy to hear you say something like that. I think there might be other advocates, however, who would be somewhat less than heartened to hear that. But Delegate Grammer got back just at the last minute, but unfortunately his hand's not up. Questions for this panel? Seeing none. Thank you very much. That concludes the testimony for House Bill 950. We're going to go now to House Bill 452. This is Delegate Crutchfield. And all right, well, Delegate Crutchfield, Reverend Little, Meredith Weisel, Sarah Mikey, my constituent whose last name I can never say because I'm used to her old last name. So Delegate Crutchfield for 3 minutes, everybody else for 2. Delegate Crutchfield, go right ahead.
Thank you, Chair, and good afternoon, Judiciary Committee. So I am, for the record, Delegate Charlotte Crutchfield from Montgomery County, representing District 19. And I want to thank you all for the opportunity to testify today for and in favor of Bill number 452. This bill simply enables victims of hate crimes with the ability to go ahead and file civil remedies, such as injunctions, such as damages. If this legislation is actually passed, we would join 31 other states in having the ability for victims of hate crimes to actually file civil remedies. This would be paramount. We, again, would not be the only state doing this. It's critical that victims of hate crimes have more than just the criminal actions that can be taken. They can act so that they can actually have some other redress. And that is why I am here today to testify in favor and urge a favorable report on this bill, HB 452. Thank you.
Right, that's fine. We will go now to Reverend Little, who's here.
Good afternoon, Mr. Chairman and members of the committee. A special congratulations and welcome to Delegate Rachel Jones. I want to thank Delegate Crutchfield for sponsoring this legislation, House Bill 452. I'm Reverend Kobe Little. I represent the Maryland State Conference of the NAACP, and we are asking a favorable report on this bill, which would allow people to recoup damages for civil damages for hate crimes that they've been victimized by. We think that this is an important deterrent to hate crimes, and we think it's an important way to begin to make victims of hate crimes whole. So we do urge your favorable report on this legislation. We've been supporting this legislation now for at least 2 years, and we hope to see this session, this bill come into law. So thank you all very much. I can continue to talk, Mr. Chairman, and to say that you're still on mute.
No, you did the right thing. You stopped early. No, thank you very much, Reverend Little. You were great today and said, I oppose this one, support this one, oppose this one. We loved you for that. That was wonderful. That was great. That was the night we were going until 10 o'clock. Now I'm taking more time. It's terrible. All right, Sarah Mickey. For 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies. I'm here today in support of HB 452, Hate Crime Civil Remedies, which has been explained by the sponsor and by Reverend Little. Like everyone else testifying in support, the Baltimore Jewish Council is concerned with the ever-increasing amount of hate bias incidents in this country and in this state. From white supremacists who stormed the Capitol with Nazi apparel and t-shirts that said 6 million was not enough, to the increasing amount of swastikas found spray painted in Baltimore and other parts of the state, including several incidents from the past few weeks. According to the 2019 State of Maryland Hate Bias Report by the police, which is in and of itself highly underreported, Maryland experienced an average of 386 hate bias incidents each year from 2017 to 2019, and there were 10 more incidents reported in 2019 as compared to 2018, with anti-Black followed by anti-Jewish, making up the majority of total incidents. These incidents were reported in all of Maryland's jurisdictions. And while there is a criminal statute for hate crimes, our state is one of the few states that does not have a specific civil cause of action for hate crimes. While victims can still bring tort claims against their perpetrators, it is not for the hate bias. Words and names have meaning. This is the same reason we have a criminal statute for hate crimes, because even though there are crimes that can be prosecutable with someone who is victimized, but when someone is victimized simply due to who they are, because of their gender identity, race, religion, etc., that type of crime deserves a special name. This should also be true on our civil side in Maryland, like it is in the majority of states. Lastly, allowing treble damages on the civil side, similar in context to some of criminal enhancements for hate crimes, further acknowledges the heinous behind the offender's actions. For these reasons, we ask for a favorable report on HB 452. Thank you.
All right, Delegate Watson to begin.
Thank you, Mr. Chair. For Delegate Crutchfield, so is this a civil remedy that we're talking about?
Yes.
Are there any other civil remedies where the court can award damages 3 times the amount of actual sustained damages?
Yes, there are, but not in this instance, not for hate crimes. The only thing available is the criminal action.
Okay, and can you just define for me real quickly, because I'm a novice, what give me an example of proximal cause.
Proximate cause? Like
proximal cause.
Okay.
Proximate cause?
Proximate cause, yes.
Okay, the proximate cause is something.
Yes.
I haven't done it in a while, but it's a causal relationship between events. You know, in order for something to happen, there has to be a cause and effect to it. So for the hate crimes, though, that's what we're referring to, which we are right now. For the hate crime, part of it would be obviously the victim. There would have to be a showing by the victim that the event happened. It was in violation of the Hate Crimes Act, and there are several ways to do that. There's sections of the hate crimes dealing with religious issues, obstructing religious belief, destruction of property, all those kinds of things have to take place, okay? And then once that is determined that it actually happened, then the victim should be able to make a claim that there has been a violation. And as a result of that, ultimately, they would be able to go ahead and file a claim under this bill.
And so there would be an amount associated with each proximate cause?
Well, you know what, that's really going to be up to the trier of fact as far as if there's a jury trial as to what that claim is going to be, okay? That's going to be up to the jury and or if it's a bench trial, the trier of fact, to determine how much, and it's again going to be based on what that victim brings as, you know, whatever their damages were. If they were damages to property, you know, if their vehicle was demolished, obviously they will present information to indicate that. If they had some other kind of health, you know, doctor's bills, et cetera. So that would be how it would be determined.
So as a final example, if someone spray painted a swastika on my house and it cost me exactly $100 to remove it with no other damages that I sustained, a court could award me up to $300 in terms of making me whole civilly. Is that fair?
That's possible. Yes, that's possible.
All right. Thank you very much.
You're welcome.
Delegate Carden.
Thank you very much, Mr. Chair. Just for the sponsor real quick. So proximate cause is to say, would it be fair to say that it's like, but for that act, it would not have happened? So for example, if I threw a baseball through your window and the fact that I threw it is the proximate cause of the damage to your window, would that be fair to say?
That would be fair.
So if I wasn't there, if I didn't throw the ball, then you couldn't say that I was the proximate.
You couldn't make that claim. Yes.
Okay. Number two is treble damages or triple damages. Oftentimes people ask for it in fraud cases and civil fraud cases. Is that fair to say? And
yes.
And there are also other civil lawsuits where treble damages can be awarded, not always are, and it depends on whether the judge believes it meets the qualifications. Is that fair to say? So it's not just
correct.
This is a civil thing with treble damages. Yeah.
Right. Thank you, Delegate.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing this bill. How is the average person going to know the difference between a hate crime and freedom of speech or freedom of expression?
How would they know the difference? I don't know if I can quite answer that question for you. I mean, hate crimes are pretty specific about how they're violated. I mean, freedom of speech, those kinds of things, we're talking about constitutional elements. And that would really be up to, you know, a judge or someone to really, or a lawyer to explain the differences, because usually you're talking about that as a defense is what you're saying, okay?
Yes.
So, I mean, is that where we're going with this?
Well, I was just wondering about the gray area, if there's a certain level of the gray area.
Okay.
You know, where I don't want to say SWAT sticker, but let's say if you're on a public street with a SWAT sticker, can someone perceive that to be a hate crime or feel that they're intimidated by, I mean, you walked in front of my church with a SWAT sticker. I'm thinking this is a hate crime or a level of intimidation. You're entering the gray area in my perception. So I was just wondering.
Okay. Yeah, I understand what you're saying. Yeah, but this bill is not to find what crimes are, okay? This bill is simply giving those victims, once it's determined that they're a victim of it, that there has been a violation, the opportunity for some additional redress, okay? Through civil means. That's what this is doing.
Thank you so very much.
There was one person who we missed here. We're going to let her testify and then we'll take any final questions. You, Delegate Anderson, let her testify and then we'll go from there. Meredith Weisel for 2 minutes.
Thank you, Mr. Chairman. Just for the record, Meredith Weisel here testifying for the Anti-Defamation League. I think a lot of things have already been said. I just want to clarify a few things while we're here in support of House Bill 452. So ADL was part of model hate crime statutes for states were established in 1981. And just for some numbers, 46 states currently have criminal statutes and 46 plus DC. So 47 total have hate crime statutes under the criminal side and 33 plus DC. So 34 actually have civil remedies that are allowed. It's important to note that when we're talking about civil remedies, hate crimes have a distinct type of harm that has a lasting effect. It's an immeasurable impact on the individuals, on the community. So it's appropriate in certain cases to allow a civil remedy to be part of one of the tools for the hate crimes victims. The statutory provisions make it so victims can recover from the harm caused by the bias motivation itself, not just from the damages, which is what a lot of times you're talking about in the criminal statute. So it's important that it's not just the damages that flow from the underlying torts. It's also important that for the civil remedy, it provides a necessary stopgap in cases where, for example, prosecutors, for a variety of reasons, and we've seen this play out in the Maryland courts too, are unable to prove bias motivation beyond a reasonable doubt. The House Bill 452 would also permit hate crime victims to seek injunctive relief and reasonable attorney's fees and costs. And as one of the questions noted, up to 3 times the amount of the actual damage that's sustained. There's no magic wand, and I have this in my written testimony, there's no magic wand that you can wave to undo irreparable harm to hate crimes caused, but allowing a civil remedy the way 34 other jurisdictions have done, again, it helps our laws and policies to combat the rising tide that we're seeing in hate crimes and how it affects the individual itself. So for these reasons, we ask for a favorable report on House Bill 452. Thank you, Mr. Chairman.
Thank you. Delegate Anderson has a question. I think I have a question too. Delegate Anderson.
Yeah, thanks, Mr. Chairman. I guess my first question is that this is punishing a behavior that obviously we don't want to have in society. And I didn't notice anything in the bill, and maybe I've kind of looked it over a couple of times with regard to punitive damages. And I think punitive damages are important because they give the judge or the jury the ability to award far beyond treble damages where there's pain and suffering that can be proven or loss of enjoyment. Many of those things are kind of hard to prove, but if there's a section in here that allows a court to do punitive damages, you don't have to use the multiplier. Have you considered that, or is it not possible in this bill?
Delegate Anderson, in previous iterations of this bill, punitive damages were in it. They were taken out for this year because it has been a barrier, an area of contention for the passage of this bill in committee, especially on the Senate side.
When you say a barrier?
To committee members, yes.
Oh,
yeah,
okay.
This bill was actually brought, I believe, on the Senate side for the last couple of years. And I believe that's what she's referring to.
Okay. And all right. Well, if it were the will of this committee to do it, would you do it? Just asking.
I would consider it. Yeah, absolutely.
Okay. Second thing, I'm a criminal defense attorney, so I don't know some things about these civil cases. What's the difference between emotional distress and mental anguish?
Does anybody want to answer on the panel? Okay. Nope. Okay. So, I think there is just a slight deviation between them. And I believe with emotional distress, it's more of an intent to cause it. And
let me ask you this. I'm sorry to interrupt. Let me ask you this way.
Sure.
Would you bring in like a psychiatrist to prove either of these, a psychologist or some type of a social worker to prove either emotional distress or mental anguish?
Yes, you would. I think you would do it for both.
Okay. That was actually the crux of my question. You would do it for both, right?
Mhm.
Okay, thank you, Mr. Chairman.
I have a nitpicky question, but, well, all right, I'll ask my nitpicky question. The bill says a person who is the victim of an act that would constitute a violation of the subtitle,
Mhm.
civil action. If you are not found guilty of the criminal action, one of the points that Ms. Weisel made a moment ago, then the part of the reason for the bill is to give an alternate way forward. But it strikes me that in the way the bill is drafted, if you were a victim based on the criminal law hate crime statute, that gets you in the door. So I don't see, and maybe I'm looking at it too closely, losing the forest for the trees, but it seems like to me that you would have to get a criminal conviction in order to get civil judgment.
So I don't have the bill in front of me. I apologize. I think that, I mean, that maybe needs to be clarified, but there are civil statutes where if it still presents the elements of what would be considered a hate crime, even if the judge doesn't. So for example, if a hate crime charge was thrown out in the criminal statute, but the elements of a hate crime were still there, then it is still possible to prove it in a civil case. Same thing. So I think that maybe that's a clarification that maybe should be in the language of the bill, possibly. Again, I don't have it in front of me, but I know that is the case in some of the other statutes that are currently in place.
The other question that I have is that for many of these hate crimes, they're a hate crime because they did something and it was based in animus towards somebody else. It was, it could be malicious destruction of property, or it could be an assault, or it had to have some crime. So this is crime plus animus. I guess the question is, just for riffing off of Delegate Anderson, we're on the criminal side usually, so now coming onto the civil side. What makes this different than if I just took out a civil case against the person who painted the swastika on the side of the building? Is it the triple damages alone, or is it more than the triple damages?
Go ahead, Delegate Crutchfield. I don't know if I cut you off. Apologize.
No, you didn't. You didn't. Go ahead.
So I think that, and this is one of the questions that has come up with this bill in the past, I think, and before this committee and before the Senate committee, and I'm not sure if I'm exactly correct, with your asking, Chairman, but whether—
Why can't you just bring a regular
tort case, right? And I think the distinction is, so when states have considered this, it is a sea change. It's a big policy change to say, we are looking at it from the bias that stems from the cause. And so if in a criminal case, you're bringing the charge may not stick and it may not go through, but the prosecution may still bring it forward. Same thing on the civil side, where you're looking at it as it is stemming from the hate and the bias. So if the elements are still there of why somebody was targeted, we as a society in the state are trying to say that this is because of the hate that was motivated, or the bias that was motivated, and why somebody was targeted. So it essentially has a little bit more teeth to it versus, I was just attacked and I want to sue somebody for assault or battery or something along those lines. And so the damages could be different.
I'll do some more research as to the differences between, bringing just a basic tort action and this, and I'll get to the bottom of that.
Sure, and I'm happy to provide how it's worked in a couple other states too, if that's helpful.
Thank you very much. We'll go down to Delegate Rachel Jones, please.
Good afternoon. I just have a question. I'm noticing that the bill only applies to victims of the hate crime. I'm wondering, is there a reason why it doesn't apply to extend to families as well, particularly in instances where the victim may be deceased and perhaps, as it's already been mentioned, perhaps that person wasn't charged with a hate crime. Perhaps they were charged with a lesser charge or a second-degree murder or something like that. and the family would still like to pursue civil charges. Is there a reason why this bill doesn't extend to families?
Delegate, no, there isn't a reason, and that's something maybe we could look at a little closer.
Okay. Thank you.
Okay, I don't see any further questions. Those are the people who are signed up to testify on the bill, so I think that's going to conclude the testimony for House Bill 452. I think we had Will McAvoy in opposition. However, he does not appear to be on the Zoom, so we'll just note his opposition for the record, and we'll go from there. So thank you very much. We'll go now to House Bill 686. 686 Delegate McComas, and this will be with Judge Wilner and Darlin McLaughlin. And those two will each get 2 minutes each. We'll go with 3 minutes for Delegate McComas. So Delegate McComas for 3 minutes, please.
Thank you, Mr. Chair. Our branch of government, the judiciary, is under attack. Recently, the critically acclaimed TV show 60 Minutes aired the tragic story of U.S. District Court Judge Esther Salas and the brutal attack planned and carried out by Dean Hollander, a men's rights lawyer with a history of anti-feminist statements. On that fateful day, Judge Salas lost her only son. Disguised as a FedEx delivery personnel, Hollander was greeted at the family's door by Salas's 20-year-old son while her husband was close by. The gunman viciously and premeditatedly fatally shot the young man and then severely wounded her husband. The next day, authorities found Hollander dead by a self-inflicted gunshot wound. Upon further investigation, documents were discovered in Hollander's locker that detailed plans to kill Supreme Court Justice Sonia Sotomayor. Last year nationwide, there were over 4,000 threats against the judiciary. HB 686, as originally written, has been carefully scrutinized by Judge Alan M. Wilner, the chairman of the Judiciary Rules Committee and retired judge from the Maryland Court of Appeals. I want to personally thank Judge Wilner for his legal acumen, dedication, and hard work in making the amended bill so much better, practical, and workable. 686 has been amended to be inserted in the public safety article, and there is a little kerfuffle between the amendments office and my side of the fence. Its purpose is simple: to protect judicial officers and prosecutors, as well as their immediate families, from the risk of harm to life and property and from harassment. The bill as amended prohibits state and local government agencies and certain persons from publishing or posting on the internet the home address and telephone numbers of the proposed protected group. It also requires these agencies, entities, or individuals who post such information on the internet to remove the information upon request of the judicial officer, prosecutor, or immediate family member while providing relief for the failure to do so. The definition of an immediate family member is provided in the bill. It's the spouse, parent, or child of the judicial officer or prosecutor. Judicial officer is defined as incumbent or retired judge of the Maryland court created under Article 4 of the Maryland Constitution, a judge of the U.S. District Court, including bankruptcy court, living in Maryland, and includes U.S. magistrates, circuit court magistrates, and commissioners of the district court. Prosecutor is defined as a person authorized to prosecute an offense in Maryland court or the U.S. District Court for the District of Maryland. HB 686 permits those individuals as defined above to request in writing that the appropriate government agencies and internet entities are not to publish or post their home address and home phone numbers. The governmental agencies and internet entities shall then promptly acknowledge receipt of the request in writing and then take all reasonable steps to make sure the information is redacted or removed from the internet and public eye. If a private citizen posts such information, the protected individuals may deliver to the individual a certified and first-class letter by mail, which identifies the personal information that is posted as protected information. Information be removed. And it goes on, but please support 686 and protect our judiciary and prosecutors who protect and defend the rule of law. Thank you, Mr.
Thank you very much, Delegate.
Judge
Let's go to Judge Wilner now for 2 minutes. Judge Wilner. Judge Wilner.
Can you hear me now?
Need to turn on your video, please.
I thought I had it on. Because I can
Okay.
see you. I'm sorry. Can you hear me? Is it important?
I can hear you.
Okay, wait. Here comes start my video. Is that?
Go. We can see the top part of you.
Oh, well, how's?
It's better.
I'll try to.
Good enough. We'll go with that. All right.
Mr.
Judge
Chairman,
Wilner for 2 minutes.
Thank you. May it please the committee. We support the objective of this bill, and we certainly support the bill as Delegate McComas has just described it to you. We initially had some concerns about regarding whether some parts of the initial draft of the bill could be implemented. We discussed those concerns with Delegate McComas. She was very gracious. We had a very constructive meeting, and we agreed on a set of amendments that would address those concerns. Those amendments were apparently sent to the Department of Legislative Services for technical drafting. We received their version of the amendments about an hour ago, and they are not what we had agreed upon. The concerns as to the implementation problems remain with respect to the amendments drafted by DLS. We do support the bill with the amendments as Delegate McComas has recited them. We would like to work with Delegate McComas, who has been so very cooperative with us in this, to try to deal with that situation. We do urge that this bill be approved by the committee and approved by the General Assembly, but with the amendments that we and Delegate McComas had agreed to. Thank you, and I'd be happy to answer any questions.
I believe that is everyone. We'll go now to questions. So Delegate Williams, please.
Thank you, Mr. Chair. Delegate McComas, I'm not certain if you saw the letter that was submitted from the Maryland State Bar Association, the real estate property section, with regards to their concerns as to how your bill would affect basically recordings in the county land records. So, you know, with the land records, if someone purchases a house, their deed is recorded in the county land records. That deeded information, as well as the tax identification number for that property, is also sent over to SDAT for SDATs to put, you know, for the property tax purposes. And so I guess the question becomes, and those documents are needed basically for title searches and et cetera. And so how would your bill, I guess, affect that? Is the concern that the real property section has. I mean, obviously well, I shouldn't say we, even though I'm a member, we are supportive of the bill that you're trying to raise, and definitely wholeheartedly agree that we need to protect our members of the judiciary from harm. But, you know,
we were just trying to figure out a way to do this. Now, there is the security of the Secretary of State with domestic victims. And so, and that procedure is used for when they buy property, and it's sort of shielded. So that may be the remedy here. Of course, this has been a very challenging session, and have not had a chance to negotiate that. Right now, the problem is I think there's an argument between Judge Wilner wanted this bill put into the public safety, and the drafting, the amendment office seems to think it should go in a different section. So there's a disconnect there. So and just getting the thing, but I think the judiciary, because it's their protection and it's the protection for the prosecutors. Now, we haven't heard anything from the prosecutors, but I think it's a matter of getting something that's going to work. But I will say, sitting down with Judge Wilner, I realized that this is not a simple fix. And what he was suggesting, it doesn't go all the way, but it goes some of the way. And certainly, I think that we can probably take care of the concerns for the real estate through the Secretary of State, but we've got to talk to them and see if they would allow them. Because not every judge would want the protection, but some may. But certainly when 90% of the domestic of the courts are handled by the circuit courts and the district courts, those guys are on the front lines, guys and gals are on the front lines, and they make decisions that people are not happy with. And the public is getting, as we can all say, the public's getting raw and raw because there's so much stress in the community, in our society right now. So, domestic cases are some of the worst. And then if somebody loses a lot of money, or the judge awards the wife half the house value, and it's a pretty hefty amount. So I think we have to figure out a way to do this. And I'm obviously very amenable to any suggestions. And I will definitely be dialing up the Secretary of State, and also working with Judge Wilner and the Amendment Office.
Okay. Thank you.
All right, we're going to go now to Delegate Davis, then Delegate Cox. Delegate Davis, please. Delegate Deborah Davis, please.
Thank you, Mr. Chair. Delegate McComas, is there any reason why you left out the Office of Public Defenders?
I didn't think that people would be yelling and screaming at them as much as the prosecutors and the judges. Certainly if they would want to be in that, I mean, that's something we can consider, but I haven't heard too many situations where they have been assaulted, but maybe, are you aware of some? Because I'm not.
I'm aware that these lawyers deserve the same protection.
Well, I just think that they're viewed differently by the defendants, but I don't know. I mean, if they want to be included, we can certainly have that discussion and consider it.
All right, Delegate Cox, please.
Thank you. Delegate McComas, I think it's a great bill. Judge, I noticed that the proposed amendment was focusing on, like what Delegate Deb Davis just mentioned, just clarifying the protected persons. Is there something specific? I noticed that it was adding in magistrates and district court commissioners, which I think is a great idea. Is there anything else specific, including, I guess, Deb Davis's position on the public defenders, that you would want in there? Because I think it's a great bill.
Oh, no, I don't think, we just didn't address it because it wasn't in the original bill. But I don't think we have any problem if the legislature wants to include public defenders or other groups that are, that need protection.
Well, I know that under your testimony, you had mentioned that the amendment wasn't exactly what you had requested. So is that just the public safety article issue, or are there?
No. It's more than that. Where it's housed is relatively insignificant. We thought it belonged in public safety because that's the thrust of this bill, is public safety. As Delegate McComas indicated, there were something like 4,000 threats or inappropriate communications just with federal judges in the past year. And federal judges only deal with about 10% of the litigation. They don't deal with domestic violence cases. They don't deal with divorce cases. They don't deal with landlord-tenant put-outs. The high emotion-laden cases that can produce this. But we just did not think about, frankly, other groups.
So what would be some of the changes that you would look for in a new amendment that we can expect to see? So we just kind of understanding.
Well, I think that the committee probably has or can easily get the amendments that, with Delegate McComas's collaboration, we drafted and agreed to. I think the committee has those, and if it chose to do so, could adopt them, part of them or all of them, as opposed to what Legislative Services has given you. They have completely changed the bill around to put it back to almost where it was when we first discussed this with Delegate McComas. And I had never seen that happen before.
And in candor, Delegate Cox, I sent in what Judge Wilner's staff and himself had drafted and wanted to see, and they had it, just in perfect form, except for the way an amendment should be done. And I had requested a reprint. We didn't get a reprint, but we didn't get what we wanted anyway. So, but the point is that was passed on to them, and this is what we got back, which is not what we wanted. And literally, I didn't even have time to look at the amendment because I was busy trying to get it out to you guys. And then it's not what we needed, or wanted. But anyway, we'll try to fix that up.
Well, thanks for bringing the bill.
So we'll make sure that you get what Judge Wilner originally wanted from their office, and we'll get it emailed to everybody. Now, I have one request from Delegate Jones. I can't find her email address and so I wasn't able to send it to her. And I'm like, trying. So if she can give me her email address,
we'll work that out off of his bill. That's fine.
Okay.
I'll put in the
All right,
chat.
are there further questions for the panel? Seeing none, that concludes the testimony, I do believe. Yes, it does. For House Bill 686. Moving right along.
Thank you, Mr. Chairman.
Thank you very much, Judge Wilder. So now we're going to go to House Bill 885. And I guess this is where we're going to have the question as to whether or not they're done in JPR, because we're expecting Chief Judge Barbera to talk to us virtually for the first time, and Chief Judge Fader to talk to us. They are done in JPR, so they should be on the call. I'm double checking. And there they are. So with that, we're going to go ahead, and Ron Watson is going to go for 3 minutes. 3 minutes here, Ron Watson, on House Bill 885, and then we'll hear from both chief judges for 2 minutes each. Thank you very much. Delegate Watson.
Good afternoon, Mr. Chair, Vice Chair, and members of this distinguished committee. I come before you bringing the best bill of the afternoon and come to urge a favorable report for House Bill 885, which renames the Court of Appeals as the Supreme Court of Maryland and renames the Court of Special Appeals as the Appellate Court of Maryland. It also renames the Chief Judge of the Court of Appeals as the Chief Justice of the Supreme Court of Maryland and makes other conforming changes. Colleagues, this is the third time that I've been before you bringing this bill. This is the most bipartisan bill ever created and has been supported by luminaries in the judiciary such as Griffith, Malone, Shetty, Fisher, Davis, Crutchfield, Cox, Bartlett, Anderson, Arakan, and the indomitable and indefatigable Vice Chair Vanessa Atterbury. In this country, only the state of New York and Maryland have their highest courts named the Court of Appeals rather than the Supreme Court. And I ask this committee to vote favorably on House Bill 885. Thank you for your time, Mr. Clippinger.
Okay. I think the Chief Judge is having a challenge. Chief Judge Barbera is having a bit of a challenge with her camera. Oh, maybe we're okay now. Chief Judge Barbera, are you ready for us?
I am. Good afternoon.
For 2 minutes.
Oh, yes. Chairman Clippinger, Vice Chair Atterbury, and distinguished committee members. I will try to be very, very brief. Good afternoon, and thank you for the opportunity to testify on House Bill 885, the renaming of Maryland's appellate courts. For the record, I'm Mary Ellen Barbera, Chief Judge of the Court of Appeals, and with me today is Chief Judge Matthew Fader, Chief again of the Court of Special Appeals. We're here today to testify in support of the name changes proposed by House Bill 885. The history of the appellate courts of Maryland goes back to long before the Revolutionary War. Its origins can be found somewhere around the mid-years of the 17th century. It is a history deserving of respect, preservation, and celebration. Although one or two other states may dispute the claim, our Court of Appeals is the oldest appellate court in the nation. Our name, however, is the source of much confusion, for it is one of only 2 states, plus the District of Columbia, that has named its highest court the Court of Appeals. 48 states call their highest appellate court their Supreme Court, with many referring to their intermediate appellate court as a Court of Appeals. There is confusion from beyond the borders of our state as lawyers, law students, and litigants research, contact, and even file papers with the wrong court. That same confusion persists among Marylanders. They are most familiar with the nation's United States Supreme Court and expect that Maryland would have the same name for its highest court. Preventing new confusion is a good reason not to rename the Court of Special Appeals as the Court of Appeals if the highest court's name becomes, and I hope it does, the Supreme Court of Maryland. Imagine trying to research case law and not knowing whether the opinion of the Court of Appeals is of the intermediate appellate court or the Supreme Court. What would be challenging for a lawyer or a law student or any one of the members of this committee would be overwhelming for the self-represented litigant. Changing the names to what Delegate Watson proposes both cures longstanding confusion and prevents new confusion. Thank you, Delegate Watson, for submitting yet again this year a bill on renaming the appellate courts. Our appellate courts do carry a rich history. They will continue to do so even as their name changes. To meet their names change, to meet the need for greater clarity. That's what this is about, for greater clarity about their respective roles. The efforts to resolve the confusion caused by the names of Maryland appellate courts are not new. Going back to the 1967 and /68 Constitutional Commission and Convention, and then again throughout a number of years in the 1990s. I please urge your support for a long overdue change that will help the people of Maryland and beyond understand Maryland's courts better. I now turn to Chief Judge Fader, who will give you his thoughts regarding changing the name of the Court of Special Appeals.
Judge Fader.
Thank you, Delegate Watson and Chief Judge Barbera, Chair Clippinger, Vice Chair Atterbury, and members of the committee. Good afternoon, and thank you for the opportunity to be here with you virtually. When the Court of Special Appeals first opened its doors in 1967, it was a court of limited, and so properly referred to as special, appellate jurisdiction. As originally authorized by the General Assembly, my court's jurisdiction was limited only to criminal appeals. At that time, the Court of Appeals was the court of general appellate jurisdiction for all cases coming out of Maryland's circuit and orphans courts. Relatively quickly, the General Assembly saw fit to expand the jurisdiction of the Court of Special Appeals, first to torts, then to domestic relations, then to workers' compensation, and ultimately, by about 1972, to almost every type of case that first emerges from a circuit or orphans court in the state. Today, we stand as an inaptly named court. Although we like to consider ourselves a special court, identifying the types of appeals we handle as special is now a misnomer. In truth, we are now a court of general appeals and have been for some time, and we are happily and proudly a court of general appeals. Unfortunately, the misnomer at times sows confusion among members of the public. I would venture to say that the average Marylander, given the name of our 2 courts and asked which is higher, would likely identify mine. Most lawyers in the state do not suffer from that confusion, of course, but non-lawyers in the state, the self-represented litigants who appear in our courts every day, and lawyers and judges outside of the state do. I know that for a fact. The name change presented by this bill would help to eliminate that confusion. For that reason, I also urge your support for the bill renaming the Court of Special Appeals. Thank you.
All right, there are several questions. Delegate Cardin and Bartlett, then Juanita Fisher. Delegate Cardin.
Thank you very much. Thank you very much, Your Honors, for coming to us virtually today. And thank you, Ron, for bringing or Delegate Watson for bringing the bill. Wouldn't it make sense? First of all, I have no problem with Maryland being a unique state and being associated with New York's Court of Appeals. That sounds like a pretty good place to be associated with. However, why wouldn't you want to change it to the Court of Intermediate Appeals and the Court of Final Appeals? so that we don't get mixed up with the Supreme Court. And we don't have to, I mean, not that it wouldn't be nice to be called a justice, but you would certainly be mixed up with justices of the Supreme Court. So I understand the name change and I understand the confusion, but why wouldn't you do intermediate appeals and final appeals?
If I may respond to Delegate Cardin's very good question.
Go ahead.
I have some doubt as to the confusion that Marylanders and others would have if the name of the current Court of Appeals would be to the state Supreme Court. As I mentioned, 48 states, their state highest court, the court of last, final jurisdiction, say for any constitutional claim, federal constitutional claim that might go to the United States Supreme Court. But in talking with my colleagues across the country, there isn't confusion about the state Supreme Court and the United States Supreme Court. So with most respect, Delegate Cardin, I don't think it would present the problem that you've advanced.
Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Your Honors, for being here. Here I am. So the name change is fine, but my question is, will the robes be red?
The answer would be, and I would proudly report, they would continue to be red.
Great. Thank you.
We are the only state court that I know of across the country that has red robes. You've heard my predecessor, my Chief Judge Bell, refer to the red robes on many occasions. But worldwide, there are actually quite a number of courts where the judges or justices wear red, and sometimes blue, sometimes green. But we have our colleagues in Canada, some of the provinces in Canada wear red, and they are fancy. They have ermine. We don't have that.
Thank you, Your
Great
Honor.
question. Thank you, Delegate Bartlett.
Glad you cleared that up. Delegate Juanita Fisher.
Oh, thank you, Mr. Chair, for the, as I'm getting a phone call. Thank you, Mr. Chair, and thank you, Delegate Watson, for this bill. Judges, it's so good to see you. I have two questions. So I think the things about the, I'm pretty about the name change, but when it comes to court precedent and citing to prior cases, I just wanted clarification specifically for the attorneys on this committee of how is the court and what is the confusion going to be like when you are filing that appeal and you're citing in any courtroom in our state to prior cases when the court was a different name, and will you all be putting money or a framework to correct that, or it's just going to be known to cite the old way and then the new way will be with the new name?
Oh, and another fabulous question. Thank you so much, Delegate Fisher. It's certainly one that we've taken into account. And I know that I'm going to turn this over to Chief Judge Fader, if it's okay with him, because I think that court might have at least potentially a bit of concern were it not to be amended to the proposed name that Chief Judge Fader has for our intermediate appellate court.
So thank you, Delegate Fisher. Is the question more how attorneys would refer to the court? Like, for example, if they were referring to a decision that was handed down in 2018, how would they refer to the court?
Yes.
I think that my assumption is that the answer would be that if they're in our court now, they'd refer to the Appellate Court of Maryland generally, and if they wanted to say then known as the Court of Special Appeals, they could add that. I mean, the books wouldn't change, so the books would, with the decisions from this year and before, would identify it as the Court of Special Appeals, and I think that the practitioners would certainly know that, and there would be a change in the name as of the date. But I think that's why we wanted to make sure to keep the names distinct. As Chief Judge Barbera mentioned, even though the vast majority of intermediate appellate courts in the country are called the Court of Appeals, that would be an extraordinarily confusing name to give our court, given the history of the current Court of Appeals. So I think that they would just refer to the courts by their current names, and the cites to the reporters would be the same going forward. So the Supreme Court decisions would be in the Maryland Reporter and have that cite, and the citations to the Appellate Court of Maryland decisions would still be in the Maryland Appellate Reporter, as my court's decisions are currently. So there would be consistency through all of that. So if you're citing to a prior case, just by the citation, you would know whether it's an intermediate appellate court case or a Supreme Court case.
And I appreciate, I have a follow-up question, Mr. Chair, if that's okay. And I appreciate that answer, Judge. And I do also think about law students in Maryland and those, maybe from other states who are going to be taking the Maryland bar and practicing here as I did. I think it's already, you would kind of have to learn both sets of names as you were going through that. And even, I think those that law students that do clerkships and the like. And then my final question would be, a lot of the times we hear from the judiciary, more so Judge Morsi, but about the inability to do certain things that we ask, like automatic expungements and other things that we want to see done that are important to us. So I just wanted to ask the two of you is what would this change, it seems to be very important to the judiciary, and what about the changes that I think this committee has requested, but seems to get that it's an inability to be flexible or move on those changes?
That is that is a very appropriate comment, and it is a challenge to the judicial branch of government. And I would not want to take the committee's. I know you have precious time here and many bills, but we can have a continued conversation on that, Delegate Fisher and others. And we oppose bills that may be wonderful bills in content, but would interfere with the exercise of judicial discretion or would be contrary to sort of what is the limits of the judicial branch of government's role. But again, we could talk about this for quite some time, but I fear that the chair might be upset with me.
Yeah, he's usually upset with me though, Judge, so don't worry.
For another 10 or 15 minutes. Would that be okay, Mr. Chair? No.
No, I appreciate that. I really do.
We will get back to you though, Delegate Fisher. Absolutely, we will. There are folks on my staff who, as we speak, are listening to your questions and my response to them. And we will get back to you on that. That is a legitimate concern and one that I know we always have to, there always creates a little bit of tension between the branches, but it's worth continued conversation.
May I don't really have the context to address the second question, but could I address your first question, Delegate Fisher, about the difficulty of learning the two sets of names? I also went to law school out of state, and I practiced law for 10 years out of the state, and so have some familiarity, as you said, with coming to that. My impression is frankly that you wouldn't have to learn the new names. Because if you come from out of state, you're in all likelihood coming from a state with a state Supreme Court, and would expect Maryland to have the same name, and the Appellate Court of Maryland is a self-explanatory name. I think it's actually the current names that need to be explained and learned newly by attorneys who are coming from outside the state or law students. I think that the ones that are in this bill are self-explanatory just by their terms, and also certainly well known to others coming from outside the state.
Thank you both so much, and it's such a great honor to see both of you.
Thank you very much.
All right. I took a nice walk for lunch for once. It might be the last long walk I get to take for 47 days or so, and that's fine. It's a lovely day here in Annapolis, and I do want to compliment the Chief Judge because I walked down Route Boulevard and I turned left. I saw the lovely work that was completed in front of the building where she works. And there in gold type, brand new, Court of Appeals building. Looks very nice.
Thank you.
Questions for this panel? Seeing none, thank you very much. We're going to move on now to House Bill 35 to Delegate Cardin and his legislation on judicial elections. I believe we do have the Chief Judge here for this one as well. We have Delegate Cardin, who's going to speak for 3 minutes, Chief Judge Barbera, Judge Baines, Judge Barry, and we have 2 other people. And so we're going to call them out. We'll just do the first panel, 1, 2, 3, and 4. Delegate Cardin, Judge Barbera, Judge Barry, Judge Baines. We'll do that. We are joined now by people from Ways and Means. And that's Delegates Lisanti, Jones, and Long. I see Delegate Jones here. I'm sure the others are here as well. So we'll begin with that. And Delegate Cardin, if you'd like, for 3 minutes, please.
Thank you very much, Mr. Chair. Thank you, members of the committee. It's an honor to present this bill to you. Those of you who have been here for years past know that this is one that's very close to my heart. This bill seeks to standardize the appointment of and election process of judges on all levels of the state of Maryland. Currently, circuit court judges are the only judges in the state that are subject to a contested election rather than having to go through the standard appointment process and then continue to be able to stay on without an election. Not only is this practice inconsistent with the way that the district and the appeals courts operate, but these contested election of circuit court judges offer or present lots of problems.
Say what?
You didn't one this morning about that.
I think that's
Delegate Bartlett, if you would go on mute, please. Delegate Bartlett.
So let me just mention a couple of the issues that we have and the reasons why we want to do this. Number one, politics. There is no room for politics in judicial elections yet, and the judges are not permitted to play politics in judicial elections when they're campaigning. Yet they are required to walk that fine line. They're not allowed to be partisan. They're not allowed to talk about any issues or decisions that they had. They're not allowed to talk about it, but yet how are they able to campaign if they can't talk about anything? However, the people running against them can talk about everything they want. They can talk about the decisions of those judges that they're running against. They can talk about how they would make decisions if they are running against them. And that's not fair, it's not right, and it's a appearance of impropriety. The other appearance of impropriety is dealing with raising funds. You have to raise funds to run elections, and judges certainly get funds from lawyers and others who go before them. And whether it's improper or not is certainly an appearance of impropriety, and it just shouldn't happen. The judicial nominating system was, I've learned, was set up, the way it's done now was set up in approximately 1970, and it works. And now the issues, the racial issues that were problematic in years past are no longer a problem. If you look at this governor's appointments, just over the last 7 years, they have been diverse. There has been all the issues dealing with race, gender, age, all these issues have all been dealt with through the nominating process. Perhaps we should codify the judicial nominating process as a way of dealing with this. And that's something that I mentioned to the chairman, and maybe we can talk about that also. Challengers who become judges who win elections don't get vetted, don't get screened, and don't get recommendations. They don't go through the nominating process. And so there's an opportunity for there to be a real problem there. In 2024, non-incumbents won over sitting judges in Charles, Howard, and Prince George's County. And before that, 9 judges over the last 25, 30 years have won. This is not a major issue. It's just an issue of optics, number one, and of appropriateness, number two. Judges should not have to be campaigning. It's not appropriate. So this bill creates the retention election system that is in presently for appellate judges,
Delegate Cardin.
district court judges.
All right.
Thank you very much.
Thank you very much. Here's what we're going to do. I got a note that says that the Chief Judge, Judge Barry, Judge Baines, my understanding is that your testimony on House Bill 35 is going to be the same as your testimony on House Bill 447 with Delegate Dumay's bill. That's my understanding.
Correct.
With that being the case, I'm going to give you a little more latitude on time. I'm so generous, I'll give you 3 whole minutes because you're going to be doing it on both bills. And I know that both of these bills have a little more complexity to them. So since you're doing both of them at the same time, that's why I'm going to do that. With that, the Chief Judge, please, for 3 minutes.
All right, very good. And thank you once again. Good afternoon, Chairman Clippinger and Vice Chair Atterbury, as well as the members of this fine committee. Again, for the record, I'm Mary Ellen Barbera, the Chief Judge of the Court of Appeals. Thank you for the opportunity to talk to you once again about the need to eliminate contested judicial elections in Maryland circuit courts. With me today are the Honorable Keith Baines, who is the Circuit Administrative Judge of the 2nd Judicial Circuit and Administrative Judge of the Circuit Court for Cecil County. He's here today in his capacity as the newly elected chair of our Conference of Circuit Judges. Also with us this afternoon is the Honorable Bibi Berry, Associate Judge of the Circuit Court for Montgomery County, who can speak with much specificity about her recent election campaign. Many of you may have heard my testimony in previous years. Today's testimony may be familiar because contested elections for judges continue to undermine, ladies and gentlemen, the trust and confidence of the people in the impartiality of justice. Contested elections for judges have long been decried for the adverse impact upon public trust and confidence in the impartiality, and fairness of judges, to the point that Delegate Cardin made in describing his bill. It is a challenge to the judicial branch of government to have it be perceived as impartial, which it is, to have it be perceived as fair, which it is. Justice is meant to be fair and impartial. This is the only promise a judge running for elected office can make. That is why so many courts around the nation, including both of Maryland's appellate courts, rely upon retention elections. We judges who are subject to retention elections are accountable to voters who are able to vote upon our individual records of fairness and impartiality, upon our ability to deliver meaningful justice in the matters that come before us. In urging retention elections for judges of the circuit courts, we do not seek that the voters give up a vote. To the contrary, that voters cast a vote that decides whether a circuit court judge should be retained. Contested elections, however, are by definition political. I will not get into that in any detail because you've heard from Delegate Cardin and in previous years from me about we can't have to campaign if it's a contested election with essentially our hands tied behind our back, whereas someone who is not a sitting judge at the time can say or speak to certain things that just run opposite to what the judge's limits are. It is political. Politicians, justifiably so, seek votes by promising to do things for their voters, who seek promises in exchange for their votes. It's transactional. That is not the way the judicial branch of government works, whether it's in Maryland, all of our sister states, or in the federal courts. The only promise that is ethical that a sitting judge may make is to be, again, fair and impartial and to follow the law. I am trying to keep it short. So I'm looking through my notes real fast, Mr. Chair. I do not want to repeat what Delegate Cardin said. We are also very uncomfortable about the solicitation of funds to run a campaign as a sitting judge, and the awkwardness of primarily the people who would support a campaign with their dollars would be the lawyers who appear before the courts. Talk about something that is awkward between the judges and the lawyers who appear before them. Money should not be part of this process. It is no accident that the MSBA has strongly urged for the end of the contested elections for circuit court judges for many, many years now. Fairness, impartiality run high with our members of the bar. Many of you are members of the fine bar of Maryland and are with me as I'm looking at your faces this afternoon. We've come such a long way, ladies and gentlemen, members of the committee in Maryland from the early 80s, when courts were overwhelmingly white and male, and only about 1 in 10 judges was either a woman or a person of color. Today, I'm proud to report our courts look so much more like the Maryland communities they serve. It is important that all who seek access to justice in our courts know that people, I'm stopping right there.
All right.
A good lawyer knows when to stop. Thank you, Mr. Chair.
I need those red and green lights things. I really need that, but I don't have that. I should get that. I'll work on that.
Oh, thank you. Thanks
We're,
for the
we'll,
time.
I know how important this issue is. We'll do the best we can here. We're going to go now. I think it's to Judge Baines. I think that's right. Yes, Judge Baines and then Judge Barry.
All right, thank you very much.
3 minutes.
Thank you very much, Chair Clippinger and Vice Chair Atterbury, members of the committee. Good afternoon. As Chief Judge Barbera told you, my name is Keith Baines, and I'm here in my capacity as Chair of the Conference of Circuit Judges. The Conference of Circuit Judges is made up of the Circuit Administrative Judges for the 8 judicial circuits and 1 elected judge from each judicial circuit. And I'm here today to convey to you that the Conference of Circuit Judges strongly support both bills, House Bill 35 and House Bill 447. Mr. Chairman and members of the committee, there's no question that elections play a vital role in our democratic process. Both of these bills propose a constitutional amendment to alter the method of selection and tenure of circuit court judges from a contested election process to a retention election whereby the registered voters of the county, and I think that's important, from which the judge was appointed to vote to either approve or reject the continuance of that judge in office. I would also point out that neither of these bills propose a change to the current mandatory retirement age of 70. For more than 20 years, the Maryland Judiciary has opposed contested elections of Maryland Circuit Court judges, and that is for really the same reasons that Delegate Cardin and Chief Judge Barbera have mentioned. The current process requires judges to raise large sums of money from the very lawyers who appear before them, which undermines the integrity of the very system itself. And that's what happens every time a circuit court judge is appointed. Everyone has a right to a fair, independent, and impartial judiciary. Everyone has a right to appear before a judge free from political influence or social pressure. Fair courts mean fair outcomes. Elections decimate that principle. Unlike legislators and executive branch officials who choose a career in political arena, most appointees to the circuit court have no interest in being politicians or fundraisers. They are interested in due process and the rule of law. The rule of law should be everyone's focus, not politics. Once elected judges are rightfully forbidden from having anything to do with politics and fundraising until their term is about to expire. And even then, they are very limited in what they can say or do compared to their opponent. They always have one hand tied behind their back. As indicated, when it's time for election, judges can only say they'll be fair, they're going to work hard, they'll be impartial, while their opposing candidates can also often make all kinds of claims of being tough on crime, always giving long sentences to offenders with weapons, putting drug offenders in jail without repercussions. In addition, our citizens deserve judges with the background and experience to do the job. From the day a judge dons the robe, he or she is making decisions that fundamentally affect the lives of people in family, criminal, civil, and juvenile cases. Simply, this is not a job judges have the luxury of sitting on the sidelines while learning the job. It is a job that needs experience. We currently have such a process through the Judicial Nominating Commission. In addition to a comprehensive application, judges are thoroughly vetted through the commission as well as through 13 local and specialty bar associations. That is the way to pick a qualified judge. Lawyers who run against a sitting judge need only to be 30 years old, a resident for 5 years, and in good standing with the bar. That's it. There's no vetting, there's no qualification, no background check, no need to ever have stepped into a courtroom. As noted, and I think Judge Barry would deal with this, we've lost some amazing jurists through the current process. Campaign tactics by opponents, name position on the ballots are just some of the reasons. So for those reasons, I would thank you for your time today.
Thank you,
and
Judge.
Respectfully request your favorable vote on these two bills.
Thank you, Judge. Let's
Thank
go
you.
to Judge Barry, please, for 3 minutes.
Good afternoon, Mr. Chair and members of the committee. My name is B.B. Berry. Before the bench, I've been on the Judicial Selections Committee of my county bar and the Trial Courts Nominating Commission, where I vetted judicial applicants. The vetting revealed things like whether you filed your tax returns, charges, arrests, your business interests, personal litigation, sanctions, including private reprimands. The opinion of judges was one of the most important pieces of information we gather because judges see everything. They see how you practice, how you treat others, whether you're competent, honest, respectful of the law. And that source is entirely unavailable in an election, as is much of the other information that goes to the heart of acumen, competence, temperament, and integrity. Going through that process myself is the hardest thing I have ever done professionally, and it needs to be. After about 14 interviews for one position, closing your practice or leaving your career, and about a year into the job, there's the election. And you pray that you'll be chosen by an electorate who doesn't have nearly the information that the interviewing bodies had. In the recent election, my colleagues were condemned for being white. We were accused of being racist, insiders taking advantage of a rigged system, insensitive to the needs of the marginalized. Words were twisted out of context and even changed to impact the election. Members of the commission were accused of being unethical with zero basis. Voters were convinced that vetting our judges didn't matter. Voters wanted to know my stance on abortion rights, my party affiliation, and my opinions about politically charged issues that we as judges could not give. We do, in fact, go through elections with our hands tied behind our backs because we're sitting on the bench and obligated to follow the code of judicial conduct. Because we recognize that our responsibility to this community to foster trust and faith in the integrity of the system doesn't stop because we want to keep our jobs. Representation in positions of power is vital, but we certainly have not come so far that putting incompetent Black people on the bench won't close doors for others. We have to continue to support, mold, and mentor diverse attorneys and prepare them to hold positions that so heavily impact people's lives. So I implore you, please, please help us to eliminate judicial elections. Thank you.
Thank you very much. We have questions for this first panel. We'll go now to, we're going to start with Delegate Watson, then Delegate Juanica Fisher, then Delegate Bart. Delegate Watson, please.
Thank you, Chair Clippinger. And this was this Cardin's bill? Delegate Cardin? Okay, I have a
Yes,
question.
this is Cardin's bill.
Okay, thank you very much. So this issue is very challenging for me personally, because while I appreciate, the comments that I've heard about hands being tied behind the back, I've actually seen white candidates lose and somehow magically laws have changed. They become traveling judges. They get instantly reappointed back by the governor to start the process all over again. Yet I wonder if that same type of support structure, a la safety net, would have been provided for an African American. And so what I strive to do, when trying to work out these differences in laws, I try to find that common median. So my question, say for Mr. Baines, I think that's what my notes say. What if, you talked about the funding piece, what if it was all public financing approach. So we take funding out of the picture. What if they were restricted and automatically had to remove themselves from any ballot if they participated in any debates? What if we could somehow specify the number of years that somebody has to practice before they can even submit their name? And I say that, and give me a moment here, because, for example, my school board, there are a lot of folks who would like me to impose legislation that establishes criteria. However, all I can say from that perspective is an age requirement and how long you've lived in a specific location. Specific to the judges, because I agree they are very, very unique, require specified skill set and need to have their skills honed over time and be able to make good decisions. Is there any criteria we can put on candidates for that, so we don't totally shut out those who are trying to kick the door down and get in, but we can untie the hands of the judges who are seeking to, win that election? And the one thing I will absolutely disagree on, candidates are connected. All right. It is political. It is. To go through that process, to get your name through that morass of various boards and what have you, to get up to the governor, they are connected. Let's not make a mistake about that. All right. And so I would like an answer to my question. Are there some specific criteria we can put in place for judges, for candidates who seek to run, that would even the playing field, so that, as you say, the sitting judges don't feel that their hands are tied? Can somebody respond to that, please, if that's even a possibility? Thanks.
I can defer to either Judge Barry or Judge Baines to respond to that question. Since you're closer to the ground and certainly you have your recent experiences, Judge Barry, what do you think?
So there's a lot. I'm not sure I'll be able to respond as quickly as you all may like, but I would say that that putting more requirements in, I don't think it's going to necessarily address the concern of the vetting and the need to investigate fully applicants to the bench. And that's really the problem, that in the election arena, there's no opportunity to really do the investigating that you need to do. And someone can practice, and I learned this coming onto the bench. There are attorneys who come before me who've been practicing for 30 years. And there's this joke that some attorneys practice the same year 30 times. They don't learn and they're not good. And that happens often. And it could be people who are out in the bar and are known very well, and people don't understand that these attorneys are not good attorneys. That's what you find out through vetting.
May I follow up on that as I'm thinking about your question, Delegate Watson? It was a very good one. There always is, in the system that we have now for putting aside contested elections during the election cycle, there is all the vetting that Judges Baines and Barry have spoken to, and that everyone who goes through the nominating commission has the many interviews before that. There is an element of politics, I must admit, but I don't think it comes into play until the governor, whoever he or she maybe one day shall be, because the job of the commission, it's a neutral body, and the job of the commission is to send to the governor the best and the brightest, essentially, the most highly qualified. And it would be my hope going forward for all future governors to do what many of our governors of late have been doing, and that is making decisions. Once you've got a qualified individual, you can decide from among that group of, say, 3 or 4 or 5 or however many it may be, I want any one of these folks to be qualified. Any one of these folks could do a great job. I'm looking to diversify. I'm looking to bring women. persons of color, persons of different experiences than maybe others have had to the bench. That's where an element of politics comes into play. But you're only dealing with, as a governor, you're dealing with people who have gone through the crucible of the campaign, as it were, that is not an election campaign, but the effort to make it through the commission, and then onward to the governor. I hope that maybe adds an element of that's pertinent to your many good questions, Delegate Watson.
No, and I appreciate that, Judge Barbera. I'm just trying to take in the information so I can sift through it, and I appreciate you and the other judges' unique perspective. So thank you very much. Appreciate it.
Delegate Watson, I'll also say, because I've helped many judges who in their elections, I'm constantly talking on their behalf, going to communities and being able to say things that they're not allowed to say. I have seen candidates who have 20 years of practice, but yet they don't have the demeanor, they don't have the public interest, they don't have the kind of characteristics that you want in a judge, and the reason that maybe they didn't make it through the nominating process is for that very reason, or they decide not to because they know they'll never get through it. They're good campaigners. They can campaign really well, but they're not necessarily the people that that our expert community would choose to have be these judicial officers.
Thanks, Delegate Cardin.
All right, we'll go now to Delegate Juanita Fisher, then Delegate Bartlett. Delegate Juanita Fisher.
Thank you, Mr. Chair. And I was joking earlier, I'm not always in trouble. I'm my chairman's favorite. He just doesn't tell everyone. I'm just joking. My question really has to center on diversity for this judges panel. And I wanted to also say, I want to thank Delegate Cardin for the bill. And I do agree, being in different courtrooms throughout our great state, one, it's an honor to stand in front of the judges in Maryland. But the other part of it is that I do see is the lack, going from prosecuting to defense now, and I'm in other counties other than my home county of Prince George's, is the lack of diversity that I see at the bench. And so I guess this question really triggers on, the governor's role in the appointments, because there's an election, for example, and I'll just use my own county because that's what I know best. If you're going to put up a sitting judge's slate, and you don't see, for example, African-American or other judges of color, and you had, let's say, all white judges appointed, that some of those judges are going to lose, right? Because we are very diverse. Everyone knows Prince George's County, biggest Black middle class in the world. And so what I struggle with is, I totally understand all the concerns about the election, and I'm very open on this issue. I think for me, though, the question comes in, if you don't have that election there sort of being a rail and a check on who's being picked, how do you get diversity? Because for me, I don't see a lot of governors, I'm not even attacking this governor, let me be clear, over time, putting in candidates of color in non-diverse counties because they fear that they'll lose their election if you put an African-American judge in a predominantly maybe white and rural county. So I guess I wonder, how do we come to terms with that? How can me as an African-American female attorney, be in a rural county representing a client and feel like I'm going to see a judge that looks like me or my client somewhere? And so that is really what I struggle with, and I'm not sure of the solution. So I wanted to just bring that out to you all and to get to your comments and thoughts, and if this bill would it really address that.
I saw Delegate Dumais, and obviously both her bill and Delegate Cardin's bill are before you now. Delegate Fisher, just what you said. Those are the challenges. And those are the challenges perhaps in our rural counties, more so than some of our more populous, Baltimore City or our larger counties. But the three of us who are before you today, we represent a very large group of people who want exactly what you want. Qualified individuals who represent the community they serve. Male, female, trans, persons of color. It is important, and it's something that we need to work on. But we don't want to overlook the fact that we want folks who will have the characteristics, as Delegate Cardin mentioned, that are necessary to be a good judge. I think the best judges are those who struggle every day to get those decisions right. But I listened carefully to what you said, Delegate Fisher. You are much of what you said, all of what you said, I agree with. But what in the end we want good judges who cover the spectrum, the beautiful spectrum, and make fine decisions in the end.
We could also codify the judicial nominating process and put in it requirement of diversity in the selection in the options for the governor. There's nothing stopping us from doing that. We just have never done that, never gone that path. Something maybe we could work on, Delegate Fisher.
Thank you.
That's fine. We will go, just from a procedural standpoint, the judges are testifying on this bill simultaneously as House Bill 447. After this, we will finish the testimony on Delegate Cardin's bill and then do Delegate Dumay's bill. I thought I might call Delegate Dumay, but I missed that there are people and different opponents on each bill, so I need to keep them separate. So for that reason, that's why I'm doing what I'm doing. Let's go to Delegate Bartlett, then Conaway, then Cox. Delegate Bartlett.
Thank you, Mr. Chair. So Delegate Cardin, you make a good point. In fact, that's a bill I supported last year, was that we would have a level of diversity on the bench as a requirement. So, we just had, we listened to some bills today and previously on implicit bias training and the need for implicit bias training. And you made a comment that things have gotten better over the past 7 years. So with that, I want to ask you a few questions. How many Latinx judges do we have?
I don't know.
How many judges who are self-identifying as LGBTQIA plus do we have?
I don't know. I don't know the specifics. If I had them, I would pull the statistics up. I don't even know if we have.
Right, and so that's my point. How many Asian Pacific Islanders do we have? How many Native Americans?
We appointed our first Asian in Baltimore County this past year, and we have 2 now. Actually, we appointed the first 2 in Baltimore County. So.
Yeah, and so you're kind of making my point, but here's the thing. I couldn't let this go because this has been a huge deal in Anne Arundel County. And we just got our first appointed African-American woman to the bench. And I am, super excited about that, but that's just now happening. I think that one thing I wanted to suggest was if we could possibly, in lines where everyone else is going, could we possibly say, since we do have bar associations from each of these groups that I just mentioned, that, and I know that bar associations do the vetting process and come up with some names, but I think we need to do a better job with that in the sense that we can say, as a bar association, perhaps if not in the statute, we can say that there has to be 1 or 2 members from each section of the bar that represents these diverse populations. And those are the names who need to go to the governor. Because if you only give all white male men to the governor, by golly, who else can the governor appoint?
Amen.
So if we give more Latinx and all the entire group that I just gave, perhaps we could see a diversity in appointment, and your bill could could have, could hold water with respect to changing the complexion and the culture of our bench.
May I make a point?
Isn't that so?
Just a quick point, if I could. In the two positions, Judge Mike McAuliffe and I came through at the same time, and those were two open positions. There were no candidates of color other than myself who applied. And I think part of the reason might be because you have a lot of attorneys of color, and there's still inequities, of course. And a lot of attorneys are solos, small firms, and maybe can't afford the luxury of giving up their entire practice, starting on the bench, and then losing an election. That is really, really hard. I would love to have a judicial track mentoring program. I would love to be part of that. And I think that would help to solve some of these issues, not all of them, of course, but people have to apply too.
Right. I think a lot of people don't apply because they don't think they'll be selected. The other thing is I wanted to say, and I do appreciate what you said though, Judge Barry. The other question, one quick question I had to something that you mentioned, and that is with respect to, oh, darn, I forgot it. And I was trying to hold on to my apple because I know that my chair won't let me have another bite, but I cannot remember. I'm sorry. But thank you very much. And I appreciate your responses.
Thank you very much. We're going to go to Delegate Conaway now, please. Delegate Conaway.
Thank you very much, judges, for coming in and testifying respectfully. Delegate Cardin, the question is for you. I hear about this awareness and diversity, but what I'm interested in finding out about is what we were talking about in House Bill 950, where justice is going to be blind. And we've heard about these statistics. So it's not so much where we're looking at a Caucasian person or African-American or Latino person. What we're talking about is the disparity in treatment. So do you think the time shift in your bill would allow for additional training for the judges that would come on new?
Yeah, I mean, I think that we could probably figure out a way to wrap all this into additional legislation. I mean, House Bill 950 that's the Delegate Washington bill, right?
Yeah, anti-blackness training, if you want to. I didn't want to say that, but since you pushed me.
If we need to do additional training, and I believe it was the chair who suggested we put the training, maybe put the onus on the bar associations to help figure out how to maybe work on the curriculum. Perhaps that's the kind of thing where we can.
Yeah, well, I think the chair said something about after he gets the AG's opinion, but I appreciate you entertaining my thought. Thank you.
Delegate Cox, and then Delegate Deborah Davis. Delegate Deborah Davis, you are not muted at the moment. Delegate Cox.
Thank you, Mr. Chair and honorable judges. Chief Judge, I'm missing you on the screen if you're still here, but Barbara, good to see you, and Judge Baines and Judge Barry. Real quick question for Judge Barry. I just wanted to tell you that congratulations on your confirmation, election, et cetera. Supported you along with my close colleague from Rockville, John Garza. So I'm glad to see you retain that. And in light of that, I noticed that this election was kind of an interesting election in that we had, for the first time, I guess, in the last 30 years, we had a pretty strong field of replacement candidates, so to speak, that won, and all four appeared to be African Americans who defeated Governor Hogan's appointees, who obviously, as a Republican, I would support the governor's appointees, but I was rather impressed that three of them were African American women, one was an African American man, and they all seemed eminently qualified. How do you view that as a kind of a bellwether for how this would play into this bill.
Thank you for your congratulations. In the last hearing that I testified in, we were asked, do you know that any of the elected judges, the ones who took the seats of the ones who were appointed, they aren't qualified? And I think therein lies the crux of the problem, is that we don't know. You can't know in an election. And the very best way to learn that is to submit to the very rigorous vetting. And that's how you know. I understand the vetting process. Many believe it is not perfect. I don't believe it's perfect either. But you don't throw it out completely because it's not perfect, because it is the only vetting process that we have. Yes, there were, I don't think the story ends with the fact that there were 4 Black candidates who unseated 4 white judges. I just don't, I think that there is more, much more to be considered when we're trying to decide who should be on the bench than that person's color. And there are other diverse applicants that I'd love to see. I'd love to see people with disabilities. I'd certainly love to see more Latinos and Asians and Native Americans and LGBTQ and all kinds of diverse applicants. But I want them to be competent and qualified to be there. That's extremely important to me, and I think to many of us who deal with the law and the judiciary on a daily basis.
Thank you. Thanks so much.
Thank you.
All right, thank you. We'll go now to Delegate Deborah Davis, who can now unmute. All right, great.
Thank you, Mr. Chair. I'm enjoying the conversation, and I just wanted to add that what happens when the governor gets it wrong? I live in a majority minority jurisdiction, and we got our first Black female judge less than 4 years ago. The idea of that just amazes me. And we talked earlier about the separation of powers. How the heck do we have accountability? Do we get accountability if the voters aren't able to vote or to make their wishes known, which they did in my county just the last election? We had a contested election, and they got rid of someone that they thought was too conservative and who didn't represent our community. And so that's my question. If the governor gets it wrong, how do we hold judges accountable? And how difficult is it for you guys to maintain some accountability and get rid of a judge who you don't believe is doing a good job?
I'll just mention while everybody's thinking about the responses that my bill actually changes the retention from 15 years to 12 years. So it does reduce the amount. Now that's obviously that number is movable. But if we do have somebody who, it's just a shorter time frame. Nobody's perfect, as I think Judge Barry said, the system's not perfect. We're just trying to figure out, just like Thomas Jefferson or Winston Churchill, wherever you say is attributed to the quote, democracy is the worst form of government except for everything else. Well, the judicial nominating process is a pretty good system, but it's certainly better. At least my opinion is better than everything else. You look at Alexander Wright, and he's not here testifying, but Judge Wright was appointed twice and lost twice. He wasn't a good candidate. He didn't campaign well. He wanted to be a judge. As it turns out, he's a fabulous judge who went on to have an incredible career as an appellate jurist. So in my opinion, you just have to do what you think is the best possible situation, given that nothing's perfect.
There are further questions for this panel? I have a question that is tangential to this, but that goes to sort of the broader question regarding elections, and you've talked, Chief Judge, about pretty extensively, and I've seen the challenges that judges have as after they've been first appointed. They go out and raise money, and everybody sees who they get their money from because they have fundraisers with lawyers and many of the same lawyers who are appearing in front of them. The question that I have is, if there maybe is a intermediate station, I guess, on the pathway here, would it make sense to take the judicial elections out of the primary election? One of the more confusing, I think, parts of the judicial election process is that judges go on the ballot on the Democratic and the Republican, both Democratic and Republican ballots. While independents can vote, they don't generally vote in those primary elections. What if there was something that moved forward that would remove the primary election, and the judges would simply be up in the general election, and anybody who wanted to run against them would also be up in the general election?
Well, this is Judge Barry. I certainly would be happy to get rid of the primary. And one of the interesting things is I thought it crazy that you can't vote for judges as an independent. And in fact, when I would be asked, well, what's your political affiliation? One of the points that I made was that I can't have any input in my judges if I'm registered as an independent, which is unfortunate. But removing the primary just doesn't resolve the huge problem we have with ensuring that our judges are vetted. They're making these major decisions about people's lives. And you have, I recall being at the polls, and I would talk about vetting, and my assistant, she was with me because her job's online too. And she said, people don't know what that is. You have to explain. People didn't know what vetting was. And frankly, a lot of them didn't care. Regarding accountability, retention elections will provide some accountability. We also have judicial disabilities, but therein lies part of the problem as well, that if I don't know the law and I apply it wrong consistently, there isn't a lot of accountability. I think that the parties can appeal. They can appeal, and that's money, and that's time, and that's pain that they have to go through to get the right decision, hopefully. That's part of the reason why we have to have the vetting.
So you're saying that, I guess my question is, first, there's a cost that comes with running in the primary election. There's a cost with running in the general election. My question here is it's, if we did not make a significant change with the elections system right away, would it, you're saying that the primary election is somehow helpful in vetting the judges? Because I'm missing that, because I think that I think from my experience running with judges on the ballot, I run into too many people who can't really make a judgment about those things, and maybe that is a separate question, but I guess I think that excluding a significant portion of the population of independent voters from making that decision on what is effectively, or what is supposed to be, a nonpartisan decision, I'm more than vaguely uncomfortable with that. So you're saying that the primary election is helpful in vetting the candidates?
Not exactly. What I'm saying is I don't like the primary, but I don't like the general either.
I got it. Okay.
I'm saying Yeah, what I'm saying is that I have the same problem that I think you have with the primary, is that there's a significant portion of the population that can't say anything, can't make a decision about their judges, but that doesn't, primary and general, neither one resolves the issue of vetting.
Got it. I understand you. Okay, that's fine. I'm going to stop right there. We will let the judges go. Thank you all very much for being here today and spending some time with us. Appreciate it. We're not with Delegate Cardin's bill, however. We have people who are here to testify in favor, two in favor, one favorable with an amendment. So we'll hear from Michelle Seary, from Ron Jerichow, and Eric Smith testifying favorable with amendment. Then we'll hear from those people in opposition to Delegate Cardin's bill. Then we'll hear from Delegate Dumais on her bill. So
I think, Mr. Chair, I think that Michelle Seary had to go over this JPR in the Senate, so she may not be in our waiting room.
All right, is Ron Jerichow here?
Yes, Mr. Chairman.
Ron Jerichow?
Yes, I'm here.
Great. If you'd like to testify for 2 minutes.
That's fine. Thank you, everybody. My name is Ronald Jerichow. I am a former judge in Anne Arundel County. I lost in the 2010 election. I am testifying on behalf of the Maryland Association for Justice, and on my own behalf, I've filed position papers in both regards for the committee to review. I'll try to summarize what I can, because I also would like to respond to some of the questions I just listened to by the committee. First of all, a judge can screw up a life of the people before them worse than any other politician can. What I mean by that is that there are checks and balances. You all have an executive branch. A judge doesn't have that. So as Judge Barry said a few minutes ago, a judge has a tremendous amount of power. And that's why we should be careful in who gets selected and appointed as judges. They go through 14 different interviews, the governor interviews, there are multiple ways that the candidates are vetted. And the retention election would be much more likely to get people who have been vetted on the bench. And I'll just point out that I agree with Judge Barry. It's a question of who applies. The current system actually deters people from applying. Nobody wants to give up a practice. A minority candidate doesn't want to give up a practice that's successful to go on the bench. So you're talking about a qualified minority candidate that would make a great judge. Why would that person give up a seat? Let's look at the history. It's true, this past election, there were many minority candidates who prevailed, but that's not been true historically. In Anne Arundel County, there have been 2 minority candidates who did not prevail. Judge Warren many years ago and Claudia Barber did not prevail. And if you look at that across the state, my understanding is, and I haven't really studied it because it's hard to get that statistics in my position. I think in Howard County, in Talbot County, and other counties around the state, minority candidates have lost. Judge Wright was a good example, as Delegate Cardin said. So my point is that the current system is not conducive to getting minorities on the bench, even though it has been sometimes successful. And we're very pleased. I mean, I'm very glad that we have minority candidates on the bench. But the fact is that it's not a good system for accomplishing that goal. That so much in my election, I lost to a person who had an A as a last name. When you talk about not vetting, my understanding is she never tried a case before, but she became a judge. I lost. And you ended up with somebody on the bench who her first trial was as a judge. That's not a good system. And I know Delegate Watson talked about political contacts. I didn't have political contacts to get on the bench. I practiced law for 35 years. I tried to keep a high quality. I clerked for the chief judge of the Court of Special Appeals, and I got selected, I believe, on my merit. I was nominated 5 or 6 times before being appointed for the appellate court and the circuit court. But, I went through the whole vetting process each time. The ethical considerations are very serious.
Mr. Jerichow, Judge Jerichow, please, if you would wrap up, please.
Okay, I'll wrap up. So, and I'll just go with one point. The public doesn't understand. When you're running, only 100,000 people voted in my election, 200,000 people voted for governor in my election. I would ask for a favorable report on this bill. Thank you.
All right, thank you very much. I understand that Michelle Siri and Eric Smith are still effectively over in JPR. They are also signed up to testify in favor of Delegate Dumay's bill. We're going to keep moving forward. We'll give them the opportunity to talk hopefully when we come around for that, for Delegate Dumay's bill. But I will ask now whether anybody has any questions for Judge Jericho, and then we will go to the people who are in opposition to House Bill 35, and we'll hear from them. Any questions? Seeing none, thank you very much for being here. I think you're coming back again for Delegate Dumay.
I am. Thank you.
That's totally fine. We'll hear from you again in a moment, but now we'll go to those in opposition to House Bill 35. We're going to hear from Judge Robert Dugan, Claudia Barber, Ricky Jones, Mithun Banerjee, Mary Lynn Pierre, and Marguerite Morris. We're going to hear from all 6 of them. And I will wait to see if any of them pop into the room.
I'm Judge Dugan.
I see you. Would you turn on your video, Judge Dugan, please? There you are.
Oh, thank you.
All right, Judge Dugan, you can go first. We're trying to keep people to about 2 minutes, please. Would you, if you can do that, that would be great. And then we'll hear from Claudia Barber and the rest. Judge Dugan, please.
Thank you, Mr. Chairman. I'm testifying against both bills. Let me introduce myself. It's been my honor and privilege to be a judicial officer in the state of Maryland for 37 years. I've served as a magistrate, a district court judge, a circuit court judge, and now a senior judge. During the last recent history, the events have enhanced my position that we should not change and do away with circuit court judicial elections. If either of these proposals is enacted, the winners will be well-connected, white male Democratic lawyers, many from large law firms with political clout. The losers, Republicans, women, African Americans. Only 7 Maryland governors out of 62 have been Republican. The experience with Governor Glendening and Governor Malley demonstrates they did not appoint Republicans. Women and the minorities have definitely benefited from the election process. Going into a little more detail on Delegate Cox's comments, let me summarize. Since 2010, there have been 10 successful challengers. 7 have been women. All defeated incumbents were white males. 4 of the 7 successful female challengers have been African American. 1 of the 10 successful challengers was an African American male. So a total of 5 of the last 10 successful challengers have been African American. All 4 successful challengers in 2020 were African American. In response to Judge Jericho, overall, African American challengers have won 9 times, whereas only 3 have lost. Let me address this vetting situation with the Judicial Nominating Commission. Majority of the members selected by the governor. They meet in secret, they interview applicants in secret, they confer in secret, and they vote in secret without any explanation for the basis of their recommendation. The system is very reminiscent of the Star Chamber in medieval England. The nominating commission is a window dressing, a facade, and political cover for those who are most influential in having judges nominated. The process serves as an old-fashioned shield for political patronage and a spoiled system.
Judge Dugan, we're going to need you to begin to wrap up, please.
Thank you. The governor selects the commission members, and commission members most likely will approve of his choices. May I have one final comment?
Quickly, yes.
Yes. I remember talking to Ken Johnson, an African-American judge elected in 1982, and he related to me his experience of going through the nominating commission and how demeaning and condescending they were to him. And that's why he sought and was successful in the election process. Please keep this system open for the benefit of Maryland citizens.
Thank you, Judge Dugan. Thank you. We're going to go now to Claudia Barber, please, for 2 minutes.
Good afternoon, everyone. Good afternoon, Mr. Chairman and members of the House Judiciary Committee. How many members of this Judiciary Committee know why there are no Hispanics, no Native Americans, and no Asian Americans on most of the circuit courts in Maryland? Why hasn't a task force been established to determine why these ethnic groups are consistently shut out of the shortlisting process, especially in counties such as Anne Arundel County, which has a history of blocking and not considering non-white applicants for nomination to the circuit court? House Bill 35 and 447 and its companion bill do not help us get closer to eliminating that exclusionary practice. It is state-sponsored discrimination. Just as the Maryland Legislative Black Caucus met this month with the Maryland State Superintendent of Police about discrimination in the state police force, it is time for the same caucus of other legislators to summons the Judicial Nominating Commission members and get answers regarding why the commission practices disparate selections that consistently benefit white males who often are less qualified than applicants of color. The commission's current selection process is not transparent. Judge Dugan did an excellent job of explaining why, and there is no real oversight of Judicial Nominating Commission members. Therefore, we ask the members of the House Judiciary Committee to issue an unfavorable report on both House Bills 35 and 447, which would change what is supposed to be a transparent and open nominating process to one that will only encourage further discriminatory practices. Further, and of great significance, the elimination of circuit court judges contested judicial elections to replace by retention judicial elections only as a sophisticated voter suppression tactic. Vote no to House Bill 447 because it deprives voters of their constitutional right to choose trial
Ms.
court judges.
Barber, you're on 35 right now, and your time is about expired. If you'd like to sum up on 35, that's fine.
They will have to live with the next 15 years. Vote no to voter suppression and biased judicial nomination selection practices. Thank you.
Thank you very much. For the next time, we're going to need to be able to see you. It says that your camera is on, but we're not seeing you, so you may need to remedy that on your end.
Thank you.
Ricky Jones, please, for 2 minutes. Ricky Jones.
Yes, I'm here. Thank you very much, Mr. Chairman, Vice Chairman, and members of the committee. Thank you very much for your time. I sent a written report in, so I won't go through that in detail. I was pretty thorough with that, so I'll kind of rely on that. So what I want to talk about is I want to talk about some of the things I heard in favor of the bill, because these are very disturbing. Number one, politics. What I want to share is that I've run multiple times for the circuit court. And the concern about politics, I'll be able to discuss issues and things of that nature. I sat next to other candidates and we sat in forums together. And we all deliberately did not talk about issues because we respected the process and knew the judges could not do that. Challenges not being vetted. This is such an unfair process and a process that is not genuine in terms of objective qualifications. I'm talking about legal knowledge, experience, and scholarship, because anytime you put a Caucasian on the bench with 1.5 years of legal experience in private practice, and Reverend Jones has been doing this for 30 years, 15 different areas of law around the country in state and federal court, that is preposterous. The vetting process is a farce, to be light about it. Undermine the trust of the people. Nothing undermines the trust of the people more than depriving them of their right to choose. The circuit court, unlike the district court and the appellate courts, has such a significant hand in the lives of citizens For example, major civil matters, serious criminal matters, family law, domestic violence, juvenile, appeals from a district court, from administrative agencies, from the orphans court. Their hand is so significant in our lives that if we have no say-so on that, it is a tragedy and anti-democratic. And finally, this voting for retention is not really the voice of the people. They have already been given a choice. So they did not vote for the choice. So the whole idea about retention is, so to speak, misleading. And I'll conclude with this. I noticed at the end of both of these bills, 35 and 447, that the amendment is to be submitted to the people to get the vote on it. But the very amendment being submitted to them is taking a vote away from them. This double-minded stuff is disrespectful of the electorate. Please vote against these bills. They're very bad ideas. Thank you very much, sir.
Thank you very much. We'll go now to Mithun Banerjee.
Good afternoon, everybody. Thank you, Chair and Vice Chair and the committee members and the judges present today. Thank you for the opportunity. I'm wearing the cap because of the COVID. I have the long hair, excuse me, and the mask to support the people and the first responders and the doctors and nurses doing a wonderful job in the state and the country due to COVID. So I'm right now here today present for the opposition of House Bill 35 and 447. And I just wanted to let you know that I was born in India and I migrated to this country and I'm a legal citizen of this United States of America. It's a wonderful country of immigrants. So I have personally faced discrimination and my rights were violated by the sitting judges of District Court and Circuit Court of Montgomery County. Judges preside over cases of their distant cousin and law firms from their campaign managers' law firms in this recent elections, and maybe in the past, I don't know that. I have even filed complaints to judicial disability commissions, and those complaints were not even taken forward, nothing happened. And they want evidences, but no recourse was taken. I filed 4 lawsuits against 4 sitting judges in US Federal District Court, but they were been for possible corruption, possible expertise communications, and they were been dismissed for judicial immunity. I even have filed my writ of certs in Court of Appeal, and now I'm due to US Supreme Court, which was not accepted. Even I filed a motion, not done that. So it is very unfortunate, people like color like me. Montgomery County is a minority majority county, and that doesn't reflect in the circuit or district court judges. I want to see more judges who looks like me. If I can see that, I think that will be wonderful. So I would request the committee present today, please don't vote in favor of this. Please give an opportunity to people who can vote and choose a person of color who can reflect, who looks like me or somewhat similar to me. I appreciate the opportunity. Thank you very much. And
thank you.
Be safe and thank you for this opportunity.
Thank you very much. We'll go now to Mary Lynn Pierre, please. For 2 minutes.
Afternoon. Good afternoon, Mr. Chair. May I please have additional time because I am going to testify in opposition to both Bill 335 and 447 at the same time.
Well, I was going to let you testify against the other bill when we go through that bill, so we were going to give you those 2 minutes then.
Well, when you did the other panel, you allowed.
If you'd like 3 minutes now for both bills, that's perfectly fine. I'll give 3 minutes right now for both bills.
Thank you very much. Good afternoon, Mr. Chair and members of the House Judiciary Committee. My name is Mary Lynn Pierre, and I am here to testify in opposition to House Bill 35 and House Bill 447. Intrinsic in the right to vote is the right to vote for the candidate of your choice. All of the candidates who challenge the appointed judges are qualified. The candidates have to file the same judicial financial statement, pay the same $50 filing fee, and get the same approval from the administrative office of the courts before the Maryland State Board of Elections would put their names on the ballot. I implore you to ask yourselves, if you would be here if you had to go to an unelected and unaccountable commission before your name could be put on the ballot. How many of you would not be chosen because of your race, your gender, your religion, your family's lack of connection, your lack of a social network, your social economic status, your gender identity, your your sexual orientation, your disability, or the myriad of other conscious and unconscious reasons that the Commission perceives to be necessary to recommend you, but which have no bearing on your qualification for the office. We only need to look at Maryland's federal bench to see what will happen if House Bill 35 and 447 or similar bills were to pass. Maryland has very few people of color on its federal bench in comparison to its general population. Maryland has never had a Black woman or a woman of color on its federal bench, in spite of the brilliant, dynamic, passionate, and well-qualified Black women and women of color who have applied. Maryland has never had a judge who self-identifies as LGBTQIA on its federal bench, and to my knowledge, has only had one judge who self-identifies as LGBTQ. The Justice Policy Institute reports that Maryland incarcerates a higher percentage of its young Black males than any other state in the country because of the extreme sentences that the Maryland judges give them. These shameful statistics and others I do not have time to go into right now will become worse to all of our detriment if HB 35 and 447 are passed. If an elected judge is not performing his or her duties properly, the Commission on Judicial Disabilities is there to address whether that judge should be retained. And just like appointed judges, candidates for judicial office have to abide by the Maryland Code of Judicial Conduct, and they are limited to what they can say and do as candidates. I asked for an unfavorable report in reference to HB 35 and 447. Thank you for your time and attention.
I have too many things going off at once. My phone, then my ringer on the phone telling me that the time is up, then everything else. I apologize, Ms. Pierre. Now, here we'll go next to Marguerite Morris, please, for 2 minutes. Marguerite Morris.
Thank you. I believe there is a system. Can you hear me?
Yes, can hear you and can see.
Can you hear me?
Yes.
There is a system issue, and this has been a harrowing experience with confusion. So everybody's experiencing that. I can see none of you except for 2 people.
Okay.
But anyway, thank you very much. I'm here. My name is thank you, sir. My name is Reverend Marguerite Morris. I'm the founder for Kathy's Sake Community Advocacy Seeking Transparency. I reside in Irvington, Maryland. In my experience in courts over several years in matters affecting the community, I've come to know and appreciate judges that have unbiased opinions and feel the pain of those with biased opinions. I've come to understand that these sometimes biased opinions can result from inherent conflicts of interest, and we should have the right to select on the ballot from a field of qualified candidates instead of demonstrated biased judges running unopposed in a system that persons that don't know any better will do no more than check the box. Therefore, I adhere to oppose HB 35. Citizens should have the right to form their opinions about how judges handle issues and whether those judges have done a good job in being fair, honest, and open in court proceedings, as well as being sensitive to the community it represents. We should continue to allow qualified individuals to declare their candidacy because it is their desire to serve our community in that capacity. The fiscal and policy note for House Bill 35 reads, appellate judges frequently receive 80% or more of a vote in favor of retention. It is here that I made a note that normally persons such as myself have a tendency to check all the boxes because the persons are running unopposed. That is most likely why the 80% vote in favor of retention of those running unopposed. There's a need for not only judicial reform, in an article by David O'Brien about state court elections and judicial independence in the Journal of Law and Politics, it notes that the very reason for the need for elections results from a history of corrupt and partial judges empowered to continue by both legislature and governors acting in unison to not only promote their friends, but keep them in positions of power, unfortunately. Moreover, circuit court judges should be voted on by the citizens because they have made themselves known through the campaign process about their demonstrated impartial values and beliefs, and yes, sensitivity to the community they serve within the law. In addition, it should be one's constitutional right to select the individuals that not only represent themselves with the qualification to do the job, but in their demonstrated ethics and commitments to serve and respond with the demonstrated impartiality. In conclusion, why can't they be known by the people and elected by the people to be representative of those communities? Again, thank you for your leadership, and I ask you respectfully to oppose House Bill 34, Judges Selection and Retention. Thank you very much for your patience.
We can't hear you, Mr. Chair. It doesn't say you're muted, so I'm not sure what's happening.
Can you hear me now?
Yes.
Oh, that's better. Let's try that again. I had started like an hour-and-a-half conversation with everybody, but I guess I won't do that. Let's give it to Delegate Watson instead and let him ask a question. Delegate Watson, then Cardin, then Crutchfield.
Thank you, Chair Clippinger. My question is for Reverend Morris. And Reverend Morris, you had mentioned, qualifications, and I don't know if you heard my prior comments, but trying to seek a balance, in this process. Let me tell you, from personal experience, a prior member of this Judiciary Committee threatened an individual who was running for candidate for judge that if she supported me in my desire to come to the delegation, she would not be supported to become a judge. He ultimately did not support her, and I'm here now with you. That is a person who is going through the current process the way it currently is. And when I said that there is political pressure to do that, I know from personal experience. However, there has to be more qualifications assigned to those who seek to be a judge than just the fact that over some course of time, you have studied law, okay? My question for you, Reverend Morris, is would you be supportive if there were other criteria other than just the basics, other than just having a law degree, no matter how long ago you got it, and being of the proper age? Would you support other qualifications? That's my question. I think more is required. I don't know if you can see me on your screen.
Absolutely.
Go ahead.
No, I can't, but if you can hear me, I would support, yes, sir, I would support other qualifications, but then that's part of getting to know the candidates and their qualifications. And I think that person should have a right to run, and we look and evaluate, the citizens look and evaluate their qualifications, evaluate them on what they've demonstrated themselves to prove who they are, and that we be trusted to be able to make that determination.
And so my last question is, what if the process didn't just include those who the various bars felt were worthy of going through the process, but everyone had to go through the process? And then before an election, the newspaper said, here are those who met qualifications, had that list, and here are those others that applied, and left it like that. That would be the one piece of information that will go out to the community. No debates, no forums, no fundraising, general information. And it tells you the people who met this criteria, here are what they went through. So we can increase the knowledge of our electorate, but hold back all of the other nuances that everybody admits that there's a problem with running elections for candidates. Would you agree with something like that?
No, I would not. And my experience tells me that working in the community and getting to know those individuals, different individuals, and the jobs they've actually done and what they've actually represented when they weren't running for judge, I think all those qualifications. So we've had, in my opinion, we've had some near misses where persons that absolutely were not who we would vote for, but because they may have had those qualifications might have come out and appeared to be ahead. We need to be able to look at individuals, look at what they are representing, look at the life they're living and all of those different things, and be trusted to make those determinations, as well as being qualified on paper and in a school does not mean that you are experienced and have the background and acknowledge to bring all those things to the table. And that is where it can be misleading. I myself am a non-attorney. But in my experience with attorneys, I've given several qualified attorneys, excuse my expression, hell. So that I don't know what that qualifies me as, but it says that you don't always have to have that written experience to have the ability to do that job above and beyond what is needed in our community. So I would not, I would not base it just on paper qualifications.
I understand, but even if a part of that information was a biography that each candidate had to write themselves and submit. So you have reference for their background, you know their schooling and their education. You have that summary that an individual will want to get out. I'm trying to put two pieces together here to make sure that a person who is qualified, who has a law degree, but for some reason cannot make it through the process, has a shot at those who have a little more recognition in legal circles, who also have a shot, to put those together in some kind of framework where it doesn't hold a disadvantage to one or the other, mitigates all the things that we heard are negative things about the whole running piece, but still offer an opportunity for the public to make an informed decision. And that's all I have. I just want you to respond to that for me.
And I'm not sure exactly how to respond other than that as a private citizen, non-attorney. I know that there are more factors to making that determination other than that piece of paper. And there are persons that they show their qualifications in other ways. And therefore that bar should not be that unless you got this degree, because a degree, let me say this and then I'll be quiet. And it may or may not apply, but my stepson years ago came to me one day and he's 12 years old. He said, I've read the Bible from cover to cover. I was like, okay, at the age of 12. Now he knew what he read the Bible from cover to cover. That did not demonstrate that he had mastery over anything in it or that he was qualified to do anything in it. So I'm saying there are a little more factors to that. And I personally want to see not just what someone speaks and not necessarily what they've written on paper, but if you want my vote and my confidence in you, I want to see how you've demonstrated that in other circles. And oftentimes persons with the qualifications, their life should mirror that in other ways about them. And I think the community has a right to get to know those individuals and what they stand for.
All right. Thank you for your comment, Reverend. Appreciate you.
Mr. Chair?
Yes, Ms. Pierre. Ms. Pierre, go ahead.
If I may respond to some of what Delegate Watson talked about.
All right, I will let you do that. Just one moment. I'm going to step down for a moment. The vice chair is going to take my place and give me a second to take a quick break. So we'll, Ms. Pierre, please continue, and I'll pass it to the vice chair.
Thank you, Your Honor. Reverend Morris made some very, very good points, but I want to talk about my personal experience. There was a lot of discussion about the vetting process in the previous panel, and I would like to talk about my personal experience. The last time I went in front of the Montgomery County Trial Court's Nominating Commission, I felt like I was under fire and I did not understand why. It was not until I went to the person who actually was able to fill that vacancy that I had a semblance of what I think happened. What the person on the commission who gave me the hardest time, who would not let the other commission members ask me any questions, who would not, who just dominated the whole interview, was this woman who then was able to, what was a speaker at the judge's swearing in ceremony. And she said, oh my goodness, I'm so glad so-and-so got appointed to the position. You know, he gave me my first job as a lawyer. I have known him for over 30 years. His husband and my husband were law partners before my husband got on the bench. And now, you know, he's going to be on the bench also. He and his wife and me and my husband, we hang out together regularly. Oh my gosh, this is the best thing that's ever happened. And to have somebody who is on the commission who has so many ties with one of the applicants, yet does not reveal that, and has, as far as I know, has no duty to reveal that, is problematic. And so we could talk about vetting all we want to, but until those problems with the vetting process are taken care of, it's not a good system to just allow vetting and not an election of judges. And in addition to that, there was a discussion about, well, these elected judges will not be qualified. Well, all judges, whether they are elected or whether they are appointed, have to go to what's called baby judge school. Are the people at the other panel saying that the elected judges do not have the capacity to learn what they need to learn to be judges at baby judge school before they take the bench? So thank you very much, Madam Vice Chair.
Thank you. Next, we'll move to Delegate Cardin, then Delegate Crutchfield, and then Delegate Conaway. Delegate Cardin.
Thank you, Madam Vice Chair. Thank you, Ms. Pierre, for that anecdote. And I had a similar experience with a person being appointed in Baltimore County who I thought, because of their close relationship with the nominating commission folks, why he may have gotten that appointment. But the truth, and I found that to be inappropriate. But the truth of the matter is that, like we already admitted, the system is never going to be perfect. Here's the question. This really is a question for Ms. Morris. You were talking about wanting to get to know people and wanting to see their ethics and wanting to see kind of their morals. And the problem is, as was already indicated by the judges who testified in favor of this bill, is that the sitting judges are not permitted to talk about their ethics. They're not permitted to talk about anything that will help you understand what they're going to say or what they're going to do or how they're going to act. But yet the candidates who are running against them can say anything they want, and they're not obliged. They're not under the judicial ethics or judicial conduct canons. So, and not only that, they can say that they're a judge. They can say that they've had the experience of being a judge. They can say whatever they want, whereas a sitting judge is not permitted to do that. So I'm not sure that, and if you want to correct the vetting process, fine, let's correct the vetting process. But I don't understand how you think you're going to get to know a candidate when we know that like 98%, everybody but the judges, but the lawyers have no idea who these judges are and what they represent, what they stand for, because they're not supposed to. So I'm wondering if you can comment. I just don't understand how you can say that you're going to get to know these candidates.
Is that for someone in particular?
That was for Ms. Morris. I'm sorry.
Okay.
Thank you. Yes, thank you. And I can absolutely talk to that experience. I think in one of our last elections, there was an individual running, and I had experience with that individual throughout the community for several years. So I knew his pattern of behavior. I knew how he actually treated and disrespected me when no one was watching. I knew the evilness of his character. Other people wouldn't have known that, but I knew from personal experience. So when he launched his candidacy, I knew who to vote for and who not to vote for. So I think that person shouldn't have to tell you about themselves. You should be able to see it in how they walk their life. So by the time they get to, and I say that because in those individuals declaring their candidacy, they didn't just become a judge right then. There was something about their life before they became a judge. So they shouldn't have to speak it out of their mouth for some of the citizens to know what they're really representative of. And if that individual had won, our judicial system would be in trouble because of his character, who he really was when people weren't watching. Now, and that's an important component of us being able to elect who we'd like to see represent us in these different capacities. Thank you.
Madam Vice Chair, I'm so sorry to keep interrupting, but may I address Delegate Cardin's point?
Yes, briefly.
Just briefly, that is not true. A candidate for a judicial office has to abide by the same code of judicial conduct as an incumbent judge. That was said over and over again, but that's not true.
Okay, next, Delegate Crutchfield.
Thank you, Madam Vice Chair. This question is for Ms. Pierre. So Ms. Pierre, we have talked a lot about the vetting process, and I know that you have run during several different election cycles for a circuit court judge in Montgomery County. So what I'd really like to understand and know is, as a candidate running for judge, what makes you believe or feel that you are qualified to be a judge without going through the vetting process?
Thank you, Delegate Crutchfield. I have gone through the vetting process many, many times, and there's nothing on my application that is disqualifying. I think that the administrative office of the courts know more about me than they do about the other candidates because I have applied so many times. The reason why I can't get through the vetting process, in my mind, really has to do with what I stand for. I stand for, I believe that the justice system should provide just that, justice. And to me, the fact that Maryland's justice system just are not getting the results that we should be getting if things were fair and just is really what I have with is really why I run. Because I think that the reason why we have such a high over incarceration rate in the state of Maryland, I mean, I find out so outlandish, I can't even talk about it because Maryland doesn't have the highest criminal rate. We don't have, our young Black males who are more criminally inclined than any other state in the country, yet we have the highest incarceration rate of our young Black males. We have a population of around 30%, and yet of Black people, yet our prison population is 70%. And the Justice Policy Institute says that we have the widest margin between our population and our prison population than any other state in the country. All these problems, to me, stem from the fact that the people who get elected, whether they're Black, white, purple, they just do not have a diversity of thought. I know we talk a lot about diversity of color, diversity of this and that and the other, but I think diversity of thought really needs mentioning. For instance, when Thurgood Marshall was replaced on the Supreme Court by Clarence Thomas, and when Justice Ruth Bader Ginsburg was replaced on the Supreme Court by Amy Coney Barrett, nobody said that we needed to change anything, yet everybody was saying, oh my goodness, there's going to be a huge change just based on those things alone. So we don't need just diversity for diversity's sake. We also need people who are going to go in there and actually find out, well, why is it that these things are happening? Because they're hurting the people in our community. I'm the mother of 2 young Black males and a young Black woman, and so the idea that, to me, I'm living in a state where they're more likely to be in prison than if I were to move to another state. It's scary to me, and it's something that needs to be addressed by the judiciary, and that is why I'm running. I could have addressed it as a lawyer because I represent a lot of disenfranchised people, but the way to address it on a macro level is actually to be in there and to educate people. I heard that there's a bill in reference, I was listening to the testimony in reference to the bill that has to do with training. I'm a former military police officer in the Army, and so I've had implicit training. I'm a former CASA. I've had implicit training. The problem with implicit training, I could tell you right then and there, is that people will sit in the class and their eyes will glaze over if they're not interested in the topic. And so, yes, they're checked the box saying that they attended, but nothing really has changed in their mind. And we really need people who have diversity of thought to go in there and actually find out what's going on and improve the system from the inside out. I hope I responded to your question, Delegate Crutchfield.
Thank you, Ms. Pierre.
Vice Chair Atterbury, do you mind if I correct something?
Judge Barrett, no, I'm sorry. I can't let you do that, Judge.
Okay.
As you've already testified, we don't allow the back and forth once we've switched panels. I'm sorry. I'm going to go to Delegate Conaway now.
Thank you, Mr. Chairman. Thank you, committee, and people came in to testify. This is for Reverend Morris, I believe it is. Are you saying that it's partially the people's responsibility to know or have knowledge of the lawyers and the judges, to know what their statistical background is, what kind of decisions they're making? So if you look at it another kind of way, when Ms. Pierre was talking about baby judge school, in your arena, it would be like looking at the disciples of Jesus, but knowing that inside guy is Judas. Am I perceiving what you're saying correctly? Reverend Morris?
I'm not sure how to respond to that, only that.
Okay.
Yes, can you hear me?
Yes.
I said I'm not sure how to respond to that, only that I am the non-attorney on this panel, I think.
Right. Well,
and
you had said you had said that your child came to you and said they read the Bible, but you perceive that as just because you read the book doesn't mean that you have knowledge of the inner workings, basically. Would you?
Yes, sir. That is absolutely true. So that.
Thank you very much.
Go ahead. I'm sorry. Okay. Yes, that is absolutely true. That you read the book doesn't mean that you have. It's almost like leadership. Because you've gone through the leadership training doesn't mean you have the ability to actually lead people. And that's a, I think, with getting the book knowledge. My primary thing here is that there are qualified individuals that should not be. There are qualified individuals that have by who they are, I guess the essence of their character, their morals, their standards. They've demonstrated certain things prior to getting on that bench, prior to declaring their candidacy. And those are the things that we, the people, would look for. We know that there are only certain things that they will be able to say when they are running, but we should not be deprived of the right to select and elect who we choose as citizens of Maryland. And I believe that there are a number of qualified individuals, Black, brown, red, and purple, that will not have that opportunity to be on that list. I would say that A or B list that the governor would get if you were lucky enough to know the right people to be in the right places and say the right things. You're on this list and you get appointed or have these opportunities that are denied other people, other qualified, hardworking, educated, and all those other things you need to bring to the bench in our communities, that they just wouldn't have that right to do that. And I would just trust that we can do some of that vetting ourselves as citizens of this state, that we be entrusted to continue to do that, and that we not put something up that is just going to be a roadblock and continue to perpetrate, or whatever you say the word, the disproportionate things that have been occurring in the state of Maryland.
Okay, thank you, Reverend.
Thank you very much.
Something that's going to.
Thank you very much. All right, seeing no further questions for the panel, that concludes the testimony on House Bill 35. Now, where we stand is Delegate Dumais is going to present her bill, House Bill 447. We've already heard from the judges. They indicated they were testifying on both bills. If Michelle Siri is back, we'll hear from Michelle Siri and Ron Jericho as well. Also testifying in favor are Ralph Watkins and Eric Smith. If people indicated that they wanted to testify for both bills previously, I'm not going to call them again if they are on the list for unfavorable. So with that, we're going to hear from Delegate Dumais for 3 minutes. Committee, I think at this point we will, I thought we might be able to get away with not taking a break. I think we're going to be taking a break, and we're trying to figure that out here shortly. Delegate Dumais, please, for 3 minutes.
Thank you very much, Mr. Chairman, and good afternoon, colleagues. And I'm sure you are done with hearing about this issue at this stage of the game. And it's certainly an issue that I have brought to you on many occasions. I was elected for the first time in 2002. And ever since then, I have been very involved in this particular issue. I want to talk to you about it from a practicing lawyer's perspective. As many of you know, I do practice law. I practice family law in Montgomery County, actually in many counties, but primarily in Montgomery County. And the kinds of cases that I bring to the court are those where it is often two parents or a husband and wife, and it's their entire world that I am dealing with and that I am presenting to a member of the bench. If it's custody, it's a matter of who is going to have the child how much of the time. If it's a financial case, it's how much is going to be divided out of the business, how much support is somebody going to, it's incredibly personal. As a result, it is incredibly important to me that the members of the bench are highly qualified, not just qualified, highly qualified. And I know you've heard a lot about the vetting process, but I wanted to make a couple of things clear. The way the vetting process works is you fill out an application, and by the time you're done filling the application out, it's probably 40 pages long. You have had to indicate, as Judge Barry said, your criminal background, if there is any, God forbid, what cases you've handled, what appellate court cases you've handled, submit a writing sample, and submit a list of references. It's sometimes suggested, it's no big deal, it's just an interview. It is not just an interview. I have one of my partners is on the Trial Court Nominating Commission at the moment. A friend of mine was on it during all of the O'Malley years. The members of the Trial Court Nominating Commission take this incredibly seriously. Each member is assigned a candidate or several candidates to interview and investigate. You don't just interview the candidate, and you don't just interview the people that they told you to interview. You interview judges that they have been before, opposing counsel, clients. You go through the entire process. And that's done 13 times. Trial Court Nominating Commission is the last one. Do I think that the bench should be more diverse? Absolutely. But here's one of the ways that you get that done. And the Bar Association has been doing it for a long time. You mentor individuals. I don't know if anyone knows Federal Magistrate Charles Day, who is absolutely one of the most incredible individuals I've ever met in my life. And he is sponsored through the Montgomery County Bar Association and the State Bar Association. How do you become judge? Trying to mentor particularly minorities, but certainly others, to apply. What do you need to do? The Women's Bar Association, every other year at their annual meeting, holds classes. How do you become a judge? Again, for women, minority women, whatever. The question is who applies? And the Bar Association acknowledges and agrees, we have a problem getting minorities to apply. That is something we have to fix. It's not the vetting system that is the problem. Usually, like at the moment there is an opening in Montgomery County, we will probably end up with 20 people that have applied. Generally speaking, by the time you get all the way through, the Trial Court Nominating Commission is going to send anywhere between 3 and 5 names up. They don't send all 20. Judge Barbera, Chief Judge Barbera, was absolutely correct that where the politics lie tends to be at the gubernatorial appointment process.
Delegate, I need you to.
I'm done. Okay. But just if I can make one other point, I think that Judge Dugan in particular was wrong when he says that, gee, it's just a bunch of white male from big law firms. Well, that's not true. On my bench, I have a lot of state's attorneys and public defenders. And I have family law lawyers, and I have those that were sole practitioners. It's a diverse bench in Montgomery County, and we've, done everything we can to get there. It's important that judges it's different. It is just different. And for my clients, I hope that we eventually get rid of the contested judicial election process. Thank you.
All right, we're going to hear now from Michelle Siri, I think. Is she there?
She is not here, Mr. Chair.
All right. Well, let's go to Ron Jericho for another 2 minutes. Judge Jericho? For another 2 minutes.
Okay, thank you very much. Can you hear me yet? Thanks.
Yes, go ahead for 2 minutes.
Thank you very much. So I'm not going to repeat what I said before, the same things I said on the earlier bill, but there's a great financial.
Yes, go ahead for 2 minutes.
Sorry, I just need to feedback. Sorry. In order to run for judge, you've got to raise between $200,000 and $400,000, and that's a lot of money to get. And the ethical issues of getting it mostly from lawyers are very, very serious. And the politics come in the election process. In my election, for example, Governor Ehrlich endorsed the Allison Asti, did not endorse us. And as a result, when Governor Ehrlich prevailed by 54% of the vote in this county, she got carried into office. I lost by a very small percentage. So the politics is there, but it's in the election process as well. And yes, you can't get some politics out of the matter. And I think the Delegate Dumais is correct that when she says it's mostly at the vetting process that the governor's staff does, but the governor's staff also does vetting besides what goes on in the Judicial Nominating Commission. And a judge is not like any other position. The public does not understand. Judge Berry was correct that most often you get asked, what party are you with? And what's your view on this topic or that topic? And you can't say. I was very scrupulous about not saying I was a Democrat, for example. Further, when you go to public forums, I was going out every night politicking. Maybe I spoke to 10,000 people. There were 100,000 people that voted for judge. There were 200,000 people that voted for governor. And so most of the people who go to the polls do not understand. So that is part of the reason to get the out. And Delegate Dumais is exactly correct. The vetting that goes on, the application process, and what Reverend Morris talked about, getting the public to know them. Yeah, if every applicant filled out the application, and if the public got those applications, which they can't do because it's like 40 pages long, then you might have an even playing field. But politics comes into play in the election process. It's a very difficult thing to do. I really urge you to put out a favorable report on these two bills. Thank you.
Thank you very much. These are the people, well, let's see, is Ralph Watkins on the call? Ralph Watkins? All right, is Eric Smith on the call?
Watkins is joining the call.
Okay.
Good afternoon.
We need you to turn your video on, please, Mr. Watkins.
Okay, yes.
Watkins is joining the call.
And you have to turn off your YouTube in the background, otherwise you're going to get feedback. There we go. Mr. Watkins for 2 minutes.
Thank you very much, Mr. Chairman. I am speaking on behalf of the League of Women Voters of Maryland. We support HB 447. We really appreciate this bill being brought forward. And just let me touch on something that has to do with the litigant's interest. No one who is before a judge and has either money or their personal liberty at stake should be worried that the judge needs to worry about how the case will appear during the next election cycle. It is vitally important that judges be independent of political pressures. I've heard from other witnesses, there are a lot of concerns about possible abuses of the selection process. I believe that those will be far more effectively addressed through the nominating commission, the selection commission process. As you all know, it currently is a creature of the governor's executive order. I think I heard one of the delegates raise the question of, should this be put in statute? Should we set some more criteria for these selection commissions? That could be a good idea to ensure that they reflect the diversity of Maryland. And I would also note that if there's concern about the governor's abuse of their power, either based on party or on race or any other consideration. Delegate Dumay's bill includes confirmation by the Senate. So there is a really important check on the governor's power in the appointment of judges. So we hope that the committee will report this bill favorably. Thank you for your attention.
All right, thank you very much. We have Eric Smith not going to testify here, so we were ready to go for questions. Delegate Watson.
Thanks for those comments, Mr. Watkins. Delegate Dumay, I got one question for you.
Sure.
And I'm trying to figure out, I mean, you guys really make really cogent arguments. So I'm trying to figure out those people who have run against the sitting judges and won. Is there any indication that their level of expertise is below standard? And are there any metrics that can show me that by having rulings overturned or appeals sustained or those types of things? Is there anything that you can tell me to convince me that those, 2 or 3, 4 folks who've gotten through the last couple cycles have failed to perform as composed to other newly elected circuit court judges who've gone through the regular formal process?
The answer is no. I mean, to be honest, I don't know the individuals that recently won in Prince George's County, though I've heard that those women are highly qualified and wonderful. And I expect that they will be very good judges. The question is that we have to have a selection process. And you can either throw it all open to election and just, we don't need qualifications. You put your name on the ballot, you campaign, and you become a judge. Or what has been decided, and if you're, I have it in my big files, where the trial court nominating commission even came from was after a very thorough study under Governor Mandel about how do we diversify the bench and what is the best process for appointing judges. And it was that commission back in whatever it was that determined the trial court nominating commission was the best way to do that. The trial court nominating commissions, generally speaking, have 13 people. They are not all appointed by a governor. There's a certain number that's appointed by the governor and it's the majority, but then there are others that are appointed by the county bar of whatever the jurisdiction is. The governor's appointments are usually dictated that it's lawyers, but it is also citizen members that are not members of the bench. And that's been the system we've had in place since Governor Mandel was governor. It's a question of, is there a party preference? My experience, and I again was elected for the first time in 2002 at the same time Governor Ehrlich was elected. I served for 4 years under Governor Ehrlich, 8 under Governor O'Malley, obviously now whatever number it is for Governor Hogan. And I am involved in the judicial selection process because I usually weigh in and send letters to the governor when we're at that place. But you know what? I think each of those, regardless of party, take the responsibility of appointing someone to the bench incredibly seriously, and they are looking for the most qualified. Is there some politics at play? Sure, but the only people before them are the 3 to 5 people that have been determined by 13 bar associations and the trial court nominating commission or appellate court nominating commission to be highly qualified.
I understand that, Delegate Dumay. My question is much simpler, and I
appreciate
the process. I understand and believe that there needs to be a serious vetting process. My only question is there some kind of way I, as an average citizen, can go into some kind of record and look at Judge A, who just recently got elected, and seeing that they've made a series of bad decisions and all of those have been overturned, or something negative like that has been happening in the courtroom? Because what I've heard for the last 2 hours is that there's an issue with the level of expertise and preparedness and history of working in the judiciary that is required for somebody to take the bench. And I want to see, not going through that process, what indications can I get to show me that, yes, you are indeed correct, and this is the way to go?
Okay, and there's not such a database that you're asking for. So there isn't a way to look at a current sitting judge or someone that was elected to the bench to sort of say, whatever, other than to, again, through the judicial disabilities process. So all I'm saying is that the distinction is that I'm not saying every person that ever ran to become a judge is not qualified. That is not what I'm saying. I'm simply saying that I think that the system of appointing members of the bench who I'm going to bring very difficult cases to, I want it to be someone that has gone through this vetting process. Now, I will give you an example, however, just of people that have run in Montgomery County. I think he ran twice, and I obviously will not give you his name, but there was a gentleman that ran and made a contested judicial election for a 4-year period of time, who had never practiced in Montgomery County and had actually never practiced in a state court, and was sort of a government lawyer and just sort of put his name out there. And he could self-fund his campaign. So as a result, the sitting judges had to put up quite a bit of money or raise money to be able to do that. What I eventually found out through the process about this gentleman, I actually don't think he would have made it through the system. Ms. Pierre talked about that she's been through the vetting process. She seems to think it's stacked against her. I practice in Montgomery County, and she went through the vetting process 9 times. And again, I don't think, she is a wonderful community advocate. She's done a lot of wonderful things in her career, and she's a very hard worker. But she didn't make it through the commission 9 times. I don't think it's because the people didn't appreciate her background, but after talking and doing the vetting process, decided that she didn't meet the level that they were looking for. That's hard to understand and hard to accept as an individual. I would find it hard to accept as an individual, but we have a process in place. It's a process that I think is strong and works. But it ain't perfect. We've all said that all day long. We've got judges on the bench that I sometimes wonder, how did that happen? But for the most part, I find the appointments by governors of both parties to have been really good choices, and they've been really good judges.
Thank you, Delegate DeMay.
Thank you very much. Seeing no further questions for those in favor, we thank you all very much. I'm going to go now to the 2 people who still remain who can testify now for 2 minutes, Ricky Jones and Marguerite Morris. We'll hear from the 2 of them, and then that'll conclude 4:47 after any questions. Ricky Jones, please, for 2 minutes. Ricky Jones. All right, not here. Marguerite Morris. Is joining now. So we'll hear from Marguerite Morris for 2 minutes. I don't believe Judge Dugan remains. I don't believe Mithun Banerjee remains. So we'll hear from Marguerite Morris. Okay. Ms. Morris, are you on the line? Okay. I do not see her. Being told by staff to wait. To my committees. Now I'm disappointing 2 committees. My need for patience. Okay. I'm not sure what the technical problem here is. Give it another couple seconds, but I think at this point, I do see her now. Marguerite Morris, please, for 2 minutes. Ms. Morris?
Yes, I can't. Yes, can you hold on?
Yes,
Can you
we
hear
can
me?
see, we can see and hear you. Go ahead for 2 minutes, please.
This has been an amazing day with technology. Thank you so much for allowing me back. I have not heard the testimony of anyone, but I appreciate your letting me back in. I'm here to testify. Obviously, my name is Reverend Marguerite Morris. I've already told you the organizations I'm with, and I am in from Odenton, Maryland. I'm here in opposition of 447. We know that before the mid-1800s, nearly all the states elected judges by means of gubernatorial election. And of course, in the 1830s, Mississippi was one of the first states to implement judicial elections. And then after the Civil War, most of the states, if not all the states, went to that procedure. According to the same site, which is I can't even say the site. This was attributed to a number of factors, to include the belief that judges at the local level should be accountable and responsive to their communities, and the importance of the common man's law. In other words, contested elections have been a long time tradition, and currently in judicial election methods by state, out of 147 trial courts, only 100 appoint 6 judges, only 6 appoint judges strictly by gubernatorial methods, 46 using assisted methods, and with 73 using partisan or nonpartisan election procedures. A colleague shared the following with me. She said it would be a great inequality to the community to allow circuit court judges of Maryland to be appointed only by the governor, and not allow the people to continue to have the opportunity to choose who they believe will be fair and just in their communities. The governor is currently allowed, with recommendation, to decide who should administer the rule of law to the people and communities that are Black and brown. Yet there have been no reasonable vetting processes that would encourage diversity and inclusion on the bench and many of the courts to ensure there's an adequate and diverse representation for the community. My colleague is right. There are a number of excellent attorneys in our communities, but if they don't have the right connections to get on the right list, we would miss what they could bring to the judicial system by way of fair and equitable application of Maryland laws. In the bill's appendix, it says judges at the circuit court level are the only judges in the state who may face a contested election in order to retain their appointment. And it's only in the circuit court level where an individual may become a judge without being screened and recommended by a judicial nominating commission.
Ms. Morris?
I say, yes, this is true, but I don't see I'm almost finished, sir.
Thank you.
I don't see a running list of scandal and documented concurrent. Can you hear me?
Yes, but we need you to wrap up,
It
please.
seems that the unintended purpose, sir, I'm doing that. It seems that the unintended purpose that this may serve is to prevent a disproportionate number of qualified qualified individuals from our Black and brown communities from serving us in this honorable capacity. I respectfully ask you to oppose HB 447. Thank you very much for your time and patience.
Thank you very much. Are there any questions? Seeing none, we thank you very much for your testimony today, and that concludes the testimony on House Bill 447. We're going to go now to Delegate Chi and House Bill 75. We can have.
Hi, good afternoon. Oh.
There you are. I'm sorry. Hello. We're going to.
Hi, I'm here.
For 3 minutes. That's great. 3 minutes.
Thank you very much. I would have to say I am still excited and honored to appear in front of the Judiciary.
This is your first time, I believe, in front of the Judiciary
It's my
Committee,
first
isn't it?
time, and it took me 3 sessions to get here. So thank you. Patience on both sides. I want to preface my remarks, and I'm here for the record. I'm Delegate Lily Chi here to present HB 75. I want to preface my remarks by saying I do support constitutional amendment to create a single system for all of the circuit court judges candidates, no matter what that system is. And no system is perfect, but we are here to improve it. The fact that there is such robust discussion on this super smart committee tells us that something has to change. And I'm here to make a very small proposed change. I would like to say if we have to elect the judges, then at least
all registered voters should be able to elect the judges. And instead of just the Democrats and the Republicans, as the current system is. And that is the angle of my argument. So HB 75 is a very simple bill to make our circuit court judges elections in primary election truly nonpartisan. So all registered voters could vote for them. And there are several good reasons for that. One of which is we are leaving out too many voters out of the process, not just the independents and unaffiliated, but also third-party voters. We now know the independent voters are the fastest growing voting segment in Maryland. Just for your context, between the 2016 and the 2020 presidential elections, Maryland's independent voters grew by 92,000 voters, or 14%, while in the same time period, Democrats grew by just 5%, and the Republicans grew by just 0.15%. We now have 766,000 unaffiliated voters all across Maryland in counties that are blue, red, and purple. In fact, 10 counties across Maryland now have at least 20% of their voting segments, of their voting base, that are identified as unaffiliated. So if you combine that number with another 64,000 registered voters that are third-party voters, we have an entire population of equivalent to Baltimore County, which is the third largest county in Maryland that are locked out of our primary election system, who cannot vote for circuit court judges. And that is just undemocratic. So my bill would simply make our circuit court judges elections the same as school board elections, so all registered voters can vote for them. My another argument is the independent voters are disproportionately made of immigrants, young voters, and other first-time voters who move from other states, for example, who are not familiar with the Maryland's closed primary systems. And I'm running into many of these people. And these are the very people we want to engage as voters. I, for one, when running for my first and only election in 2018, had to run a concurrent campaign just to focus on turning the Asian immigrant voters into Democrats so they could vote for me in elections that matter. But to this day, I can tell you, many of them are still party averse and they will never join political parties for all kinds of reasons. And finally, judges should be the most impartial and non-political people who rule on cases that affect all of us. Candidates for judgeship are not listed with any political party affiliations. So why are we forcing them to run in partisan elections?
Delegate Chi, we need you to wrap, please.
Okay, thank you. And on that note, I would just finish by saying that I want to address the couple of points raised by the opposition, which is it's not true that my bill is against the current vetting process. I support that. I just am saying if everyone if we're going to vote for them, then everyone should be able to vote for them. And also, my bill is simply trying to emulate the current example of the Board of Elections.
Okay.
Board elections. Thank you very much.
Thank you very much. Are there questions for Delegate Chi on this, her first time testifying before the committee? We will not traumatize you, I don't think. All right. Delegate Cox.
Thank you, Mr. Chair. Delegate Chi, welcome to Judiciary.
Thank you.
Good to see you here. Just a real quick question. So maybe I'm wrong, but isn't there a possibility at least that a judge could, or someone could file for the circuit court and not be on the primary ballot, or is that I thought the Constitution allowed anybody to file, and if they're not on the primary ballot as a party affiliated, they could still file as an independent. Is that not the case?
Apparently, I'm not a lawyer, but according to my knowledge, they do have to run in the primary elections and run in partisan primary elections right now.
Okay, it's news to me. Thank you.
Delegate Juanica Fisher, please. You're muted, Delegate Fisher.
I put my hand down instead of unmute. I apologize. Thank you, Mr. Chair. It's good to see you, Delegate. My question comes from, do you feel like our current system, with it being in the primary, is more a voter access issue? And do you have any comments on, in my view, sometimes new voters are from different diverse backgrounds. Maybe they come from an immigrant background where, partisan politics doesn't really resonate with them. Is any issue surrounding that part of the impetus of your bill, that you want it to be just in the general? If you could comment on that, that would be great.
Thank you very much. It's a great question. You are absolutely right. There is a lot of hesitancy in joining political parties, either because of where they came from, where politics failed them, and that was why they are here to begin with, or because people did not understand why they could vote for this but not that. Except for campaigns like mine that actually made a point of explaining to people the many different deadlines, the many different kind of systems, which is very super localized. It's very hard for people from other states and other countries to keep up with our shifting primary election dates, first of all, and just different states' systems, especially for first-time voters like young people and immigrants. So I think primary election, the way it is right now in Maryland, is increasingly less reflective of the demographics that are shifting in the past quarter century of the state of Maryland. So I think whatever we need to do to be more engaging and making our system more accessible to more voters, giving them more reasons to go to the polls is important.
Delegate McComas.
Thank you, Mr. Chair. This is just for Delegate, is it Q?
G.
G. You said that the Asian community doesn't want to affiliate with parties. And I just wondered why that was, because obviously that would decrease their participation in elections.
Yeah, it's not just the Asian American communities. In my response to Delegate Fisher's question, it's the prevalent issue among immigrant communities, either because of their cultural differences, and in many countries there were no political debates or elections and things like that. So it was a very hierarchical top-down kind of political system. So democracy was new to a lot of people, And then you ask them to differentiate between different political parties without making a case. And neither party has done a very good job reaching out to these new voters to explain why you should be a Republican, why you should be a Democrat, And for many of them, that's just too much work. They have their lives to live. And that's just not the kind of nuances they are paying attention to at this point of their life. And some of them just have bad political baggages, the images of political parties that give them nightmares, for all kinds of reasons.
Well, I guess what we would all be concerned about is that whether it's partisan or nonpartisan, that the voters would understand who they're voting for and could make a good reasoned decision as to which person would be better to sit on the bench. So I'm wondering, do you feel if it was nonpartisan that the public, that the immigrant communities would understand and get a better idea who these people are, because they're not going to have the advantage of having Republican and Democratic parties behind the different candidates for judicial office, and at least there's a mechanism there for people to become more informed, I think, than if it's a nonpartisan race.
That's another very good question. I would say if we are electing political offices like politicians, then it makes sense. And the people will have to register for this and that, right? Although I also have reservations on that front. But it would make more sense to be able to vote for politicians than you need to register with a political party. But I think electing judges itself is an entirely different game. And also, just because they're immigrants and speak English as a second language does not mean they have less ability to make good judgment who should represent them. In fact, I know modern day immigrants are largely knowledge workers.
And many of them are highly educated, and they are highly analytical, and they want to remain independent in order to be able to vote for the best candidates rather than going with the party line. And I know many of them are intentional in that kind of position.
So you feel that they would be able to search out the necessary information to make a good decision?
Yes,
if
yes,
it's nonpartisan?
absolutely.
Okay.
Especially if it's online. Yes.
Oh, okay. Thank you.
All right, from the Ways and Means Committee, Delegate Lasanti, please.
Yeah.
There we go. Thank you, Mr. Chairman. I appreciate that. And Delegate, thank you for bringing this bill. And I do appreciate what you're trying to do, but I'm a little confused as to how this is implemented. Because in a primary election, which in a way, I think the term primary election is a misnomer, because the way Maryland's elections are established, a primary election is actually a nominating process for a political party. So having said that, if you're successful, it basically says that only for the office of circuit court judge would that position would be on the ballot for Democrats, Republicans, and as we know, currently unaffiliates are not permitted to vote in the primary election because
they are permitted to vote, but they are not permitted to vote for
the correct.
Yeah.
So how, I mean, does it make sense for your bill to really occur in the general election?
Yeah, that's a very good point. In fact, Chair Klimpinger actually was kind of promoting that idea before my bill's turn, and I appreciate that. I think administratively, if that can work out, it actually would be a good idea. I think you hit the nail on the head. The whole idea, the spirit of this bill is not necessarily, let's make sure everybody can vote in the primary. It's let's make sure everybody can vote.
Sure, because in primaries, it's generally, I mean, as we know, it's more or less the people that are more affiliated or more connected with a political party versus in a general election when it really truly we tend to see many more people come to the polls in a general election.
That's right. That's right.
Okay.
The only caveat is people who go to the polls in the primary tend to pay more attention to in terms of differentiating among the candidates because it's a nomination process. The larger universe of people who go to the general election. Yeah.
Right. Well, I know in the recent election that we had in Hartford County, it was very confusing for a lot of people when people were on multiple ballots, and it just caused a lot of confusion. So just bear that in mind.
Yeah.
Thank you.
Thank you.
All right. As my name was mentioned, yes, I mentioned my questions to the Chief Judge previously in one of the previous bills. That I kind of have a question as to whether we need to have judicial elections in the primary election at all, and somewhat consistent with what you were proposing in this bill and saying that they should be nonpartisan elections. One way of doing that is just to move it all to the general election and have people just run in the general election. But we'll see. We'll take this bill up in the committee, and we have one to testify, but thank you very much, Delegate Chi.
Thank you. And I just want to say state of Florida has exactly the same system as Maryland, but they do allow all voters to vote judges, just like the school board members in the primary, just for your
reference. Well, thank you very much for that.
Thank you.
We have one more person to testify, and that's Ron Jericho, who is to testify in an informational capacity. Judge Jericho. See here again, not here. Okay, I think we did hear from him on the previous bills. I think he spoke with them, and that's all right. That's going to conclude the testimony for House Bill 75. We thank you very much again, Delegate Chi, and congratulations for making it through what was described at one point, I think, as a star chamber of the Judiciary Committee. Congratulations. Let's go now to Delegate Atterbury, who has a panel. Delegate Atterbury, all right, and for the committee, we are not going to take a break. We are going to keep going, and we're going to just go ahead and try and get through the remaining 5 bills on our docket. Delegate Atterbury for 3 minutes. Robin Stimson, Alex Audie, Christine Nizer will testify with her, and then we'll hear from everybody else. So Delegate Atterbury for 3 minutes, please.
Thank you, Mr. Chair and members of the committee. Good evening. I'm Delegate Vanessa Atterbury, and I'm here asking for a favorable report on House Bill 749. I think this is the perhaps 3rd year I've brought this piece of legislation, and I'm going to let my panel really explain it, but essentially what the legislation does is require an individual who is granted a probation before judgment for driving while under the influence of alcohol or under the influence of alcohol per se, including offenses where you're transporting a minor, and an individual who's convicted of or granted a PBJ for driving while impaired by alcohol, including for offenses committed while transporting a minor, to participate in the interlock system. So in Maryland, the majority of drunk drivers end up on probation before judgment or PBJ at their first arrest. Upon their second arrest is when they're usually convicted of drunk driving. Some of you were here when we passed NOAA's laws a few years back, which closed the gap between probation before judgment and conviction by requiring drunk drivers to complete 180 days on an interlock as a condition of probation. Some may ask, is this a problem? And the answer is yes. In 2019, there were about 3,100 PBJs for driving under the influence and 3,600 for driving while impaired by alcohol. And these numbers have been consistent generally from year to year, which means about 6,000 to 7,000 Marylanders will likely go to reoffend and then finally get convicted and then finally get put on an interlock. And statistics show that when you're on an interlock, that reduces recidivism and that saves lives. Last year, I want to get right to the point. Last year, there was much to do made about the cost of the interlock, particularly from Delegate Fisher. So this year, there are folks here to testify about a fee waiver program that can be utilized by folks who can't afford the interlock program. The average cost you'll hear range from $75 to $100, but what you'll also hear is fees can be waived if you qualify for certain financial needs in the state of Maryland, like SSI, Maryland Medical Assistance, Emergency to Families. There's a form you can fill out. It is put on the website, and actually MBA will waive the enrollment fee for participants who meet those requirements as well. And so those individuals can get up to 50% of their interlock fees waived. And with that, Mr. Chair, I will turn it over to my panel and just ask that this year the committee consider this piece of legislation seriously, because as we know, taking drunk drivers off the roads saves the lives of families in particular, which is why I'm very passionate about this piece of legislation. And I want to thank all my panel members for being here year after year and working really hard to try to get this passed. So thank you very much. Thank you.
Thank you very much, Vice Chair. Thank you very much. We'll go now to Robin Stimson, who will be asked to testify for 2 minutes now. Ms. Stimson, are you on the line?
I am. I'm right here.
All right, go ahead for 2 minutes, please.
Good evening. Thank you, Mr. Chairman and members of the committee, for allowing me to testify in favor of House Bill 749. My name is Robin Stimson. I'm the manager of victim services with Mothers Against Drunk Driving. MAD thanks you, Delegate Vice Chair Atterbury, for sponsoring this critical and essential piece of legislation. You'll likely hear and have heard many stats and numbers today. It is my hope after this testimony that you remember just 3 numbers: 100, 0, and 1. 100, because the crime of drunk driving is 100% preventable. 0, because the only number that matters at MAD is 0. 0 deaths, 0 injuries, 0 families impacted by impaired driving crashes, which brings me to my last number of 1. One more victim of this crime is too many. House Bill 749 ensures that the intent behind the 2016 Drunk Driving Reduction Act, also known as Noah's Law, is followed. Noah's Law made Maryland one of 34 states plus the District of Columbia to have in place an all-offender ignition interlock law. However, plea agreements or probations before judgment have allowed offenders to avoid using this life-saving device. All drunk drivers should be required to use an ignition interlock for a period of 6 months in order to drive after a drunk driving arrest. My role as a proponent for victims' rights has provided me the honor of supporting the survivors who have lost a loved one or have been injured as a result of these horrific crimes. Victims come from different backgrounds and stations in life, but they have one thing in common. None of them ever want another person to suffer the pain and loss they have as a result of an individual's poor choices. It is my privilege to advocate for them and walk with them on their path towards healing, and that includes my presence here today. Ignition interlock devices are life-saving. They are the most effective tool we have to keep our roadways safe while providing the true second chance for offenders to allow them to maintain their independence and obligations. House Bill 749 addresses the 100, 0, and 1 numbers I just mentioned. MAD sincerely thanks you for your time and attention, and I'm happy to discuss any of the above data if the committee would like more information. Thank you.
Thank you very much. If we could hear from Alex Audie now, please, for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, and members of the committee for allowing me to testify today in support of House Bill 749. My name is Alex Audie, and I am the National President of Mothers Against Drunk Driving. When I was 13 years old, I was run over by a drunk boater. I was sitting on a jet ski behind my dad's house on Lake Harrington in Danville, Kentucky. I had been on the water and had my boating license for years prior to this. I was sitting across the narrow lake about 40 yards from my mom and brother as they were docking our boat. I was waiting for them to finish docking the boat so that I could dock the jet ski and we could go up to the house. There was a 17-foot bass boat coming under a nearby blue bridge. I gave my mom a thumbs up to tell her that I saw him coming and I wasn't going to move. The boat was headed towards my mom and my brother. My mom screamed. The boat banked to the left and never straightened up. He hit me from the side going over 60 miles per hour, threw me off the jet ski. The boat went up over the jet ski and came down on top of my body. I sustained very severe injuries, including a traumatic brain injury classified as shaken baby syndrome. I suffered a broken jaw, a broken neck, a broken collarbone, and bilateral shattered femurs. When the boat came down on top of me, the propeller landed on my legs. My left leg was under the water just enough that it only required stitches, but my right leg was severed by the propeller. The man who ran me over was 3 times over the legal limit 2.5 hours later. He was charged $250 and left to go out to continue to reoffend on the water and in the roadway. I had 8 emergency surgeries in the first 7 days and so many more in the years since. I spent a week in a coma, several weeks in the ICU, a month in a neck brace, and several months in a wheelchair. To no fault of my own, this was my new life. The only thing that would have changed that crash is if he hadn't been drunk. House Bill 749 would put life-saving ignition interlocks in the cars of drunk drivers who are granted probation before judgment. Mothers Against Drunk Driving, and myself personally, support this legislation as it is an improvement to the impaired driving law and will hold accountable those who make this deadly choice. Mr. Chairman, Madam Vice Chair, and members of the committee, MAD urges you to please advance House Bill 749. Thank you for having me.
Thank you very much. Christine Nizer, please.
Good afternoon, Mr. Chairman, Vice Chairman, and members of the committee. For the record, my name is Christine Nizer. I'm the MDOT Administrator, and I also serve as the Governor's Highway Safety Representative. At the Maryland Department of Transportation, we are squarely focused on our goal of reaching 0 fatalities on our roadways. We believe that is a multi-pronged effort, which includes legislation such as we're considering today, and the Noah's Law that you passed several years ago. And I thank the legislature for the leadership you provided in that regard. But we're also looking at other ways in terms of our strategic highway safety plan and the impaired driving working group that's part of that effort, as well as technology like the driver alcohol detection systems for safety that we've actually installed on our own fleet vehicles, which prevents a vehicle from being started if there's alcohol in the breath. This is a serious issue, as Vice Chair Atterbury identified, with on average 3,100 injuries and 163 fatalities in Maryland every year. You just heard personally one of those stories. Unfortunately, there are way too many of those families that I've gotten to know over the years. That pain never leaves, and whether it's something that you physically have to live with or a loved one who's no longer there, it is a tragedy that stays with them forever. We believe this legislation can save lives. Ignition interlock is not about punishment. It truly is about behavior modification. We know that the average drunk driver has driven impaired many times before they have that arrest. So while that PBJ might be considered a first offense, in reality, we know they've been on the roadways and a danger to the public many times driving impaired. This legislation would add about 5,900 individuals to the Ignition Interlock program every year. It's important to know that the program works, it's effective. So we stopped 3,100 attempts by individuals to start a vehicle above 0.08. They were drunk and trying to drive, but because of that ignition interlock device, we stopped them from being out on the roadways with your friends and family members. So we know that it works, it stops that drunk driving, helps change behavior to get people on the right path, still allowing them to drive, but to do so safely. And so therefore we support this bill. We ask the committee for your favorable consideration, and I'll be happy to answer any questions at the appropriate time.
Thank you very much. Are there questions for the panel? Delegate Juanita Fisher.
Thank you, Mr. Chair, and thank you, Madam Vice Chair, for bringing this legislation forward. I'm not sure if this panel is the best one for this question or it would be for subsequent panels, but do you have any data about, and my question really has to deal with the cost and the racial breakdown. And as Delegate Atterbury referred to, I had concerns about costs last year. You know, out of the DUIs that are first-time offenders, do you all know the data of how many are African-American, how many Latino, and how many are Asian? And then out of that, the companies in Maryland that are certified for doing interlock, how many of those are minority owned or have minority ownership? And the reason why I bring up these questions is that it's really about who's spending money on the interlock and who is making money off of the interlock. And I think that really needs to be parsed out, because to me, if it's all about, you know, you're going to have first-time offenders have a mandatory interlock regardless of what a judge and the prosecutor and the attorney in the case want to do, then I don't think it should be around money. And so I think if anyone had the data for, like, especially the last 5 years of out of the 5,900 people you said would be added, what is their racial background? And is there any minority ownership at all of the certified companies that do the interlock in Maryland? And I believe there's only 4 or 5 that are certified by the MVA to do that interlock. That would be great.
Go ahead. I don't know if this is the best panel. I don't know if you have any information related to that, Ms. Nizer.
So I'll answer part of Delegate Fisher's question. There actually are now 8 ignition interlock providers that are certified in Maryland. We can go back and try to break down the demographic information as best we can for an average year and see what we can get you. I'd be happy to do that. I did want to speak a little bit to the cost, because I know you did bring up this issue last year. We made it much more prominent on the website that people can see where they can get that form that Vice Chair Atterbury referred to in terms of the indigent provision. And also we do have the ability to waive that restricted license fee. That's MVA's fee. Obviously, that's the only piece that we can control. We do require the vendors to report back to us in terms of what they do in terms of reduced cost. They're required to report that on an annual basis to us. And frankly, we are open to the legislature, you know, putting forward additional policy suggestions about what that indigent piece should look like. You know, we share your concern. We want this not to be a financial issue, but it's a driver safety issue for us. So if the legislature certainly was interested in making recommendations about how those costs should be better borne, we certainly are open to those suggestions, but I'd be happy to research some of the other questions you asked.
That would be great, especially if it's now 8 companies. I think the minority ownership of those 8 companies as well, I think would be very interesting to this committee, and where those companies actually are from and if they are Maryland companies.
Yeah, most of them are national companies that operate throughout the country, but we can certainly find out where their home base is for you.
Thank you. Are there any other questions for this panel? All right, seeing none, we thank you all very much for being here. We'll go ahead and call the other people who have signed up to testify in favor of the legislation. Chris Swanger, Frank Harris, Kurt Erickson, Richard Liotta, Arlene Rosenbusch, and Philip Dacey. I see Chris Swanger. Mr. Swanger?
Yes.
All
Hi,
right,
Chairman.
there you are. If you'd like to begin for 2 minutes, please.
Great, thank you. My name is Chris Swanger. I'm the president and CEO of the Distilled Spirits Council of the United States and responsibility.org. And I represent many of the leaders in the distilled spirits industry, and responsibility.org has been on point in doing everything we can to eliminate drunk driving, underage drinking, and promoting responsible consumption. Our Discus and responsibility.org 1000% support the passage of HB 749. Just on a human level, this legislation is going to save lives. When I got this job 2 or 3 years ago, 2.5 years ago, one of the first people that I got to listen to was Rich Liotta, who is Noah Liotta's son, who was tragically killed in an accident that took place on December 10th, 2015. And we thank the Maryland legislature for passing Noah's Law back in 2016, but there's a loophole, and ignition interlocks will help those individuals that may have an alcohol problem or repeat offenders, as the other panelists have said. It will protect those repeat offenders, and most importantly, it's going to protect safe people on the roads. So we strongly, I just say, please pass this legislation. Mr. Rich Liotta is a patriot. He has suffered greatly, and we've seen and heard stories of other drunk driving victims, and we just implore you to think about passing it, as soon as you can, because ultimately this is going to save lives, and we appreciate the committee's consideration.
All right, Frank Harris, please.
Hi, thank you, Mr. Chairman, members of the committee. My name is Frank Harris. I'm the Director of State Government Affairs for Mothers Against Drunk Driving. And before I go into my testimony, Delegate Fisher, we'd like to provide you with information because today MAD testified in Congress just above the racial disparities and as well as the over-policing of communities of color. Because the data, at least outside of Maryland, it doesn't lie that this is a problem. And there are some innovative solutions that are going on that I'd like to circle back with you. But MAD's always been about innovative solutions and doing what the data says works to stop drunk driving. And when we first started supporting ignition interlocks, it goes back to 2006. And the reason why we came out in support of ignition interlocks is because prior to 2006, what we were doing simply was not working to stop drunk driving. So in 2006, MAD launched a campaign to eliminate drunk driving. The key focus in state legislatures is advocating for all offender ignition interlock laws, which we finally got with Noah's Law. But like with laws like Noah's Law, there are loopholes. The biggest one in Maryland is the fact that folks can get PBJs and therefore avoid an ignition interlock. And this is very problematic in MAD's eyes. MAD is big supporters of the ignition interlocks because they work to stop drunk driving. It's the only tool available that can physically separate a drinking driver from driving a vehicle. And the studies point to their effectiveness over the last 15 years of MAD support for these devices. It's over the last 15 years, we've actually over the last 13 years, we've reached out to these interlock companies. And we found that these devices stopped over 26 million attempts to drink and drive, including over 3.4 million attempts to drive drunk with a 0.08 or BAC or greater throughout the country. That is a remarkable number of attempts to drink and drive that have been taken off the road, which simply is not happening right now when PBJ is granted with just license suspension. And this reduction in drunk driving deaths in drunk driving that's occurred, it's been seen with the data, and you got to follow the data. Over the last 13 years, drunk driving deaths in our country have dropped by 25%, and this outpaces the overall traffic fatality reduction, which is only 15%. But still, there's a long way to go because over 10,000 people die a year in drunk driving crashes, and we got to do everything.
Mr. Harris,
So I would just say, sorry, Mr. Chairman, just please advance this bill. It's a smart on crime approach to stop drunk driving. It sets PBJ participants up so they succeed and don't become repeat offenders. So thank you, Mr. Chairman. Please advance this bill.
Thank you very much. We'll go now to Kurt Erickson, please.
Mr. Chairman, my name is Kurt Erickson. I serve as president of the nonprofit Washington Regional Alcohol Program, which is a Maryland nonprofit formed in 1982 to fight drunk driving and underage drinking. You have our written testimony. You've already heard actually what the bill does. Let me just speak a little bit to the need for it. According to the MBA's just released Maryland Ignition Interlock Program's 2020 status report, which just came out last week, nearly half, 40.4% of persons adjudicated for either a DUI or a DWI in Maryland in 2019 were granted probation in the form of probation before judgment, and therefore not subject to the full universe of public protections, namely participation in the state's proven effective Ignition Interlock program. Inasmuch, House Bill 749 looks to simply ensure public safety along that route used by nearly half of persons arrested for drunk driving in Maryland by subjecting all 21902A or 21902B offenders to Maryland's Interlock program as a condition of probation. National Highway Traffic Safety Administration data shows that interlocks typically are used as a condition of probation for DWI offenders to prevent them from driving while impaired by alcohol after their driver's licenses have been reinstated. In closing, and in a state with nearly a third of all traffic fatalities still to this day involve drunk drivers, not using Maryland's existing and offender-paid interlock program for the full universe of DUI and DWI offenders in the state is at best not using every tool in Maryland's toolbox to prevent drunk driving. At worst, it's potentially deadly, as 2019 also bore witness to Maryland posting a nearly 30% increase in the number of alcohol-impaired traffic fatalities that year. So as a means of both more effectively monitoring a drunk driver's probation period in Maryland and strengthening NOAA's law, we respectfully ask for your consideration of favorably reporting this life-saving legislation. Thank you.
Thank you very much. We're going to go now to Mr. Liotta.
Strengthening NOAA's law, we respectfully
Mr. Liotta, you're going to need to turn off the
life-saving legislation.
You're going to need to turn the YouTube link and keep up the Zoom link.
Can you hear me?
Strengthening NOAA's law, we respectfully
Mr. Liotta, you're going to need to turn off the
Let's see the
YouTube link and keep up the Zoom link.
Can you hear me? Let me try this.
Turn off the
Let's see the
YouTube link.
do I have a YouTube? Turn this off. Let me try this.
Turn off the Mr. Liotta, you're going to need to turn off the live feed and keep the Zoom link on.
Can you hear me?
Yes. You're going to need to turn off the live feed and keep the Zoom link on.
Turn off the live feed and keep the Zoom link on. All right, let's see if we can do that. Can you hear me? I can hear you. Speaker set up. All right, let's see if we can do that. Live YouTube. I can hear you.
Close that window.
I'm going to close this window. Let me close it somehow. Let's see how I get out of this. Live YouTube. Am I there still?
You're here still.
All right. Is that better?
A lot better.
Okay. I don't see anything, so I'm just talking right now. Okay.
All right. That's fine. You're going to talk for 2 minutes.
That's fine. Look, I've heard, and you've heard all the statistics and so forth. And we know the goodness of the interlock. And basically, I don't want to go and rehash that. I know you've been here a long time. I've been watching you all day long. So anyways, just what I wanted to say is, look, Noah's Law was put into place after my son basically, he was out there and he was trying to protect us from the exact same crime that killed him. And so Noah's Law went into place in 2016. And the law was intended to be an all offender protection for the public, where all offenders that were convicted of drunk driving would get an interlock. However, because of the aspect of a PBJ, essentially, we're finding that that is not the case, because those that get a PBJ 59% of the time typically are not given an interlock. So there's a number of people who are not being afforded a simple tool that can save lives and also save their lives. All we're trying to do here is save lives. We're trying to continue Noah's legacy as well as that of all the victims of drunk driving. We can't bring them back, but we can make a difference. We can save lives. Interlocks do that. You heard the statistics on that. 67% don't repeat, and it reduces fatalities by 16%. Those are big numbers. So if we capture that additional 59%, we're going to save lives. That's what it's all about, saving lives. And clearly, any cost should be appropriate for saving lives. That's what this is all about. Noah was out there trying to make a difference. So let's just keep Noah on patrol and make sure that we have everything in place with the interlock, that when people are given leniency for a PBJ, that they will get the interlock so they can change their behavior and won't repeat.
Thank you very much, Mr. Leota. We're going now to Arlene Rosenbush now for 2 minutes. Ms. Rosenbush.
Thank you very much, Chairman. I'm here because unfortunately my sister and her husband were killed by a drunk driver on October 31st, 2015. They were expert bicycle riders. They followed all the rules, were very colorful. They rode a tandem bike, so they stood out. But a drunk driver came up behind them and killed them instantly. The woman was a 62-year-old alcoholic. She had been drinking at home, and she had gotten in her car to drive over to her grandchildren's house to help with Halloween, ironically. And she had so much alcohol, she had a 0.12 blood alcohol level. There was nobody on the road. It was a small country road that my sister and her husband were very familiar with. And it was bright. There was no reason she shouldn't have seen them, but because she was drunk, she says she did not see them, and she hit them and killed them. My goal here is to get this bill passed. I have been testifying every year along with all the other people on this panel, and I really want to see this passed because I don't want anybody to go through what I have gone through and the heartbreak and my family and friends have gone through. I think about their death every single day, and it's so disheartening to feel like we have to work every year to get this bill passed, and more people are dying unnecessarily. This is preventable, and I'll tell you what's more expensive than the interlock: going to jail like this woman did for 2 years. She couldn't work for 2 years. That's a lot of loss in income. She also had to hire expensive attorneys, and she was sued. So that is a lot more expensive, and I don't want to see anybody penalized, but you know, this will save their lives too, the offenders. And I thank you, and I ask for a favorable report for HB 749. Thank you for hearing me out.
Thank you. Philip Dacey, please.
Thank you, Mr. Chairman. I'm here on behalf of the Maryland Department of Transportation, just as a resource for questions, should there be questions in support of the bill. So thank you.
Are there questions for the bill? Questions for the panel, I should say. Seeing no questions for the panel, we do appreciate that you spent the day with us, and we appreciate your testimony, and thank you very, very much. We're going to go to the opponents of the legislation now. We have Charles Murray and Thomas Moronic. Waiting to see who gets here first. Mr. Moronic, can you hear me?
Yes, indeed. I am pulling over so I can be safe as I talk about this bill. This is I am on the Eastern Shore right now, where I have court tomorrow in Snow Hill. This bill is a well-intentioned bill that has a lot of poison pills to it. And let me explain why that is. Basically, what it will mean is that a judge who has the right to decide under current law whether an interlock is appropriate, a judge can make a decision as to whether a case is such that it deserves the interlock because the facts are sufficiently serious. And I think all of you who are considering this on the panel, you would agree a 0.16 car accident, something that's very serious, that's a different story than a 0.08 DUI where someone swerved a little bit, they were pulled over, polite, cooperative with the officer, just failed on some tests. The problem is you're taking that out of a judge's hands if you were to give this bill a favorable report. And the problem with that is that's what the separation of our legislature and the judiciary is for. It's so judges can make a decision and decide what is right in a certain circumstance. The other thing that I think is very, very important, consider truck drivers who have a commercial driver's license. If they get a probation before judgment to the A charge, okay, they will have a 1-year mandatory suspension of their commercial driver's license. What you are doing is you're saying the truck driver who, let's say they get a PBJ to the B, the 21902B, and are able to continue working despite one mistake on their record for which they've taken alcohol classes, done a lot of great things. You're saying this is your guarantee you're not going to be able to work anymore. And that's what, unfortunately, this bill does. Now, as far as the interlock, it does have some problems. It's not perfect. But so I'm not here to say interlocks never work. But I will say this, it's a tremendous cost. And what about the person who the only way they'd be able to drive is by having the interlock, yet they don't even have their own car? What about the situation where somebody has a DUI and it's their father's car, their mother's car?
Mr.
They're
Moronic,
then going to put the interlock in.
we need to have you wrap up, please.
I appreciate your time, ladies and gentlemen. I appreciate, Mr. Chairman, the chance to speak. I urge an unfavorable report on this bill.
Thank you very much. Charles Murray now for 2 minutes. Mr. Murray? I see him on, I see his video off. I see he's muted. Charles Murray, there you are. Go ahead. For 2 minutes, you're going to need to unmute yourself.
Thank you. Sorry about that. So my name's Charles Murray, and I'm here in opposition to the bill. I speak not from an organization, but from the actual human component. I've been in the program, and I just wanted to kind of speak to that aspect of it because I do believe that the Interlock program is a good program, and I believe it's necessary. I just feel that it needs to be improved with some common sense acknowledgments around the technology and the process, and put some things in place to sort of address those concerns as logically as possible. I think that in this day and age, and with where we are as a society, there's a lot of things we can do to sort of alleviate just some of the, I guess, blind applications of the law. And so my opposition is not to the Interlock program, but to the mandate itself. And I think that the program works, but I think that, it's obviously it's not perfect. And I'm sorry, my screen went blank. So I don't believe that relying on technology is the way to go either. There's going to be faults, and I'm a very specific case in which I fought tooth and nail because my device malfunctioned with LifeSafer and both with Guardian. And I had video evidence, I had written evidence, I had a state trooper stand with me and witness the device malfunction and testify on my behalf. So to say that these devices are not without fault is simply untrue. And to that point, I mean, if that technology was unsafe or if it was perfect, toothpaste, mouthwash, bread, donuts, bagels, and tomato sauce are all listed in your introductory video as things to avoid. If false positives were not an option, then they wouldn't tell you about them. So I feel that right there in and of itself, there's, the possibility of false readings are laid out from the beginning. I spent 18 months in the Interlock program, of which 15 I did so willingly, and the additional 3 were for me quite literally fighting to keep out of jail, because had this mandate been in place, the malfunction would have automatically sent me to jail. And I'm 43 years old. I'm married. I have 2 children. I have 2 businesses. I have kids.
Mr. Murray, we need you to begin to wrap up, please. Can the committee hear me? All right, thank you. Thank you, Mr. Murray. Are there questions for the panel? Seeing none, we thank you very much. That's going to conclude the testimony on House Bill 749. We now have Delegate Queen, who is with us. Delegate Queen. We're going to hear House Bill 773. We have Delegate Queen and Daniel Nish, who are going to testify in favor. We'll go ahead and give 3 minutes and 2 minutes, and that'll be fine. So Delegate Queen, if you'd like to begin for 3 minutes, that'd be great.
All right, thank you. Thank you, Chairman Clippinger, Vice Chair Atterbury, and members of the Judiciary Committee. You guys are troopers, so I really thank you for your time this evening. This bill, HB 773, you actually heard last session, and you passed it out of committee, and it passed out of the House floor. So we didn't get a vote in the Senate. And so I'm asking you again to consider this bill. It's basically a study of the use of technology in firearms to mitigate unintentional consequences of lost, stolen, or improperly locked firearms. And so the study just looks at the feasibility of the technology, what's the best type of technology available, and what would be most suitable. It's really targeted for retailers to track their inventory and prosecutors to help them with prosecuting lost or stolen guns. And so it's really a safety measure to help us with using technology. It's not new to use technology for tracking. We use it for many things. Your phone is one. You can find your phone. People put them technology in to find their pets and other things that we find that is valuable. So we hope that you will, again, consider this bill favorably, and we look forward to passing this bill. Thank you.
All right, thank you very much. It's not NICH, it's NIEH. Would you please say your name, please, sir? Because I will not do your last name justice.
Absolutely. Thank you, Mr. Chairman. My name is Daniel Nia, and I hereby represent Trust Technologies. And we are favorable for House Bill 773. For the past 3 years, our company has been developing a firearm safety technology that allows law enforcers to manage and disable their own fleets of firearms when lost or stolen. And in addition, the same technology can prevent 83% of mass shootings nationwide. And the technology we provide does not change the functionality, user experience, aesthetics, and reliability of conventional firearms. The device will be embedded in firearms during manufacturing process, and it can be used in law enforcement, military, and civilian applications without any modifications. Most importantly, we can achieve all of the aforementioned without any interference with Second Amendment rights. So our company will continue to develop and work with Delegate Queen's office to provide pilot programs for the police departments in the Maryland counties. Thank you.
All right. Are there questions for this panel? Delegate Conway is raising his hand.
Yes. Thank you, Mr. Chairman. Thank you, thank you, Delegate, for bringing this. Mr. Lehigh, how do you say your name?
Nia.
Yeah,
Yeah,
okay.
you can call me Daniel. That's fine.
Okay, Mr. Daniel. So is this technology Wi-Fi or something like that?
So the technology that we utilize is through wireless communication, can be achieved through cellular data or GSM, which is commonly used in cell phones nowadays. And we can confirm that the proposal from Delegate Queen on the technology aspect is completely mature, as it has been in existence for more than 2 decades now.
Can this technology be hacked, to your knowledge?
Absolutely, it can be hacked, but however, with our algorithm, we can prevent, our algorithm specially developed can prevent firearm, for example, law enforcers' usage or interference with it, so it can operate in all circumstances when hacked as well.
Thank you very much.
Delegate Griffith.
Thank you, Mr. Chair. Thank you, Mr. Daniel. Quick question. You mentioned that this technology can be used to disable a lost or stolen firearm by law enforcement. Does that mean it can be used to disable a private citizen's weapon?
No, it cannot be. So
why?
So the technology that we provide only allows the owners of the firearm to manage their own weapon. So in this case, for example, with police officers or law enforcers, the owners of those firearms essentially is the police department that purchased them. So police departments have the ability to manage and disable their own firearms, but not privately owned firearms.
Does your company have the ability to disable the firearms?
We do not.
And you said it can be hacked, though.
It can be hacked, but anything in regards to technology can be hacked. And our response to that is not to be naive and to tell you that it won't be hacked, absolutely, but rather it's about how we implement the methodologies when they get hacked. And we have full confidence that when they get hacked, law enforcers will and can operate their own firearms under all circumstances.
Well, why do you feel that way?
Because so for example, if the firearm were to be hacked and our system recognized that the firearm is registered as a police firearm, then it would do no effect on the firearm's end to lock or disable the firearm. If that makes sense.
Thank you.
Thank you.
Delegate Cox.
Thank you, Mr. Chairman. Thank you, Mr. Ney. I had stepped away just for a brief moment. I wanted to find out what was the company, what is the company you work for?
The company that I work for is called Trust Technologies, TRUSS.
Is that correct?
Excuse me? I think I lost you there.
Yeah, you need to ask your question again, Delegate Cox.
I'm sorry, Trust Technologies, TRUSS?
That's correct.
And is that an LLC or what, do you know?
It's in Delaware Incorporation.
And is that privately owned?
Right.
Are you the owner or is there a group, who's the owners?
I'm the founder.
Okay, well, congratulations to you.
Thank you. Thank you, Delegate Cox.
And I just wanted to dovetail on Delegate Griffith's questions. And when you say this could be hacked, what's has it been put through any test anywhere to see the rate of security that it might have?
Absolutely. So, our implementation with system security in regards to those firearms is through diversification. And for example, if you would imagine, all of the firearms are not centralized in a single location. So in cases where it's hacked, hackers will have to, and in very rare possibilities based on our development and testings that we have right now, in very rare occasions when those firearms are hacked, hackers need to hack the firearms individually compared to collectively and have the entire department's firearm to be disabled. And even if they hack into a a firearm or a police department, they still won't achieve the disable functionality on the firearms. So under circumstances when it's hacked, it's still usable with police firearms.
Okay, thank you. I'll continue to look at the information.
Absolutely. And Delegate Queen have all of our contact information. So if you would like, please feel free to reach out to her and we can get in touch.
Thank you. Are there further questions for the panel? Seeing none, thank you very much. And now we'll go to those in opposition to the bill, John Jocelyn and Mark Pennock. Looking to see either John Jocelyn or Mark Pennock. Going once. There's John Jocelyn. Mr. Jocelyn, there you are. If you'd like to speak for 2 minutes, that'd be great.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. We don't object if law enforcement wants to adopt these devices. We don't object if a private citizen chooses to do so on their own. However, it's very clear.
Jocelyn?
Sir.
There you are. If you'd like to speak for 2 minutes, that'd be great. Hey, Mr. Jocelyn, you're going to have to turn off the live feed.
Chairman. John Jocelyn speaking for 2A Maryland.
All right, I think you did it. So now, if you'd like to go, or no, you didn't. You need to turn off the live feed. The YouTube link. You need to just close it.
I believe it is closer.
All right, let's go ahead. 2 minutes.
Thank you, sir. John Jocelyn with 2A Maryland, speaking in opposition to this particular bill. We do not object if law enforcement adopts it. We do not object if private citizens choose to adopt it. We strongly object to any requirement that everyone must provide one on their firearm. We believe there's some serious privacy issues here. Surveillance without warrants is possible. We strongly object to that. We also believe that this technology certainly isn't going to stop a mass shooting, because I seriously doubt that a mass shooter would put this on his firearm. Criminals will wrap up a stolen firearm in tinfoil and defeat tracking. Private citizens would take it off because they don't trust their government. It will require a power source. If the batteries go dead, the unit ceases to function. Who is going to monitor when the batteries are replaced? It puts a tremendous burden on the handgun roster board. They are mostly volunteers, and they would have to review approximately 2,500 firearms to meet the criteria of this study, simply determine which firearms could be used. It's been our experience that any study is finally used ultimately as a springboard for future legislation. We've seen it before, and this one has all the earmarks. We strongly object to it. We would ask that the committee render an unfavorable report. We would also like to see a study on what the infrastructure would be merely to monitor these.
All right, thank you very much. We'll hear from Mark Pennock now, please, for 2 minutes.
Thank you, Mr. Chairman. It is a pleasure to be here. I echo what Mr. Jocelyn just said. You have my written testimony, which lays out the constitutional issues. The study is rather pointless, considering that you may not require a trespass onto private property to place these devices. Period, full stop. But that in itself would prevent the study from being ever implemented. The Supreme Court has issued 2 decisions on this point, the Jones and Carpenter decision, which are discussed in the written testimony. The people who tried to implement this probably would face personal liability because the Supreme Court decisions clearly established authority. But I'd like to address the point that we have in this last year over 302,000 purchases of firearms in the state as measured by the FBI and NICS checks. I doubt that any one of those would understand that they were purchasing a device that would allow surveillance. So let's be clear about this. This is not a study to prevent stolen firearms. This will be widely perceived by me, by membership, and by most of those 302,000 people who are your constituents as an authorization to conduct a study for a surveillance program. And the last thing we need now is trust the government at all-time lows is a perception that the government is interested in another surveillance program of gun owners. I urge an unfavorable report.
Right, are there questions for this panel? Delegate Conaway?
Thank you, Mr. Pinnock. Could you, thank you, Mr. Chairman. Mr. Pinnock, can you be a little more specific? Why would this be perceived as a surveillance type program?
Well, because the very purpose of the program is to send out a location device that could be used by law enforcement to track the movements of the firearm in which the device is placed. That is the very purpose of the program. After all, it's supposed to be used to locate stolen or lost firearms that could be just as easily used to track the movements of the owner of the firearm as he moves the firearm from place to place. It could be used for that very surveillance program.
Do you know if they use tracking devices on the police body-worn cameras?
Well, yes, in fact, they have tracking devices on their computers and on their cars. Now, as Mr. Jocelyn says, that we don't object if the police want to use this as an inventory control or the way to actually implement this for police control of their inventory. But it will not be used on people's private firearms because people will disable them. And then what happens?
Thank you very much. Thank you.
Delegate Arakan?
Thank you, Mr. Chair. This conversation is kind of reminding me about a bill that we heard from Delegate Shetty about like the genetics systems and how sort of we had these DNA systems, and now all of a sudden the police, it wasn't intended for the police to use it, and now all of a sudden the police are using it, and it's sort of blobbed out from what the original purpose was into, you know, tracking people down through, you know, their DNA. And I feel like am I wrong in saying, like, now we're starting with this idea that, oh, we're only going to use it for people who want to, and we're only going to use it for police officers. And then I'm sort of seeing this potential blobbing effect where now it's like, well, everyone should have it on their guns. You know, we're not going to use it though. And then in 5 years, you know, mandatory, everybody's got to have it. Otherwise you're a criminal if you don't want it. If you don't want it, you're a criminal, right? Are you seeing how that could be a cascading effect?
If the delegate,
was that a question for me or who?
Oh, no, it was for Mr. Pennick. I think we're off the support panel.
Okay, but I'm still the sponsor, so I didn't know if you were asking me questions.
Oh, no, I don't think we do it like that. No, it's just for Mr. Pennick.
So I spent 33 years in the Department of Justice, and one thing I learned is that technology will be used and technology will be abused. And sooner or later, this technology will be abused. That's just the way technology is used. So I'm not unduly cynical. I hate to have to say that, but that is the hard reality. And this technology will be abused. It's just a foregone conclusion.
Yeah, and do we have a cost estimate? Did Mr. Jocelyn, did you have an idea? I can't remember if last year you testified as the estimated cost of this for people.
The websites I found for 3 different companies, not the one that was testified on today, the numbers for a unit that looked a little bit like a matchbox was $300 per unit, and that was not small enough to fit into a firearm, and that's plus monitoring.
Yeah, that's just not reasonable for most gun owners who are just regular citizens and not wealthy collectors or anything like that. Okay, I appreciate you both. Thanks for being here tonight.
Mr. Chairman, can I respond at all? Because
I'm sorry, I can't do that. We've set a line, and that's what we do. Delegate Deborah Davis, then Delegate McComas, then Delegate Jones.
Thank you, Mr. Chair. I think we got off into a rabbit hole here. This is just a study, is it not? For the sponsor?
Yes, again, this is a
Well,
study of the technology that can be available.
but I can't,
Okay, sorry.
and I apologize. I'll answer the question. Yes, this is a study bill. This is a study bill. The last year's bill was a study bill as well. We try to keep it so that the people who testify in favor, we talk to them, and then we talk to the people opposed, and then
Thank you, Mr. Chair.
I got it. That's fine. And with respect to Delegate Queen, everybody else, just trying to keep the train on the track sometimes. It's fun. Delegate McComas.
Mr. Pinnock, I wanted to ask you a question. This has sort of been the year of equity, racial equity. And I wanted to ask you, we're talking about a study that, if it sounds like it's a good idea, it's going to be pretty expensive. Is that fair to say, to be implemented, that you're going to put these things on people's guns?
I think that is absolutely true. I think my investigation of the devices corresponded with Mr. Jocelyn's is around $300 plus the monitor.
So even if we were to say, okay, we're going to put it on the police guns, it's going to be expensive to the taxpayer, correct?
Yes, and I don't know of
where I'm going with this is that right now, I mean, you guys are kind of gun experts, you and Mr. Jocelyn. Is it very difficult for a citizen of black and brown citizens that live in the inner city to be able to get guns as far as legally and to protect themselves for self-protection? In other words, are there gun ranges? They have to take qualifying.
Delegate McComas, are you on the bill, or are you?
Well, I'm just.
Which has to do with a study for telematics, or are we going somewhere else?
Well, I think that the point is that, yeah, we're going somewhere else, sir.
Okay.
Well, okay,
I'll
make it quick.
Trying to keep us.
No, I know, but you got two people. The problem is that it's very hard for people of low and middle income to purchase guns and to get licenses. Is that fair to say?
Oh, yes, particularly in Baltimore City, since to buy a handgun legally in Baltimore or elsewhere in Maryland, you have to have a handgun qualification license. That itself costs around $200, and it requires access to a range of which there are none in Baltimore.
Okay, I just kind of concerned about that because, I mean, people, we heard testimony yesterday about some secretary was worried when she walks home from work, and she, and I gather she lives very close to work and she's scared. And I mean, people can't, they don't have police around to take care of them. I'm sorry, Mr. Chair. I know I sort of like got off the res.
Delegate Rachel Jones.
Good evening. I want to make 2 points. I know that this is just for a study, but just to counter for a moment, if we all have cell phones at this point, if you think that someone's going to sort of be surveilling through a phone, if you've got a cell phone and you've got any app, your location can be tracked and you can be located. That's sort of the first point I wanted to make. But the second point, and Delegate McComas kind of just touched on this, but I just want to make it clear that Black gun owners are not just in the inner cities. I'm a country girl. I'm a gun owner. The folks in my family have owned guns for years. And so I think that I wouldn't have an issue with, were this study were to be, were this bill to pass and this study be fruitful, I wouldn't have a problem with, putting a tracker on my firearm. And so I think it's a misconception that one, Black gun owners are only in the city, and two, that this would be like an issue of affordability for minority gun owners. But again, surveillance wise, if you've got a cell phone and you've got apps, the NSA and anyone else who wants to find you really can. So I don't know that, do you have a stronger argument, Mr. Pinnock, for your opposition? Because I don't really feel like the surveillance argument is holding for me.
So let me respond to that, Delegate. You'll see in my written testimony and discussion of the Carpenter case of the Supreme Court, where the court held that a surveillance through your cell phone is subject to the requirements of the Fourth Amendment, requiring a judicial warrant based on probable cause of a crime. The trouble what we're having here with this bill is this layers onto that cell phone, which nobody has a constitutional right to, by the way. It layers onto firearms, which you do have a constitutional right to own, and conditions the right to own that on the installation of a tracking device, which will then allow them to track you from time to time whenever you have that device around. So that's what's easily done without any judicial warrant. There is no guarantee that it won't be abused. And it allows an additional surveillance tool directed solely at gun owners who are exercising their very constitutional right to have. It would be a violation of the Fourth Amendment, but it's a condition on the exercise of another constitutional right, the Second Amendment. And that's not permissible. So if you want to go into the law, I mean, this is an easy lawsuit if they start making this condition on the exercise of another constitutional right. That's an unconstitutional conditions doctrine. But just on surveillance point, nobody would believe for a moment that this is not being used to surveil them. And I would have a very big problem with that.
Okay.
Thank you very much. Delegate Cox.
Thank you, Mr. Chairman. Thank you, Mr. Jocelyn, Mr. Pennick, for being here. I just wanted to ask quickly, I did a quick search on Trust Technologies, and Chun Yang Lang Daniel Nay is the owner of the patent 108-16293. My concern is that, and he was educated over in, I think, universities over in Asia. So I looked up the patent and I was looking it over, and the intent of the patent is to establish biometric tracing. And when I consider how China is doing, and the Communist Party of China is doing systematic tracing of individuals, does that concern you at all that this could lead to that here?
So the technology is advancing so rapidly, it could be used to remotely disable the firearm simply by the person who's doing the tracking. It could be used to identify the person who's actually having the handgun in their possession by the biometric, like fingerprints, for example. It could be used for all kinds of reasons that other than for the tracking of a lost or stolen firearm. It is so open to abuse and misuse that it's a chilling effect on the very exercise of the constitutional right that the Second Amendment guarantees. It also chills the exercise of your Fourth Amendment rights. You have a right to privacy here that is guaranteed by the Fourth Amendment. That was the holding in Carpenter, that was the holding in Jones. And this is a trustatory intrusion on your private property for purposes which no one has any control over. So yeah, it scares the hell out of me, actually.
If I may, Delegate, some years ago, we considered legislation to put serial numbers on each and every bullet for the purpose of tracking them. The person who pushed it very hard as a witness just happened to own the technology to do that and the patent to do so, and received a royalty on every bullet. It was very clear from the testimony we heard that the gentleman was pushing this as something for everyone, and he certainly has a fiduciary interest in seeing this bill pass and ultimately turn into a law that requires tracking devices. I think we have to look at the traditional follow the money, and we believe that's far more than simple safety. It's about tracking the United States citizens.
And thank you. And I would just note that in the patent application, it actually states a inertial navigation system, a GPS system, wherein the signal is received as a result of a geographic location of the firearm. So this is definitely more than I think than what it was billed to us as. But thanks so much, gentlemen.
Delegate Grammer, and then we're going to move on.
Thank you, Mr. Chair. Mr. Jocelyn, I'm a big Fourth Amendment guy. If I install like a coupon app on my phone and I find out that they're tracking me, can I choose to uninstall that?
I believe most apps can be uninstalled, but not being a tech person, I couldn't swear to you that it could be uninstalled. I can tell you that a device such as we're talking about would be very quickly uninstalled from the firearm by any legal owner.
Right. But if the telematics were required by law, that could not be that would not be optional any longer.
It certainly would indicate that we are in a brave new world of Big Brother.
Yeah, I'm a big Fourth Amendment guy, and I know the majority party abandoned that a long time ago. That's why I decided to walk away, but I appreciate the answers.
There appears to be some very strong people shouting about your Fourth Amendment stand in your house. I hope everything's all right. Seeing no further questions, that concludes the testimony for House Bill 773. We thank you all very much for being with us this evening. And we will go now to Delegate Queen and House Bill 772. Delegate Queen will speak for 3 minutes. We have several people signed up in favor, several with favorable with amendments. So we're going to go with the favorable first. So Delegate Queen will speak, then Amy Hennon, Marceline White, Kathleen Highland, William Laurie. They will all speak in favor of the bill, and then we'll hear the favorable with amendments, including Bob Etten, Jason Weintraub, Daniel Press. There's one person signed up in opposition. We will get to them after the favorable with amendments. So with that, now we'll go back and we'll hear from Delegate Queen again, and that is not making light of the part, but happy for 3
Chairman
minutes.
Clippinger, I just want to make sure, I got a text from some of the supporters that said they weren't in the Zoom yet. So I just want to know.
I see Marceline White. I see Amy Hennon.
Okay, I just want to make sure they got in.
Yeah, we let them in. We let them in as we call the bill. So it's okay.
Okay, no problem. Just want to make
Great.
sure.
You're good. 3 minutes.
Thanks again, Judiciary Committee. And again, you are certainly troopers. So I really appreciate this. Now, this bill, HB 772, I think has some confusion with it. So I want to make sure I take a little time to explain what the bill is doing. So this is called Judgment Exemptions from Execution. And so basically it deals with the article on courts and judiciary proceedings, 11-504, that currently exempts up to a limit various types of items from seizure in a judgment. And so certain things that are currently there are like you're wearing apparel. We don't want to take the shirt off your back. Certain tools so that you continue to work. Appliances, certain wages, health-related aids, household furniture. And currently we state that up to $6,000 of assets in cash or property can be shielded, basically, or exempt from being seized. So what HB 772 tries to do is to clarify of that $6,000, how much of that we want you to maintain as cash so that we're not emptying your bank account so that you can't pay your day-to-day mortgage or buy food or pay your utilities, just to keep you sort of afloat for a month while you're dealing with all the other issues related to the judgment. And so we're not saying that we're not, adding any more to that. That $6,000 is already there that can be exempt. We're just saying of that cash and property, $2,600 of that should be cash. That should be maintained. And so we've been in touch with the courts. I've spoken to Judge Morrissey to talk about how this can be done. And so we're talking about how to make the mechanics of this work. We've been in touch with the banks. And so you'll probably hear some amendments about what they believe should be some clarifying language. But again, it's just to specify of the $6,000 that is already in statute, that $2,600 of that should be cash that can't be seized. Okay, so I look for favorable amendment. I think any of the issues that you're here, we are certainly looking to address them, but this is a very good bill to protect consumers. So with that, I will ask for your favorable recommendation on this bill. Thank you.
Thank you very much. Let's go now to Amy Hennon, please.
Chairman Clippinger and members of the committee, thank you so much for the opportunity to testify. I appreciate you hanging in there. My name is Amy Hennon. I'm the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyer Service. MVLS is the oldest and largest provider of pro bono legal services in the state of Maryland for Marylanders of limited means. MVLS assists Marylanders facing debt in a number of ways. Significantly, in the last 20 years or so, we've assisted more than 8,000 folks that were attempting to file bankruptcy. We also have a clinic that we run in Baltimore City for people on facing specifically debt collection on the affidavit judgment docket, where we sit, in a normal year, we assist more than 400 folks. I want to draw your attention to the story of my client, Arlene, in my written testimony. Her funds were frozen, particularly the timeline of what the timeline looked like for her. Her funds were frozen from the end of September until early December. And this was only all of her income was Social Security, but her son had given her $200 to help pay for groceries. So the funds in her account were considered commingled, and they wound up being frozen. And just because of the timeline of things and because there are variations in how the different counties handle this, her funds wound up frozen for an incredibly long time. And in addition, if I hadn't been advocating on her behalf, the order never would have gotten from, the bank never would have actually released the fund for at least another month and a half. And this would have been absolutely devastating for her because she is living on a very limited income, and this was critical for her. Marylanders who don't have an attorney to assist them with this find this process really, really difficult to manage. Because I do practice bankruptcy law as well, to me, the bill seems appropriately structured to allow a little bit of flexibility to ensure that this is, if somebody has $2,600, that this does indeed let them have that bank account exempted, but does not negatively impact how bankruptcy law gets applied. And I would just urge a favorable report on this bill because of what it means for our clients.
Thank you very much. We'll go now to Marceline White.
Good afternoon, good evening, Chair, members of the committee. Thank you so much. It's a pleasure to be here. Marceline White, Executive Director of the Maryland Consumer Rights Coalition, MCRC, and MCRC advances economic rights and financial inclusion through research, education, advocacy, and direct service. We're here in strong support of House Bill 772, and I want to thank Delegate Queen for bringing this legislation forward. What this bill does is essentially two things. It sets an automatic self-executing exemption of $2,600 that an individual can protect in their bank account from creditors. Why does it do this? It basically allows a person to have some modest amount of money that they can spend on food, housing, utilities, and other basic needs until they receive their next paycheck if they have a judgment against them and their bank account and wages are being garnished. So it sets a new floor. This is the first time that we've done anything or looked at these issues in about 40 years in terms of bank account garnishments. As Delegate Queen said, we're willing to work with stakeholders who have some concerns to come up with something that we can move forward with that is reasonable. Why is this important right now? We had a report in 2018 called No Exit, which found that in 2016 alone, there are more than 27,000 property garnishments on low-income consumers for debts under $5,000. And it also documented that there were more debts in collection in communities of color than in majority white communities. If someone has money frozen in their bank account, they're more likely to accrue costly overdraft fees from the bank, which will deepen their debt and allow the banks to profit. This does allow people to protect money in their bank. It's incredibly important right now during the pandemic when we have a wealth and health crisis. I will not go into the details, but I will say simply that legislation in Washington State, very similar to this one, just passed the House, their House of Delegates unanimously. There was no opposition from creditors or banks in that place. And I will say that several states already do this. Massachusetts, New York, California, the banks there are all able to implement these kinds of garnishments, these kinds of protections with no problems. So I believe that it should be simple to remedy. It'll save taxpayers money because we will not be providing or having to provide housing or food and support. It will save the courts time. It will ease the time banks have in terms of dealing with garnishments, and it will save the courts time as well as protect consumers during a pandemic. So for all of these reasons, I urge a favorable report. Sorry.
Thank you very much. We'll go now to Kathleen Highland.
Good evening, delegate and chair, members of the committee. Thank you for hearing me tonight. I'm here on behalf of the National Association of Consumer Advocates. NACA is a nonprofit organization that represents the interests of attorneys, legal services organizations, law students, and law professors, and we have a special focus on consumer protection when it comes to debt collection issues. I want to give the committee a little bit more information on where this policy proposal came from. It was a brainchild of many advocates and people in the committee and members of the bar, especially in reaction to the COVID-19 crisis. At this time, banks and courts, as we know, are operating with diminished capacity on limited operations. And we found that consumers who had been facing judgments now couldn't get to court or couldn't call a bank to use their wild card exemption and activate their rights, the rights that they already have under Maryland law. So this is an especially important time to make sure that when someone is being garnished, they have some sort of safety net in the form of a limited cash amount that is free from garnishment, free from the ultimate freeze. In my private practice, I've represented many consumers who either needed their exemptions filed or had issues that made them able to challenge and defend their underlying judgments. And I represented people in Baltimore County who had situations like Amy Hennon's. I represented a family who couldn't afford to pay their monthly daycare bill while they contested bad service. I represented an individual in Anne Arundel County District Court who waited months to have his wildcard exemption processed, and he also had never been served with the underlying lawsuit. So my point is that not every judgment is collectible. These judgments often have defenses. And when a consumer can't access any cash in their bank account, unless they find a pro bono attorney to help them, they can't even afford a legal consultation to get the help they need to, to get out of this situation. So since we know judgment collection isn't perfect to begin with, we ought to provide a safety net for the people who have defenses, but also for the people who just need to make sure they don't fall behind on other consumer debts during the 12-year process when these debts can be collected. So thank you, and I urge a favorable report.
Thank you very much. William Laurie. Mr. Laurie.
Good evening, Chairman Clippinger, Vice Chair Atterbury, members of the committee. My name's Tom Laurie. I'm an assistant attorney, W. Thomas Laurie. I'm assistant attorney general with the Consumer Protection Division, and I'm here to testify in support of House Bill 772 as it currently exists. We believe no amendments are necessary to it. This bill implements one of the key recommendations of the Attorney General's COVID-19 Access to Justice Task Force, as well as a key recommendation of the National Consumer Law Center's October 2020 report. I won't repeat my written testimony, but would note the following. First of all, 772 is a bill that will have virtually no impact on the rights of creditors, while providing a huge benefit to thousands of Maryland consumers that are in financial distress and possibly on the verge of poverty. This bill will automatically exempt $2,600 in the consumer's bank account from being frozen, but will not increase the current total exemption amount of $6,000. As such, this bill does not in any way reduce the total amount that creditors can collect and won't impact the ability of debt collectors, local governments, or any other person to collect on court judgments. It also should have no impact on the current district court forms that consumers are required to file to affirmatively elect the $6,000 exemption. But what it does do is give consumers immediate access to money that is essential for them to meet their basic needs, to pay their rent, to purchase food for their families, to pay for childcare, and to even pay for transportation to get to work. The way that the current system works is that a consumer is able to protect generally 75% of their wages from garnishment. The problem is that many employers require their employees to have direct deposit. So once that paycheck is directly deposited into their bank account, if the creditors already attached that account, the consumer has no access to that money until they're able to go through what to many consumers is a daunting process of trying to get.
Mr. Laurie, we're going to need to begin to ask you to wrap up, please.
Okay, if I could add that so the problem with the current system is that any checks that they currently write before the garnishment will bounce, possibly subjecting them to criminal penalties, and they don't have any access to their direct deposit paychecks until they go through this process that can take weeks or even months. Finally, I would note that banks are already implementing this in other states, so they should have no problem implementing this current law. For all these reasons, the Consumer Protection Division asks that the committee give House Bill 772 a favorable report. Thank you.
All right. Are there questions for this panel? Delegate Deborah Davis.
Thank you. I think this bill is well needed. Is it an emergency bill? That's my first question. It's not an emergency bill, no. Could you walk me through the process of how this would actually happen with the courts?
Well, if I could,
Yeah, you.
feel that. So what will happen is, well, when you say with the courts, we don't think it will have any impact on the courts themselves. There's a form that it took me. So if a consumer, suppose a consumer got a judgment against them, and then they had their paycheck garnished and their bank account frozen. The process the consumer would have to do currently is to find the form to request an exemption. And it took me three times searching for it this morning to finally figure out the correct form. It's essentially a motion to exempt income that the consumer has to file. The consumer then has to, once they found it, they have to serve it on the plaintiffs, are possibly subject to a hearing, and then wait for a ruling from the court before they're able to actually get an order that will allow them to access their money. This bill would be self-effectuating. It won't affect the courts at all. All it will do is require that not freeze the first $2,600 in the consumer's account. So it won't impact the courts at all, and it will just require the banks take steps that they're already doing in other states. As there was testimony before, Massachusetts, California, and New York already have analogous laws in effect with similar exempted amounts that are self-effectuating. The consumer doesn't have to do anything and has immediate access to that money.
One follow-up question, if I may. The courts have been shut down for a year. Is the court giving any priority to these cases?
I can't speak to that. I don't know.
So I can speak to that. And I'm sorry, I can't see everyone's faces, so I'm not trying to interrupt, but I've been representing someone who was never served in Prince George's County. She was incarcerated at the time judgment was entered against her. And now they're trying to garnish her bank accounts while we fight the judgment. And we've been waiting several months to have the court rule on anything. And as soon as the court has been able to enter a ruling to release those funds under her wild card exemption, the creditor files another, goes after another account. So it's a very slow process at this current time. We've waited 3 to 5 months each time we've filed to use the wild card exemption. That wouldn't happen if this legislation passed. Thank you.
All right, are there any further questions for this panel? Seeing none, thank you all very much. We're going to go to those people who are favorable with amendment. Bob Enton and Daniel Press. Bob Enton and Daniel Press. Yeah, that's fine. We'll start with them, and then there's one person in opposition. Who are favorable with amendment. All right. Bob Benton.
Bob Benton and Daniel Press.
Thank you very
Bob Benton
much.
and Daniel Press.
Mr. Anton, you're going to need to turn off your live stream.
Thank you very much. Robert Enton on behalf of the Maryland Bankers Association. And I've had a good bit of discussion about this bill with both Delegate Queen and with Chief Judge Morrissey of the District Court. We don't have any problem with helping consumers to realize, or judgment debtors realize, that, you know, they have a $6,000 exemption, which could include their bank accounts. The problem is the only person who knows whether or not they've claimed prior exemptions is the judgment debtor. So the bank has no idea when that garnishment is laid on. All they know is there's an account in the judgment debtor's name and there's X number of dollars in the account. But we have no way of knowing whether the $6,000 limit has been reached. So if there's an quote automatic, and that's the key word, automatic exemption, how will anyone know? The judgment creditor won't know, the court won't know, and the bank won't know that how much has been taken as an exemption. And in my discussions with Judge Morrissey, he recognized that, and frankly, I think so did Delegate Queen, that's the problem with an automatic exemption. What we need, I think, and what I would hope we would do, and I've talked to Judge Morrissey about this, is what we need is a much, much more consumer-friendly form for them to fill out that doesn't use words like judgment debtor and garnishee and other legal terms. And I have the forms in front of me, and all the terms in there are legalese. We need a simple, consumer-friendly form that they can fill out and file with the court. And what we need is a form which has them indicate, which they don't do today. And my guess is very few of them even use the form today that they get. And let me make it clear, they get a form from the court that they can use. They get an explanation of what they need to do, but I don't think it's consumer friendly. So what we would hope that the committee would do, and what I was talking with Delegate Queen and Judge Morrissey about, is, you know, I don't know what you could put in law. You know, the judicial branch objects to you telling them what to do, but to have something that we could do, whether it's a letter from you or from whoever, or
Mr. Anton,
directing them, and I'll wrap up, directing them to develop a form which is simple for the consumer to use if they want to claim the exemption, and which tells everyone this is how much of an exemption I've claimed to date. So that's our concern, and we hope that we can work with the sponsor to come up with something that makes sense. I don't have any idea what the exemption provisions are in the 4 states that the Assistant AG mentioned, but I'm sure they're not like Maryland's.
All right, we're going to hear Jason Weintraub also signed up for this. We'll go ahead and hear from him now, and then we'll go to Daniel Press.
I'll be brief, Mr. Chair. Good evening, everybody. I'm just here as backup for Mr. Anton. I think he's covered Maryland Bankers' position pretty well, and thank the sponsor for continuing to work with us on this bill.
All right. Mr. Anton needs backup. Mr. Press, for 2 minutes.
Thank you, Mr. Chairman, members of the committee. I represent the Maryland State Bar Association Consumer Bankruptcy Section. Not a usual time where I share a panel with the bankers. We are strongly in support of this bill, but if you see our written testimony, we have some amendments we think will improve the bill and avoid some potential problems. The first one, it's clear that the intent is not to prevent the $6,000 exemption. You know, right now that $6,000 has been referred to as a wild card. That can be used for any property. But under traditional statutory interpretation guidelines, when you specify one type of asset for specific treatment, it suggests that that's not included in the general. So we simply would add language saying, including but not limited to the deposit accounts in subsection B5 into the general provision about the 6,000. That way it's clear you can exempt 6,000 in cash, you can exempt 6,000 in a car, whatever. But the 2,600 will be automatic. The rest you can exempt more cash, but you got to claim it. Second, as far as implementation of this, right now it simply says it's automatic, but it is not clear that it's an instruction to the financial institution not to freeze the account. The garnishment statute, the garnishment writ itself, instructs them to freeze the accounts, and then they file a form saying, okay, I want to exempt this. And then typically the court has to rule on that. I think we need more clear language saying that it won't be frozen. That's clearly the intent behind the bill. And so I provided some language for that. That is the same language, the same structure that is used in federal law, preventing the freezing of Social Security money in bank accounts. So it will be easy for banks to implement that because they're already doing it.
Mr. Press?
Security.
Okay.
And then finally, the third one.
Mr. Press, very finally, very
Yes,
briefly, that's fine.
The third one simply makes it clear that it's a total of that much in the bank, not per bank account. So with that, with those changes, we would encourage the committee to favorably report the bill. Thank you.
Are there questions for this panel? Vice Chair.
I just want to say hi to Jason. Good to see you.
All right, enough of that. Any other questions? Any other questions for the panel? Anything else you'd like to tell Jason? Want to see pictures of the kid? Stuff like that? No? Yeah, okay, we're not doing that either, but okay. Love you all, but no. Thank you all very much. That concludes the favorable with amendments panel. We'll go to David Schley, who is testifying in opposition to the bill. Mr. Schley. See if we see him. Don't see him yet. Bless you, Delegate Queen. We see everything now. It's terrible. There, I think is Mr. Schley. No, that's Delegate Cardin. All right. He is not
here, Mr. Chairman.
Not here. Thank you very much, Mr. Shorter. And that'll conclude the testimony for House Bill 772. Thank you, Delegate Queen. Thank you to the witnesses today. Thank you very much. We're going to move on to our last two bills of the evening, and it's only 7 o'clock, everybody. But let's see what happens next. We're going to go to House Bill 902, House Bill 902 with Delegate Bartlett. Delegate Bartlett will be joined by Amy Orsi, Bruce Plaxton, David Muncy, Suzanne Burnett, Mitzi Bernard. Then we'll have a panel in opposition. Delegate Bartlett for 3 minutes, everybody else for 2. Delegate Bartlett, whenever you are ready, are you there? There you are. You're ready to go. We are ready to hear from you. Delegate Bartlett. Uh-oh. Maybe there's a delay. There we go. Delegate Bartlett for 3 minutes, please.
Thank you, Mr. Chair. Vice Chair Atterbury and members of the House Judiciary Committee. House Bill 899 proposes an increase in the civil cases wherein a person is guaranteed a jury trial upon request. The companion bill, I believe you said, Mr. Chair, that we are going to do the companion bill together. Okay. The companion bill, House Bill 902, permits the voters to decide whether they want a constitutional amendment to allow for the increase. Currently, in civil cases, the district court has exclusive jurisdiction in claims for that are $5,000 or less, and concurrent jurisdiction with the circuit court for claims for an amount above $5,000 but less than $30,000. House Bill 899 proposes to increase that amount to for jury prayers to $30,000. Jury trials are expensive. The litigants lose time, they lose money, they lose time from work, and district court cases move faster, as you will hear from the panel, and generally they're not as expensive as circuit court cases. Last year, House Bill 899, which was a different number, and House Bill 902 were bipartisan. And if co-sponsors had been allowed this session, I am almost certain it would have been bipartisan this year. It is in the same posture as last year, so therefore I request a favorable vote for both bills. Thank you, and that concludes my testimony, Mr. Chair.
Thank you very much. I should be clear, these two do come as, I think, as a package, because one deals with the policy, the other sets up the constitutional amendment. So what we're going to do is we're going to hear effectively both of them at the same time. We're still only going to give people 2 minutes because you don't need the extra time to tell us that we'd have to vote on the thing. So we're also going to add to this panel, if they're out there, they're signed up on, they're signed up for to be in support, Frank Boston and Ari Plout. I'm going to strike Mitzi Bernard because I forgot that that was Delegate Bartlett's aide, and Mitzi doesn't get to testify here. So that's perfectly fine. We'll go now to Amy Orsi for 2 minutes, please.
Thank you, Chairman Clippinger, Madam Vice Chair, and members of the committee. My name is Amy Orsi, and I am here on behalf of the Maryland Association for Justice, which is the Plaintiffs' Bar Association in Maryland. I am also the current president for MAJ. I do represent victims of auto crashes, slip and falls, and other personal injury cases all over the state of Maryland. And thank you, Delegate Bartlett, for reintroducing this bill again. By allowing an amendment to increase the amount in controversy to demand a jury trial to $30,000, a large number of cases could be resolved quickly and more efficiently. In preparing for today's hearings, I have reviewed the cases that my office filed in circuit court pre-COVID. On average, trial dates were scheduled 13 to 15 months after the filing of the complaint. With courts being closed and jury trials being suspended for over a year due to COVID, it is going to take plaintiffs even longer to get their trial dates. 2 to 3 day jury trials that would typically be scheduled in those 13 to 15 months are already being scheduled well into 2022 and even 2023. The backlog of trial dates created by this pandemic is tremendous, and it's going to take years to alleviate. And even when the jury trials resume, it will be far from business as usual in the courts. With this amendment, cases filed in the district court can stay in the district court. In district court, these cases can typically be tried within 6 months and resolved within an hour or so before a judge. Briefly, because I know others on my panel will testify to this in more detail, because of the types of damages that these cases have, it's not economically feasible for such cases to be tried in the circuit court because of the increased costs associated with discovery, the need for expert witnesses in district court. The discovery is limited and much more economical for these cases. This amendment would keep cases that belong in the district court in the district court. The district courts do not have a level of backlog as the circuit courts do. The district courts, to a limited extent, have been able to try their cases, whether remotely or in person. By this bill, it would greatly assist the people to get their day in court. Our clients and your constituents have already been significantly hampered.
Ms. Orsi, if you please wrap up.
Just wrapping up. Our clients and your constituents have already been significantly hampered in getting their access to justice because of COVID, and this amendment will allow them to get that access without further delays. And with that, thank you, Chairman. I'm happy to answer any questions at the end.
All right, thank you very much. Bruce Jackson for 2 minutes.
Thank you, Mr. Chair. It's no one ever wants to be the speaker between you and your dinner, so I will try and keep to the 2 minutes. I know I have to because you'll shut me off. Everybody understands the importance of a speedy trial. Going back to the Magna Carta, the Magna Carta said, "To no one will we delay justice." Later on, William Penn and William Gladstone turned that into "justice delayed is justice denied," which were the words that Martin Luther King smuggled out of a Birmingham jail in 1963 on a note, that justice delayed is justice denied. Chief Justice Berger later said that inefficient justice is not justice. What we have in Maryland right now is a system that does not allow small cases to be tried efficiently or inexpensively. That makes sense. I do want to take the last little bit of my time to address an argument raised by the opponents of this bill that Maryland has the highest judicial jury threshold in the country. But it's a little misleading because most states don't have a jury threshold in their constitution. The jury rules are set by the courts. So states that have these two court systems, like a district and a circuit court, if you file in circuit court, you get a jury. If you file in district court, you get a bench trial. For instance, in Virginia, district court is up to $25,000. But circuit court, you can file, they have concurrent jurisdiction for $4,500. So Virginia would show up on that chart as a $4,500 threshold, which is much lower than us. But if you file in district court, there is no removal. And many states follow that kind of rule. So to say that our jury threshold is different from other states is apples and oranges. Also, other states like New York and New Jersey have $50,000 or $100,000 in PIP. So their constituents are not waiting to have their bills paid like we have here in Maryland. And many states now have prejudgment interest. So there's no incentive for the insurance carriers to delay because they're paying interest from the time the cases are either filed or the cause of action accrues. So I ask you to discount those arguments and do what's right in terms of getting a favorable amendment out so that your constituents do not have to take 3 days off for jury duty for a $15,000 dispute, or that our clients
Mr.
don't have to wait
Claxon.
2 years. Thank you, Mr. Chair, and I urge a favorable report.
Thank you very much. David Muncy.
Good evening, Mr. Chair, Madam Vice Chair. Thank you for having us. Basically, the point of this bill is to keep the cases that are smaller in nature where they belong in the district court and allow the circuit court to handle larger matters, larger civil cases, the criminal cases that are handled in the circuit court that require jury trials. Jury trials are an arduous experience, not just for the litigants, but also for the jurors. They have to be there for 2 to 3 days. They have to miss work. And these smaller cases do not belong in the circuit court. They do not belong, do not belong in having a burden on the circuit court that they currently do, when they can be resolved in the district court in 1 to 2 hours in 6 months from filing, as opposed to 2 to 3 days, 1 to 2 years after filing. It makes sense, really for all sides. And I just want to briefly address an argument that was made previously in the Senate panel, which is that the real reason we want this is because we get better results in the district court for non-meritorious cases. And I would strongly disagree with that. District court judges have no problem dismissing with non-meritorious cases. They have no problem with telling litigants who do not have a good case as much and giving them a nominal award or no award at all. So that argument does not carry any weight. We would ask you to keep these small cases where they belong in the district court, up to 30,000, and we would ask for a favorable report. Thank you.
All right, Suzanne Burnett.
Hi, good evening, everyone. Thank you for having me, Chairman. And I am Suzanne Burnett. I'm also here with the Maryland Association for Justice. I'm a partner with the law firm Potter Burnett and a trial lawyer. My job is representing victims of negligence, and we are asking for a favorable report on this bill because it is a very difficult situation that many of our clients find themselves in. They may very quickly, after a kind of minor accident, accumulate $15,000 in medical expenses. They then are forced to make a choice of filing in the district versus a circuit court. This is problematic because some clients decide that they do not want to wait 2-3 years to get their day in court. They don't want to have all the expenses that are associated with a circuit court jury trial. There's deposition costs, there are bringing experts to court, and it's very costly, and it's a lot of time off of work for the litigants as well as the jurors who end up being part of the panel. So it's very inefficient, and clients end up having to make a choice to sacrifice getting what they deserve because they don't want to go through that more complicated and extensive discovery. And so for that reason, we're asking for a favorable report. But I will mention, it doesn't just affect our clients, it affects small businesses. So there are contractors that may file a lawsuit for $15,000 and then they end up wanting to keep it in the district court as well, because again, it's not economical for them to end up in circuit court where they're going to be drawn out for years and years. So for these reasons, we would ask you to prioritize this bill and pass or give a favorable report. Thank you.
Thank you very much. All right, we'll hear from Frank Boston.
Good afternoon, Mr. Chairman and members of the committee. I'm Frank Boston III, and I am an attorney who lobbies and represents Maryland Association of Justice, but also in my law practice, I do this kind of work as well. I thank Delegate Bartlett for sponsoring the bill. You know, I'll just speak straight to you. People in the city can't afford to wait 2 years to go to court, or when they have a case that has damages between $15,000 to $30,000. It just doesn't make sense. It costs more and it causes delay. You can surely bet that when you file a case in excess of $15,000, let's say for 20 grand, that the defendants are going to pray it up just to delay it, just to cause more money and just to cause more time. You know, so what results is the clients are forced to settle early for less than what they really want because it takes too long. It's the time value of money. You know, they already had to put up money for a new car because the insurance covered the actual value of the car, but now they had a car that was paid off and now they got to go incur monthly payments, et cetera, et cetera. They don't have time to wait to get their money. So that's a shame. You know, and also, and it was stated earlier, with COVID, jury trials are really backed up. And we all know that because of a speedy trial, they're going to take the criminal cases first. The last thing I want to say, you're going to hear from the opponents that we don't need to pass this bill this year. Why not wait till next year? But that's exactly the point. You know, delay, delay, delay. Why delay? Why not pass it this year? What's the reason to wait? But that shows their hand. That's exactly what they do in these cases. We file over 15, then there's a delay, and a delay. For those reasons, we ask that the committee give a favorable report on this bill. And Mr. Chairman, thanks for getting me in the room.
Ari Plout.
Good evening, Mr. Chairman, members of the Judiciary Committee. I'm Ari Plout, and I also represent the Maryland Association for Justice. I wanted to thank Delegate Bartlett for sponsoring this bill. I just wanted to speak from experience as well. I'm an attorney that primarily practices a lot in Baltimore City, and then when I file a case, I want to keep it at 30 grand or less. And if damages let's say the damages are up to 20, the whole purpose of filing a case in district court is the expedition. It's to expedite the case, the efficiency that district court provides, which is great for the clients. They don't want to wait. However, defense attorneys will more than likely remove it to circuit court. It's just a delay tactic. That's the only reason why they'll do it. There's no reason they need to do that other than to delay it, because circuit court are really meant for high stakes cases. There's scheduling orders, there's depositions, there's just a lot more that goes into a circuit court case, whereas district court is just to expedite everything. So I think this is a great bill, and I appreciate the time, and thank you very much, and would urge a favorable report on this bill. Thank you so much.
Questions to the panel. Delegate Deborah Davis, then Conaway.
Thank you, Mr. Chair. I'd like to ask Mr. Frank Boston, my former classmate in law school, who we just happened to be on the same side of an issue for once. But I look, if we pass this bill in normal time, how long would it take to get a constitutional amendment?
The next time we have a general election.
Wow.
So and that could be, congressional, which is every 2 years.
Okay, I think that this would be a good bill and a good relief for the court system during COVID. I think it's a good thing to do. I'm wondering, can the judiciary do it now?
I don't think so. I think it requires a constitutional amendment, but I'll defer to someone else on the panel who's a little bit smarter on this issue than me. But from everything that requires a constitutional amendment, you usually got to wait until that year. But I like the way you think, Delegate Davis. I wish it was an emergency bill.
Or the governor under his emergency powers.
From your lips to God's ears.
It's going to require a referendum.
Yeah.
Okay, thank you.
Thank you.
Delegate Conaway.
Thank you, Mr. Chair, and thank you for bringing this bill. My question is for Mr. Boston. Do you think the $30,000 figure is high enough, or what do you think about that right now?
I think, I think the $30 figure is fair. I mean, $30,000 amount in controversy is the correct amount. It's already has precedence in statute, as the threshold before you get to the jury trial. Just between 15 and 30 is kind of what is known as concurrent jurisdiction, where the defendants have a right to pray it up. So 30 is a good number. It's a fair number. Probably if you have damages that exceed 30, you're probably looking for a lot larger amounts, and you'll probably will have experts and depositions in order needed to, show, to show actual damages, economic damages. You may need a vocational rehab person. So if it gets into that amount, we probably will need to bring in experts to testify at trial.
Thank you. Thank you very much.
Yeah.
Delegate, if you don't mind, I'll give you a little history on that. It's Bruce Plaxton.
That'd be fine if the chairman will go for it.
Go ahead.
30 seconds. 12 years ago, it was $10,000, and the Senate passed the bill at 20. And with a different chairman in this committee, it was amended down to 15. So we're anxious to get it to 30 where we think it belongs.
Yes. Okay. Thank you very much.
Thank you, Delegate.
Are there questions for this panel? Seeing nothing further, we appreciate your time. We're going to hear now from the opponents of the legislation of both bills, 899 and 902. We'll hear from Andrew Kirkner, Henry Barrett Peterson Jr., Bob Enton, and Nancy Egan. We'll let them begin to enter the room. We're going to hear now from the opponents of the legislation of both bills. Bob Enton needs to turn off his live feed. Kirkner. And he did. So, Mr. Enton, if you're ready to go for 2 minutes, let's.
I am, Mr. Chairman. Thank you very much. Robert Enton on behalf of the American Property Casualty Insurers Association. Let me say, first of all, that not all defendants in all cases are personal injury defendants. So if I get sued because I get sued by a debt collector, I get sued by someone I had a contract with, I get sued for any other cause of action, why is it that the plaintiff gets to elect a jury trial, but I don't? I don't understand that. It seems to me that that the defendant should have the same right to play a jury trial as the plaintiff. Secondly, I would say that there's the biggest difference that between the district court and the circuit court, and what as a defendant in any case prevents me from having any real discovery I get to ask 15 questions and interrogatories, and that's it. And while maybe, you know, $15,000, $20,000 doesn't seem like a lot to most people, to me, it might seem like a lot. And I want to have discovery just like anybody else in the case, just like the plaintiff, if the plaintiff brings a jury trial. You know, there's this notion that the defendant is not at risk in a personal injury case. But guess what? They are at risk. They are at risk because it's going to make a difference whether or not they get a judgment against them in as far as, you know, their credit rating and how their, you know, their number of claims and everything else. You know, if there's a problem with the amount of time it takes, that doesn't have anything to do with whether or not, in fairness, the defendant should have the same right as the plaintiff has. And finally, I would say, Mr. Chairman, that the questions asked about whether or not this needs to be done this year are very, very fair questions. There is absolutely no reason what to do in this time of COVID and everything else that's going on to pass this bill, because it can't get on the ballot until the next general election. Thank you very much.
Thank you, Mr. Anton. We'll go to Andrew Kirkner, please, for 2 minutes.
Thank you, Mr. Chairman. Andrew Kirkner on behalf of the National Association of Mutual Insurance Companies and our more than 1,400 member companies across the country. We are very proud of the fact that we have 11 member companies that are domiciled in the state of Maryland, many of which are located in your various districts. I just want to start by requesting an unfavorable report on the bill. I think you've heard one side of the story laid out, and the proponents would have you believe that the only purpose in requesting a jury trial is to delay. Knowing our member companies, getting to know the people that work there, and understanding how they operate, I would push back very strongly on that notion. As Mr. Inton just articulated to the committee, there are benefits, the first of which is increased discovery in the circuit court level. And so the idea that this is just a delay tactic is incorrect. You as a consumer, each person on this Zoom call right now has an interest in accurate adjudication of these claims. That we get to that by this increased level of discovery that occurs at the circuit court level. I would simply say, you know, in closing, one of the issues in Maryland with the uninsured motorist population is the affordability of insurance. This bill will take us the other direction in terms of affordability of insurance. If you look at a MAFE study that was commissioned by the General Assembly and produced last year, one of the recommendations in that MAFE study, and it was put forward by the industry, is actually to lower the jury threshold. In fact, Maryland does have the highest jury threshold in the country already, and this bill would take Maryland further out of step with other states, including Louisiana, which just lowered its jury threshold as part of a reform package to lower the cost of insurance. With that, Mr. Chairman, I will close. I appreciate the opportunity to appear, and I'm happy to answer any questions.
All right. Hear from Barrett Peterson, please. Mr. Peterson.
My mute button, sorry. Thank you, Mr. Chairman, Madam Vice Chair. I would first note the irony that the Maryland Association of Justice, which has as part of its mission statement the preservation of right to trial by jury, means they really only want a trial by jury when it benefits their clients, not defendants. They want to take away from the defendant the right to ask for a jury trial, but they don't want it limited where they would choose one, and it's solely to their choosing. Second, I've heard a lot of talk about delay, but I would tell you that anyone that thinks that insurance companies do things for or benefit from delay doesn't understand the insurance business. We don't like delay. We don't like pending files. We don't like having to keep funds in reserves. We want to settle cases quickly for the fair price. And in most cases, most personal injury cases settle without a lawsuit being filed at all. But we don't want to overpay, because that makes insurance more inaffordable, more expensive for everyone. And when district court judges pay more on small claims than a jury would pay, that drives up the price of insurance. Let me give you the example, a case where there's no damage to either car. The plaintiff calls their lawyer before they call a doctor. The lawyer sends them to a care provider that treats nothing but personal injury attorney referrals, and the judge says, I'm untroubled by any of that, and awards $30,000. And $30,000 is not a small amount of money to most of to your constituents, to me. I would submit to any of you. $30,000 is a lot of money. That's pretty good. That's a pretty good payday for an hour's worth of courtroom testimony. Our clients ask us, what can we do? And the answer is, you can't do anything. You can't appeal that to a jury. And that same jury, a jury would award that case almost nothing. That's the real reason they're doing this. The delays they've spoken of are overstated. And to the point that, yes, right now, the delays of getting to a jury are very real. That's undeniable. But by the time, the earliest time this law could take effect would be January of 2023. By then, we may have seen some changes in the delays in the court system, delays and costs that were offered that aren't nearly as significant as the plaintiffs panel made them out to be. Louisiana had a $50,000 jury trial threshold. They rolled it back because they found that it raised the price of insurance for all their constituents, and they didn't want to sacrifice the right to a jury trial. We're the highest. This would put us.
Mr. Peterson.
Yes, thank you very much for your consideration. We would ask for an unfavorable report. Thank you.
Thank you very much. Nancy Egan now for 2 minutes.
Good evening, and I think I'm the last speaker, so I will not belabor the point. I do want to say hi to my Deborah Davis, who attended law school with me, as well as Frank Boston on the prior panel. So there is some camaraderie here. I am not going to belabor the point. I just would like to say I represent the American Property Casualty Insurance Association. We don't appear in front of you very often, but we do appear in front of House Economic Matters. And the question of affordability of auto insurance is a real issue right now in Maryland. And making sure that claims are adjudicated to their right amount, which would benefit all policyholders and lower the cost of claims, is a really important issue here in Maryland. And we urge an unfavorable report. And thank you, everyone, for staying in here for the very end. So thank you.
Questions for the panel? Anybody else on the panel go to law school with Delegate Deborah Davis? Delegate Cardin. Delegate Cardin.
Thank you, Mr. Chairman. And no, I did not go to law school with Deborah Davis. My sister did go
No
to
loss.
high school with Frank Boston. So, okay. So here's my question. I think it's for Bob Benton. I'm not sure who made this point. It may have been Mr. Peterson. It may have been Mr. Anton. I think that Maryland requires a minimum insurance of $30,000 for motorists. And so if you're a company praise my daughter's yelling at me. If your insurance company praise a jury trial, don't you expose your client to potential excess verdict if you wind up losing? And that wouldn't be on you, that would be on them if they actually only had $30,000 in insurance?
Well, once again, I mean, the exposure is what the exposure is. And, whether, if the damages are, as you heard from the plaintiff's bar, the damages are $15,000, they want to keep it in the district court. So, once again, I just don't see why it is that a defendant can't pray a jury trial, but a plaintiff can. And we're not, once again, the bill doesn't, we're not just talking about PI cases. That's who wants this. The lawyers that are testifying in favor of this are PI lawyers. That's what they want. It's got nothing to do with all the other civil cases that are out there that this would impact.
Delegate Cardin, I'd also offer this. In most of the cases when it's removed to circuit court, there's an incentive for the plaintiff to leave their claim at $30,000, because if they do, there is no expense of bringing in experts. They're allowed to submit the medical records just like they would in district court. So there's no added expense. If they filed that case for $30,000 in district court, they didn't think it was worth more than $30,000, or they would have filed it in circuit court and chosen a jury in the first place. And I think in the end, without making this a long discussion, if an insurance company takes that position with their insured, they bought that claim. So I don't think they're exposing their insured to any unrealistic risk.
I think that's absolutely correct.
Thank you for that explanation.
Are there further questions for the panel? I'd like to go back in time just a little bit. Reference was made to insurance rates going up potentially after the increase in the threshold. Do you have any? So you also, I think it was reference was also made the last time, and I think this was by the proponents, that the last time it was raised, I believe, was 20 years ago from 10,000 to 15,000. Is that right?
No, in 2010, it was raised from $10,000 to $15,000.
All right, not 20 years, about 11 years.
No, 20 years ago, it was raised from 5,000 to 10,000.
Okay, and then 10,000 to 15,000, correct?
Yes.
All right. Do you have any, can you provide the committee with any information as to what happened to insurance rates at that time in 2011 when the threshold went up?
We can probably, I suppose there's access to data that would show what the change in insurance rates was from one year to another. But I would suggest that anytime you're paying more on claims in one forum than you would be paying in another, it's going to have an impact. I'm not sure it's going to be easy to show what one change would make in what the impact of one change would make on rates. So I can say generally it has an impact, but it would be probably hard to identify how much compared to say what's the impact of more technology in cars in causing increased property damage payments. So a variety of things work together to drive rates. This would be one, and I can't tell you how much, but we could see if we could find what the change was between rates in 2010, 2011.
All right, I'm not going to belabor this too much. It just you were very clear in saying that the rates would go up, but I'd like to have the data though too. I think that's important. I'll go now to further question from Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Mr. Etten, for coming and talking to us. I think that you jarred my memory a little bit. Do you remember something about deep pockets being mentioned when we raised the fee up, the amount up? Because it was a concern that an average person might try to bring a claim against a big company, and a big company already has lawyers on payroll. And since they have big pockets and they have these people on payroll, they use their lawyers as a tool to kind of suppress you and keep all of your claims low. You remember anything like that?
No, I don't.
I didn't think so. Okay, thank you there.
Are there further questions for this panel? Seeing none, we thank you all very much.
Thank you. Have a nice dinner.
That concludes the testimony for House Bills 899 and 902, the final two bills of the evening. It's only 7:41. We could, hear some more, but I don't think we will. We're done for the evening. We'll be back tomorrow at 1:30. There are subcommittee brief, hearings that have been posted online. You can find out more information about those. We will see you then. There will be a voting session on Friday. That bill list has been posted. Any amendments proposed by members of the committee need to be in by 4 o'clock tomorrow to be considered at the voting session on Friday. With that, and I'm being told the Civil Law Committee is meeting tomorrow at 12:15. So Civil Law tomorrow at 12:15. With that, thank you all very much. See you tomorrow. Have a good evening.